ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಅವರೇ. ಅಲ್ಲ, ಓನ್ಲಿ SSCR ಅಂತ ಅಷ್ಟೇ ಬರ್ದಿದ್ದಾರೆ. ಓನ್ಲಿ SSCR ಅಂತಾರೆ, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಅಷ್ಟೇ ಬರ್ದಿದ್ದಾರೆ.
ಮೇಡಮ್ ನಾಳೆ RP ಇರುತ್ತಾ? ನಾಳೆ RP ತಗೋತಾರಾ ಇಲ್ಲ ಟ್ಯೂಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ
19 ಅಲ್ಲಿ ಒಂದು ಅದಕ್ಕೆ ಹೇಳಿದೆ, ಅಡ್ಮಿಷನ್ ಬೇಕಾಗತ್ತೆ.
ಹಾಗೆ ಕೊಡ್ಬೋದಾ ಮೆನ್ಷನ್ ಮಾಡಬೇಕು?
ಇಷ್ಟ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು. ಹೊಸಾದ ಹಳೇದ ಏನ್ ಕೇಳ್ತಾರೆ?
ಅಲ್ಲ, ಇಟ್ಸ್ ಓಕೆ, ಐ ಕ್ಯಾನ್ ಜಸ್ಟ್ ಗಿವ್ ಆಲ್ಸೋ.
ಬಟ್ ಇಟ್ಸ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ. ದೇ ಮೇ ನಾಟ್ ಟೇಕ್ ಮೆಮೋ ಫಾರ್ ಹಿಯರಿಂಗ್. ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ, ಮತ್ತೆ ಸುಮ್ಮನೆ ಬಯಸ್ಕೊತೀರ ವಾಟ್ ಈಸ್ ದಟ್ ಅಂತ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ಗೆ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡೆ ಮೂವ್ ಮಾಡಿ. ಬೈ ಮೆಮೋ ಇಟ್ ಮೇ ನಾಟ್ ಕಮ್. ಇಲ್ಲಾಂದ್ರೆ ಅನ್ಅಫಿಷಿಯಲಿ ಕೆಳಗಡೆ ಪೆಂಡಿಂಗ್ ಹೋಗ್ಬಿಟ್ಟು ಸ್ವಲ್ಪ ಈ ಫೈಲ್ ಮೂವ್ ಮಾಡಿ ಸರ್. ಓನ್ಲಿ ದೋಸ್ ಟು ಆಪ್ಷನ್. ಡೋಂಟ್ ಫೈಲ್ ಮೆಮೋ. ಅಗೇನ್ ಇದು ಏನ್ ಗೊತ್ತಾಗಲ್ವಾ ಅಂದ್ಬಿಡ್ತಾರೆ.
ಸಂಜೆ ಸಾಹೇಬ್ರೆ ಅಲ್ಲ ಕೊಟ್ಟರು.
ಹೌದು, ಬಟ್ RSC ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲ.
ಯೂಶಲಿ
ಹೊಸದಾದ್ರೆ ಓಕೆ, ಹಳೇದ್ ಬರಲ್ಲ. ಕೇಳಿ ನೋಡಿ ಒಂದ್ಸಲ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಮೇಡಮ್, ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟ್ರಸ್ ಬೆಳಗ್ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಾ? ವಿಡ್ರಾಯಲ್ಗೆ ಸರಿ ಮೇಡಮ್. ಬೆಳಗ್ಗೆ 4 ಗಂಟೆಗೆ ಬಂದು ಬೆಳಗ್ಗೆ 4 ಗಂಟೆಗೆ ಬಂದು ತಗೊಂಡು ಹೋಗ್ತೀವಿ. Connection again into this step over. And this time is over. But lower court morning they 4 o'clock they come and took my time. Till time is there, 28th December, order has been passed, Mysore. Get out the order, let also. March. There is 30, yesterday has passed an order, in this case, yesterday has passed an order in itself. Document produced when
ನಾನು ನಮ್ಗೆ ಮಾತು ಮಾಡ್ಕೊ ಬರಲ್ಲ ನಂದು ಕಾಪಿಲಿ
ಈಗ ಬಂದಿದೆ ಹೋಗ್ಬಿಟ್ಟು ಅಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಪ್ಲೋಡ್ ಬಂತು
My lords, in this matter, this honorable court has directed to withdraw money in trial court. Withdraw money in trial court, deposited money in trial court, but LCR call for ಆಗಿದೆ ಇಲ್ಲಿದೆ.
Petition, my lord. On 5th of this month, my lord, I filed a memo for posting. This court ordered to list the 6th of this month, my lord. There is a reference in the memo register also. It has not been listed. Again, they are telling that it is not. They are telling that again in memo file ಮಾಡಿ ಅಂತ ಹೇಳಿ. ಮೆಮೋ ರಿಜಿಸ್ಟರ್ ರೆಫರೆನ್ಸ್ ಇದೆ my lord. 6ನೇ ತಾರೀಕು ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ರೆಫರೆನ್ಸ್ ಇದೆ ಮೆಮೋ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ. ಇದು ನಿಮ್ಮ ರಿಜಿಸ್ಟರ್ ಇದೆ my lord. ಕೋರ್ಟಿಂದ ಕಳಿಸಿರೋ ಇದರಲ್ಲಿ 6ನೇ ತಾರೀಕು ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ.
ನಂದು 13th ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು, ನೆನ್ನೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು, ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ನೆನ್ನೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು, ನೆನ್ನೆ.
On submission, my lord. RSA, my lord.
ನಾಳೆಗೆ ಮೇಡಮ್, ನಾಳೆ
For eviction. In the owner of the property. All the lower courts are passed in favor of my.
ಮೇಡಮ್ ಅದನ್ನ ನಾಳೆ
23, 23 5. No, my lord, before this court only it is posted. Already a party admission.
On submission, 138 proceedings have been instituted. I am for respondent. Stay has been granted with this court. Settlement ಅಂತ ಅಂದ್ರು ಸ್ವಾಮಿ ಆಮೇಲೆ ಬರ್ತಾನೆ ಇಲ್ಲ.
That's 138 of NI Act, my lord, ready to pay them. Sir, 138 on my case. Yesterday, what happened, as per iron delivery for particular case yesterday. ಆದ್ರೆ ಏನ್ ಮಾಡಿದ್ವಿ ಬೆಳಗ್ಗೆ 4:15 ಬಂದು ಪೊಲೀಸ್ ಅವ್ರು ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಒಂದು ಟೈಮ್ ಇದೆ ಆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಈಗ ಬೆಳಗ್ಗೆ 4:15. ಅದರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡಿ ತಾವು ಕೊಟ್ಟಿರೋದು ಆರ್ಡರ್ ಕಾಪಿ ಕಳಿಸಿದ್ದೀನಿ, ಅದು ತೋರಿಸಿ ರಿಲೀಸ್ ಮಾಡಿದ್ದೆ. ಒನ್ ಮೋರ್ ಮ್ಯಾಟರ್ ಮಾಡಿದ್ದೀನಿ ಈಗ ಇಲ್ಲ ಇದರಲ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಿದ್ದಾರೆ ಈಗ 10:15. ಮೀನ್ ವೈಲ್ ಒನ್ ಮೋರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಒನ್ ಮೋರ್ ಆರ್ಡರ್ ಇಸ್ ಒನ್ ಮೋರ್ ಕೇಸ್ ಇಸ್ ದರ್ ಸೇಮ್ ಸಿಮಿಲರ್ ಪಾರ್ಟಿ ಇಸ್ ಡಿಫರೆಂಟ್ ಎಸ್ಟರ್ಡೇ ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಅದು ನಿನ್ನೆ ಅದು ಒಂದು ಇಲ್ಲಿ 2ಕ್ಕೂ ತಗೊಂಡಿದ್ದಾರೆ. ಒಂದು ಅದಕ್ಕೆ ನಿನ್ನೆ ಬಂತು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗೆ, ಅದು 2:30 ಸ್ವಲ್ಪ at the end of list. At the end of list. Tomorrow morning. ನಾಳೆ much.
My lord, in 138 matter, my lord, in 138 check bounce matter, my lord. My lord, the petitioner has been arrested by the police. He's arrested on 12th. Much obliged.
Serial number 7. Serial
My lord,
number 7, I'm
17.
withdrawing the
Serial
matter.
number. Serial number 17.
Serial number 7, I'm withdrawing them.
My lords, once up, my lords, regarding memo, my lords.
17, my lord. We are filing a memo for withdrawal.
ನಲ್ಲಿ TCR ಬಂದಿಲ್ಲ ಸರ್, ರಿಕಾರ್ಡ್ಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಅಡ್ಮಿಷನ್ ಇದೆ ಸರ್, ಅದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಅಂತ. ಹೌದು ಅದ ಇದದು ಒಂದು ಅಪಲೈಟ್ ಇದು ಅದೇ ಕಾಲ್ ಫಾರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್.
Serial number 30, my lords. I appear for respondent number 1, 2, and 5. 301. Yes, my lords. A short accommodation may be given, my lords, once. Respondent 7 is present, my lords. Yes, please. ಹೇಳ್ತೀನಿ, my lords. ಇಲ್ಲ, my lords. Much obliged.
Serial number 34, my lords. I appear for the petitioner. Any date in the next week may be given, my lord. See. Yes, my lord, straight. Next week, any date on next. Much obliged.
Lordship, serial number 44. Senior just gone with, yes, Your Lordship, has undergone a surgery, Your Lordship, so seek short accommodation, Your Lordship. After 3 weeks, Lordship. No, after 3 weeks, Lordship. He's undergone surgery to recovery time required, Lordship. Lordship, and serial number 47 as well. 47, 44 and 47. Yes, Lordship. Much obliged, Lordship.
49. 10 days time. 10 days.
Commissioner,
Weeks maybe. Inform markets. Senior ಮಾಡಿದ. More submission. Serial number 27 also, I am seeking adjournment. Senior as inform again. ಮಾಡಿದ senior section ಇದೆ. Interim order maybe. He is not well. Interim order maybe. Much.
My lords. My lords, on submission, my lords. My lords, I'm moving a memos in CRP, my lords. CRP is listed for tomorrow for final hearing. Senior has some inconvenience. It may kindly be taken up on 18th, my lords. Yes, my lords. It may kindly be taken up tomorrow. Blessed.
Parties are present,
my lord. Settle ಆಗಿದೆ.
Settle ಆಗಿದೆ. No, sir. Okay.
The IA number 3 amount deposited ಇದೆ. ಸೈನ್ ಮಾಡಿ. 53,500 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು. 500.
Present, sir.
They have already deposited 39,000 before trial court.
13,000
ಕೊಡೋದಿದೆ.
13,500 ರೂಪಾಯಿ ಕೊಡ್ತಾ ಇದೆ.
13,500.
13,500 sir. 500.
ಹೌದು. Respondent, also respondent number.
ಎಪ್ಪತ್ತೆಂಟು ಸಾವಿರ
ಇದೆ.
2,000 ಇಲ್ಲ ಸರ್ ವೇವ್ ಮಾಡಿ ಸ್ಮಾಲ್ ಪ್ಲೀಸ್ ವೇವ್ ಮಾಡಿ ದಯವಿಟ್ಟು ವೇವ್ ಮಾಡ್ಬೇಕು. ಆಯ್ತು ಸರ್ ಆಗ್ಬೋದು ಆಗ್ಬೋದು ಸರ್ ಆಗ್ಬೋದು.
Twenty more. 25%.
ಬೇಡ ಸರ್
ಬೇಡ. That is more than 25%. More than 25%.
ಆಗ್ಬೋದು.
Appear for the petitioner. Appear for the petitioner, my lords, in this matter. My lords, it's a 138 matter, my lord. By the order of this court on 1/3, my lords, I was directed to deposit a cost of 1,000 rupees within 2 weeks and comply the order of this honorable court of statutory deposit within a period of additional 2 weeks, my lord. My lords, earlier this week we went to comply, my lords. Trial court records have already been sent to this court and hence I was not able to comply. Trial court records may be directed to be. My lords, it should be await summons, my lord. My lords, I want the trial court records to be sent to the trial court so that I can comply with the direction. My lords, I'm filing a memo with the noting of the honorable trial court saying that the file is 24th of January. 24th of January, it was sent by the learned magistrate court, my lord. This, that I've complied with, my lords. I've deposited 1,000. My lord, 50% was to be deposited, including trial court amount. I couldn't comply it when this court granted me permission in December, my lords. Accordingly, I sought extension in March. Extended it, my lord. When I went to in the meanwhile, records have come, my lord. It may be granted permission to comply within 2 weeks of the records reaching the learned magistrate's court. Please, ma'am. If I'm not. Please, ma'am, I'll comply with it.
Petitioner in this case, my lords. Price 1 week short accommodation, my lords.
2 days time letter, complete the office, 2 days time letter, complete. Please.
2 days time. ನಾನೇ ಮಾಡಿದೆ ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದಿರ್ಲಿಲ್ಲ ಸರ್ ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವ್ರು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಕ್ಕೆ ಕೊಡುದಿಲ್ಲ ಕೋರ್ಟಿಗೆ ಬಂದು ಮತ್ತೆ 1 week ಕೊಡಿ ಸೇಮ್ 1 week time.
Appearing to the petitioner, seek to withdraw and withdraw with liberty to approach seeking for enhancements.
Grateful. For appellants, in this matter, my lord, some sort of sitting, both the parties have, and
Number 3, hospital
our client have agreed to,
time ಬೇಕು ಅಂತ ಹೇಳಿ ಮಾತಾಡ್ತೀವಿ.
ಅದೇ ಅವ್ರೇನೋ
3 weeks ಬೇಕಾಗುತ್ತೆ ಅವ್ರಿಗೆ.
3 weeks ಅಂತೆ, ಅದಕ್ಕೆ 4 ಅವ್ರೇನೋ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೋತಾ ಇದಾರಂತೆ. ಅವರು ನನ್ನ ಅಪೆಲೆಂಟ್ ಸಿಸ್ಟರ್ ಇಲ್ಲಿ ಅಪೆಲೆಂಟ್ಸ್ ಹ್ಯಾವ್ ಅಗ್ರೀಡ್ ಫಾರ್ ದೇರ್ ರೆಸ್ಪೆಕ್ಟಿವ್ ಶೇರ್ ಇನ್ ದಿ 35% ಆಫ್ ದಿ ಶೇರ್ my lord. ಅದ್ರಲ್ಲಿ 11 ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಏನೋ ಬರುತ್ತೆ. Our clients have given consent. I have given a proposal to them. Their client, I think she is in some treatment she is taking, they are telling. They are not sit together. ಅದಕ್ಕೆ ತಾವು 4th ಥರ್ಡ್ ಆರ್ ಫೋರ್ತ್ ಹಾಕೊಂಡ್ರೆ ಫೋರ್ತ್. ನಿಮ್ ಪ್ರಕಾರ 3 weeks ಅಂದ್ರೆ ಫೋರ್ತ್ ಆಗುತ್ತೆ. Please, madam.
My lords, we haven't been served a copy. 2 weeks time may be given, like, please serve our objections, my lords. We'll serve our objections, 2 weeks time may be given, my lords. My lords, we would like to, like, see the application, my lords.
Copy servagide, my lords. Alle. You have told, nim colleague anta helidru madidvi. Yarigiಲ್ಲ.
My lords, as per our instructions, we haven't been served a copy, my lords. As per the instructions, we haven't been served a copy, my lords.
ಅವರ ಕಲೀಗ್ ಅಂತಾನೆ ಹೇಳಿದ್ರು ಮಾಡಿದೀವಿ. ಅವರ ಕಲೀಗ್ ಅಂತಾನೆ ಹೇಳಿದ್ರು ನಾವು ಮಾಡಿದೀವಿ my lords.
I'll seek instructions, my lords. Please.
Lordships, I have for the petitioner, my lord. So I have filed this revision, my lord, against the order dated 9th September 2022, passed in by the trial court in the complaint by which my application for discharge has been dismissed, my lord. With great respect, I am submitting, my lord, I have no nexus at all. The FIR was filed with against the company only and the directors. I am nowhere connected with the company, my lord. I am nowhere connected to the company, my lord. My lord. No, my lord, in the FIR, I am not named at all, my lord. And the complaint also, there is no whisper of allegations against any of the owners, my lord. So charge should not be framed against me. I have nowhere connected, my lord. No, nobody has mentioned my name, my lord. But in the charge sheet by the CID, I have been mentioned as accused number 7, where I have no role at all in this. I have set out all these things in the grounds, my lord. And page number
7.
I am accused number 7 in the charge sheet, my lord.
Yes, yes.
Right now, the truth of this statement, unless the witnesses are tested to the court of fact, as stated above, when offense numbers 120 is not all have to take up on the court for answer as whether conspiracy or not. Since there is some material to show that some of the 70,000 was paid to accused number 7. The relevant period, same is required to be answered by the accused number 7. Not at this stage. Why and for what purpose such an amount was paid in the matter presented to the court not at this stage. This is the observation made very well. Having this is an amount of this 70,000. You have to explain it.
70 lakhs.
My lord, no owner has taken that. I have taken the money from them. Or another fetching the land I have taken from the company. And more important, I am not connected with the company, my lord. Only mere assumption that I have taken 70 lakhs from the.
Also, one Siddharuda and other witnesses, investors, have given a statement that is 160% before learned master.
Because there is a complaint against them, my lord. They are the directors of the company.
There is a document for having received your client and amount of 70 lakhs. You have to explain within the
Hey,
time of this.
reply is that I am the real agent, not connected with this dealing, my lord. For fetching the land only, I have taken 70 lakhs, my lord. And that is also, prima facie, no material, my lord, against me, my lord. I should be discharged, my lord. First of all, the complaint was filed against the Grih Kalyan Kendra company and the 6 directors, my lord, 2 to 5. Yes, my lord. In the meantime, because I will be harassed in the stay also.
I will dispose it of right now. Otherwise, if you want to argue the matter for a second, it will not for petition.
No notice has been issued or, my lord?
Already, CPP has taken notice.
Okay, my lord. Much obliged.
The court mic is muted, my lord.
First time, already taken,
The court's mic is muted, my lord.
notice already taken. Is a second.
ಹೊಸ ಸಿಸ್ಟಮ್ ತಂದ್ಮೇಲೆ ಪ್ರಾಬ್ಲಮ್. Even court is also unable to hear properly.
Yes, that I was facing the problem, my lord.
Anyhow, I will post the matter for admission some other day. You come and argue.
Item number 10, my lord.
Item number 10 only.
Yes, my lord. But in the
Yes.
meantime, notice.
List this matter for admission.
Obliged, my lord.
On ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 22/3.
Obliged, my lord.
22/3.
Petitioner, my lord. Challenging the discharge application, my lord. For Lokayukta.
Delay ಇದೆ.
We are challenging the discharge application. Notice means.
Issue notice on IA 1/24 and also on main against the respondent. In 138.
ಅಲ್ಲ ಮತ್ತೆ Lokayukta, PCR.
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 ಏನ್ ನೋಡಿ ಮೇಡಮ್ ಯಾರು ಲೋಕಾಯುಕ್ತ ಅಂತಾರೆ PCR ಅಂತಾರೆ.
PC Act.
PC Act. ಆಯ್ತು. Issue notice.
Appellant's counsel in this case, Your Honor. Appellant's counsel is in ICU, Your Honor. He is not well. I pray for 4 weeks time, Your Honor.
ನೀವು ಯಾರು ಪ್ರಾಕ್ಸಿನಾ?
I am a proxy counsel in this
Proxy
case.
counsel seeks time on the ground that
He is in ICU since from 10 days, Your Honor.
counsel who is on record is ICU from last 10 days.
10 days, please.
And hence this matter 3 weeks ಕೊಟ್ಟು ಆಮೇಲೆ ಕೊಡಿ. 4/4.
Oblige.
Hmm?
230 will go on.
Pass over.
2 times it is pass over, it is not.
ಇಲ್ಲ 230 already.
Pass over ಮಾಡಿ ಇದು reach ಆಗಿಲ್ಲ.
ಆಯ್ತು ಹೇಳಿ ಏನಕ್ಕೆ ಪಾಸ್ ಅವರು?
MR Rajagopal, senior counsel is.
ಲಾಸ್ಟ್ 2 occasions ಏನಾಯ್ತು ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
ಲಾಸ್ಟ್ ಪಾಸ್ ಆವತ್ತು ರೀಚ್ ಆಗಿಲ್ಲ ಅಷ್ಟೇ ಮಧ್ಯದ ಮೇಲಿಂದ.
ಪಾಸ್ ಓವರ್ ಆಗೋದು ಮತ್ತೆ ರೀಚ್ ಆಗಲ್ಲ. ಲಾಸ್ಟ್ 2-3 occasion ಇದೆ ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗಿದೆ ಈ ಮ್ಯಾಟರ್. ಆನ್ several occasion this matter was
ಡೇಟ್ ಹಾಕಬೇಕು. 230 ಗೆ ಮಾಡ್ತೀವಲ್ಲ.
ನೋಡಿ
ಡೇಟ್ ಬೇಡ 230 ಮಾಡ್ತೀವಿ.
Proxy counsel seeks time in WP number so and so on the ground that father of learned counsel who is on record is unwell. He also submits that he has informed the learned counsel for the respondents. ಸುಮ್ನೆ ಪಾಸ್ ಓವರ್ ಮಾಡೋದು ಹೋಗೋದು ಹಿಂಗೆ ಆಗ್ತಾ ಇದೆ.
230 ಮಾಡ್ತೀವಿ.
230 ಅಲ್ಲ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ ಅಂತ. ಆಯ್ತು ಪಾಸ್ ಓವರ್.
ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಅವತ್ತು ಬಂದು ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನಾವು ರೆಡಿ ಇದೀವಿ ಅಂತ.
ಎಲ್ಲದ ಯಾವ ಡೇಟ್ ಕೊಟ್ರು ಅದೇ ಕೆಲಸ. ಪಾಸ್ ಓವರ್ ಕೇಳೋದು ಒಂದೇ ಕೆಲಸ ಅವ್ರಿಗೆ.
ಎವ್ರಿ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಲೈಕ್ ದಿಸ್ ಮೈ ಲಾರ್ಡ್.
Appellant counsel seeks for passover and counsel for the respondent objects that if matter is passed over, he has got inconvenience. And hence list this matter. ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
But
22/3.
2:30 ಅಂದ್ರೆ ಸ್ಪೆಸಿಫಿಕೇಶನ್ ಟೈಮ್ ಕೊಟ್ಟರು ಸ್ವಾಮಿ ಅವ್ರು.
ನಾನ್ 2:30 ಅಂತ ಕೊಡೋದಿಲ್ಲ ಡೇಟ್. ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2:30, 1:30, 3:30 ಇಲ್ಲ. ಮ್ಯಾಟರ್ ಯಾವಾಗ ರೀಚ್ ಆಗುತ್ತೋ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
22/3 22/3 interim order to be extended. Status
ಮಾಡೋ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್. ಎರಡರಲ್ಲೂ ಇದೆಯಾ ಒಂದರಲ್ಲಿ?
ಒಂದರಲ್ಲಿ.
ನಿಮ್ದ್ರಲ್ಲ?
ಹೌದು. MFA
interim order granted in MFA 3627 of 23 is extended.
No, it may be like tomorrow.
ಏನಿದ್ ಮ್ಯಾಟರ್?
ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಸ್ವಲ್ಪ.
ಅದೇನಾಯ್ತು?
ನಾವು ಪಾಸ್ಪೋರ್ಟ್ ಮಾಸ್ ಕಾರ್ಡ್ಸ್ ಕೊಡ್ಬೇಕು.
ಅದೇನಾಯ್ತು ಸೆಟಲ್ಮೆಂಟ್?
ಆಫೀಸಿಗೆ ಬನ್ನಿ ಅಂತ ನಾವ್ ಹೇಳ್ತಾ ಇದೀವಿ. ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗ್ತಾ ಇದೆ. ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಟೈಮಿಂಗ್ಸ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗ್ತದೆ ಬರೋದಕ್ಕೆ.
ಅದಕ್ಕೆ ನಾನೇನ್ ಹೇಳ್ತೀನಿ, ಅವ್ರ ಆಫೀಸ್ಗೆ ಹೋಗೋದಲ್ಲ ಬೇಡ, ಇಲ್ಲಿಗೆ ದುಡ್ಡು ತಗೊಂಡ್ಬರ್ತಾರೆ. ಇಲ್ಲೇ ಇಲ್ಲೇ ರಿಟರ್ನ್ ನಾಳೆ
ಆಯ್ತು ಹಂಗೆ ಮಾಡಿ.
Exit formalities.
The exit formalities, they are insisting that my client should be present in their office. He is not their employee from the last 3 years. ಅವ್ರು ಅಲ್ಲಿ ಹೋಗಿ ಸೈನ್ ಮಾಡೋದು ಏನು ಎಕ್ಸಿಟ್ ಫಾರ್ಮಾಲಿಟೀಸ್ ಏನು ಇರೋದಿಲ್ಲ. ಅವ್ರು ಈಸ್ ಜಾಯಿಂಡ್ ಅನದರ್ ಕಂಪನಿ, ಎಲ್ಲ ಬೇರೆ ಕಡೆ ಈಸ್ ಮೂಡ್ ಆನ್.
ಆಯ್ತು, ಒಂದ್ ಲೆಟರ್ ಕೊಟ್ಬಿಡಿ. ವಿ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ದಿ ಅಮೌಂಟ್ so and so we have relieved her.
ರಿಲೀವಿಂಗ್ ಲೆಟರ್ ಕೊಡ್ಲಿ, ನಾವು ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ಸ್ ವಾಪಸ್ ಕೊಡ್ಲಿ.
ರಿಲೀವಿಂಗ್ ಯಾರು ನೀವು ಕೊಡ್ಬೇಕಾ?
ನಾವು ಕೊಡ್ಬೇಕು.
ಕೊಟ್ಬಿಡಿ ಒಂದ್ ರಿಲೀವಿಂಗ್ ಲೆಟರ್. ಅದೇನ್ ದುಡ್ಡು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದೀರಿ ಅದನ್ನ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. How long we have to keep this matter?
I understand. ಅವ್ರು ಬಂದು ಅಲ್ಲಿ ಬರಕ್ ಅವ್ರು ಎಂದು ಮುಂದೆ ನೋಡ್ತಾರ.
ಎಲ್ಲಿಗ್ ಬರ್ಬೇಕ್ರಿ?
ಆಫೀಸ್
ಮತ್ತಾಕ್ ಬರ್ಬೇಕು? ನೀವು ಬೇಡ ಅಂತ ಬಿಟ್ಟೋದ್ಮೇಲೆ ಮತ್ತಾಕ್ ಅವ್ರಿಗೆ ಬರ್ಬೇಕು?
ನಮ್ಮ ಕೊಲೀಗ್ ನ ಕಳ್ಸಿದ್ದೆ ಜೊತೆಗೆ. ಮೈ ಕೊಲೀಗ್ ವಾಸ್ ಆಸ್ಕ್ಡ್ ಟು ಸ್ಟ್ಯಾಂಡ್ ಔಟ್ಸೈಡ್ ದಿ ಆಫೀಸ್. ಆಚೆ ಕಡೆ ನಿಂತ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಅಡ್ವೊಕೇಟ್ಸ್ ನೆಲ್ಲ ಹೊರಗಡೆ ನಿಲ್ಸ್ಬಿಟ್ಟು.
ಅಲ್ಲ, ಇವ್ರು ನನ್ಗೊಂದ್ ಮಾತು ಹೇಳ್ಬಾರ್ದು.
ನಿಮ್ಗೆ ಹೇಳೋದಲ್ಲ ರೀ, ಅವ್ರಿಗೆ ಸೆನ್ಸ್ ಇರ್ಬೇಕು.
ಅಲ್ಲ, ಅವ್ರು ಅಡ್ವೊಕೇಟ್ ನ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ಕಂಪನಿ ಅವ್ರಿಗೆ ಸೆನ್ಸ್ ಇರ್ಬೇಕು. ಅಡ್ವೊಕೇಟ್ ಬಂದ
ಏನು ಮಾತಾಡಲ್ಲ. ಲಾಯರ್ಸ್ ಬಗ್ಗೆ ಬಂದಾಗ
ನಾನು ಹೇಳೋದು ಆಫೀಸರ್ ಆಫ್ ದಿ ಕೋರ್ಟ್.
ಹೌದು ಹೌದು.
They cannot make the advocate to stand outside.
ಅದ್ ಮಾಡಿದ ತಪ್ಪು ಸ್ವಾಮಿ, ನಾನು ಒಪ್ಪೋದೇ ಇಲ್ಲ.
ಅಲ್ಲಿಗೆ ಹೋಗೋದೇ ಬೇಡ. ಈಗ ಏನಾಗ್ಬೇಕು ಹೇಳಿ, ದುಡ್ಡು ಇಸ್ಕೊಳ್ಳಿ, ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ ಅಷ್ಟೇ. ಯಾವ್ದು
ನಾನು ಹೇಳಿದ್ದು
ಅಷ್ಟೇ ಮಾಡಿ. ಯಾವಾಗ ನಾಳೆನಾ ನೆಕ್ಸ್ಟ್ ಮಂಡೇನಾ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
ಅಲ್ಲ, ಅವ್ರ ಕನ್ವಿನ್ಸ್, ಅವ್ರು ದುಡ್ಡು ಕೊಡೋರು ಅವರು, ಎಕ್ಸಿಟ್ ಫಾರ್ಮ್ ಸೈನ್ ಮಾಡೋರು ಅವರು.
ನಾಳೆನೆ ಕೊಡ್ತಾರಂತಲ್ಲ ಅವರು. ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಟುಮಾರೋ.
ಆಗ್ಬೋದು
ಅಟ್ ದಿ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಬೋತ್ ಕೌನ್ಸಿಲ್. Non-filing of document in respect of site number 37. ಏನಿದು?
My lord, subsequently, my lord, there was some discussion between me and the appellant.
Told them that.
They have given an
I told them, my lords, to my learned friend, standing outside this, I said that it should come in this way anta ಹೇಳಿಲ್ಲ ನಾನು. I requested my learned brother that my client is old. She may sell it. Provided 10 ರೂಪಾಯಿಗೆ 9 ರೂಪಾಯಿ ಆದ್ರೆ ಒಪ್ಕೊಳ್ತಾರೆ, 10 ರೂಪಾಯಿಗೆ 2 ರೂಪಾಯಿ 3 ರೂಪಾಯಿ ಆದ್ರೆ ಒಪ್ಕೊಳ್ಳೋದಿಲ್ಲ ಅಂತ. ಅವ್ರು ಅದಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂದ್ರು. ನಾವಂತೂ ಅದಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ತೀರಾ ಕಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದೆ. ಈಗ question is, last time your lordship asked us to provide that if there is a layout plan and everything, place it on record anta. We have all these things, my lords. For them, they have to produce, my lords. On the last occasion, your lordship directed that they have to place the layout plan which they have, my lords. Now the question here is, my lords, if your lordships were to see the photograph, ಒಂದೇ ಒಂದು ನಿಮಿಷ
ನಿನ್ನೆ ಏನಾಯ್ತು, yesterday learned senior counsel had shown a photograph. ಹೊಸದಾಗಿ ಇನ್ನೊಂದು ಫೋಟೋಗ್ರಾಫ್ ತೋರಿಸಿ ನಿನ್ನೆ ಹೇಳ್ತಾ ಇದ್ರು, ಇನ್ನೊಬ್ರು ಬಂದು ಅಲ್ಲಿ ಹೆಸರು ಬರ್ತಿದ್ದಾರೆ.
ನಾವು ಲಾಸ್ಟ್ ಪೇಜ್ ತಗೋಬಹುದು ಸ್ವಾಮಿ.
So I'll have to take instruction so far as that is concerned. And the proposal given.
Why you defend such way? ಎಲ್ಲದರಲ್ಲೂ ಇದೆ, ಎಲ್ಲದರಲ್ಲೂ ಇದೆ, ಇದರೊಂದ್ರಲ್ಲಿ ಮಾತ್ರ ಇಲ್ಲ. ಹಿಂದಿನದ್ರಲ್ಲಿ ಇದೆಯಾ? ಥರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ 14ರಲ್ಲಿ ಇದೆಯಾ? ಮತ್ತೆ 15 ಇಲ್ಲ, 16ರಲ್ಲಿ ಇಲ್ವಾ?
ಬಿಗಿನಿಂಗ್ ಇಂದ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್, ಬಿಗಿನಿಂಗ್ ಇಂದ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲೂ ಹೇಳಿದ್ರು. ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಪೇಜ್ ನೋಡ್ಬೋದು ಸ್ವಾಮಿ, ನಾವು ಯಾವ ಕೊಟ್ಟಿರೋ ಪೇಪರ್ಸ್ ನಲ್ಲಿ ಫೋಟೋಗ್ರಾಫ್ ಹಾಕಿದೀವಿ. ಮೊದ್ಲು ಇವ್ರ ಹೆಸರಿತ್ತು ಅಂತ ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು ಇವಾಗ ಯಾರೋ ಗುಲಿಶೆಟ್ಟಿ ನಾಗರಾಜು ಅಂತ ಬರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಫೋಟೋಗ್ರಾಫ್. ಸ್ಟಾರ್ಟ್ ಮಾಡಿದಾಗ ಇವರು ಈ ತರ ಕಂಬಗಳು ಇದು ಹಾಕಿದ್ರು ಅಂತ ಹೇಳಿ ನಾವು ಬಂದು ಇಮ್ಮಿಡಿಯೇಟ್ ಆಗಿ ಹಾಕಿದಕ್ಕೆ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರು. ನಮ್ಗೆ ಇಂಜೆಕ್ಷನ್ ಇದೆ ನಮ್ ಕೇಸ್ ನಲ್ಲಿ. ದಟ್ಸ್ ವೇರ್ ದ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಸ್. ದಿಸ್ ಇಸ್ ವಿತ್ ಡೇಟ್ ವಿ ಹ್ಯಾವ್ ಟೇಕನ್ ದಿ ಫೋಟೋಗ್ರಾಫ್. 30 by 40 is our site. ಅವ್ರ ಪ್ರಕಾರ 900. ಇವತ್ತು ಹೋಗಿ ಅವ್ರ ಜಾಗ ಬೇರೆ ಅಂತ ಹೇಳೋದಕ್ಕೆ ಅವ್ರೇನಾದ್ರೂ ಅಲ್ಲಿ ಬಂದ್ ಮೆಜರ್ ಮಾಡಿ ನಾನು ನಮ್ ಜಾಗ ಇದೆ ಅಂತ ಅವರು ಅವ್ರ ಜಾಗ ಅದೇ ಅಂತ ತೋರಿಸಿದ್ರೆ ಇಟ್ ಬಿಕಮ್ಸ್ ಟೂ ಡಿಫಿಕಲ್ಟ್ ಫಾರ್ ಅಸ್ ಟು ಸ್ಟಾಪ್ ದಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್. ಪ್ರೀವಿಯಸ್ ಪೇಜ್ ತಗೋಬೋ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಪೇಜ್ ಗಿಂತ ನೆಕ್ಸ್ಟ್ ಹಿಂದಿಂದು ಅದಕ್ಕೆ ಹಿಂದಿಂದು ಫೋಟೋಗ್ರಾಫ್ ಇದೆಯಲ್ಲ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಹಿಯರ್ ಸೈಟ್ ನಂಬರ್ 37 ಅಂತ ಹಾಕಿದ್ದಾರೆ. ನಮ್ ಸೈಟ್ ನಂಬರ್ 37 ಗುಲುಶೆಟ್ಟಿ ನಾಗರಾಜು ಅಂತ ಕಾಂಪೌಂಡ್ ಮೇಲೆ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ, ತಾವು ಗಮನಿಸಬಹುದು. ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಒಂದೇ ಫೋಟೋಗ್ರಾಫ್, ಲಾಸ್ಟ್ ಬಟ್ 1 ಪೇಜ್ ಅಲ್ಲಿ. ಅದ್ರ ಪಕ್ಕದಲ್ಲಿರೋದು 1180 ಇಸ್ ದರ್ ಬೇರೆ ಒಬ್ರು ಪ್ರಾಪರ್ಟಿ, ಒಂದ್ ದೊಡ್ಡ ಮನೆ ತಮ್ ಕಾಣಿಸಬಹುದು ಅದು ಫೋಟೋನಲ್ಲಿ. ನಮ್ಮ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ಕ್ಲೀನ್ ಆಗಿ ಈ ಕಡೆಗಿರೋದು 1180 ಅಂತಿದೆ. ನಾವು BDA ಸೇಲ್ ಡೀಡ್ಸ್ ಕೊಟ್ಟಿದೀವಿ, BDAದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವ್ರ ಸೇಲ್ ಡೀಡು ಕೊಟ್ಟಿದ್ವಿ. ಅವ್ರದ್ರಲ್ಲಿ ಟು ದಿ ಸೌತ್ BDA ಪ್ರಾಪರ್ಟಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ಇಫ್ ದರ್ ಪ್ರಾಪರ್ಟಿ ಎಕ್ಸಿಸ್ಟ್ ಬಿಯಾಂಡ್ ದಿಸ್ ಇರ್ಬೋದೇ ಹೊರತು ಇದಿರಕ್ಕಾಗಲ್ಲ, ನಮ್ದಿರಕ್ಕಾಗಲ್ಲ. ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಮನೆ ಕಟ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ. ಅಂಡ್ ದರ್ಸ್ ಇಸ್ ಅಡ್ಮಿಟೆಡ್ಲಿ ದರ್ಸ್ ಇಸ್ ಅ ಪ್ರೈವೇಟ್ ಲೇಔಟ್. ಏನೋ ಅರ್ಕಾವತಿಗಿತ್ತು, ಆಮೇಲೆ ಸೇರಿಸ್ಕೊಂಡ್ರು, ಆಮೇಲೆ ಒನ್ ಏಕರ್ ಬಿಟ್ಬಿಟ್ರು ಅದ್ರಲ್ಲಿ ಒನ್ ಆಫ್ ದಿ ಸರ್ವೆ ನಂಬರ್ಸ್ ಅಂತ. Ours is completely the whole document, possession certificate, sale deed, everything is shown. Kindly see here, my lords. Page number 9 of our compilation may kindly be seen. Page number 9 schedule anta ide. Adರಲ್ಲಿ north by 1180 ಅಂತಿದೆ. 1180 ಅಂತ ಇದೆ. ಆಮೇಲೆ ಈ ಕಡೆ ಅವ್ರದ್ದು ಸೇಲ್ ಡೀಡ್ ನೋಡ್ಬೋದು ಸ್ವಾಮಿ. ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ 1178 ಗೆ ನಾವೇ ಕೊಟ್ಟಿದೀವಿ. ಏನು ನಾವು RTI ನಲ್ಲಿ ಎಲ್ಲ ಅಪ್ಲೈ ಮಾಡ್ಕೊಂಡು ಕೊಟ್ಟಿದೀವಿ. ಪೇಜ್ 35 ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಸಿ. 1178 ಗೆ ಅಡ್ಜಸೆಂಟ್ ಇಸ್ 1179 ಅಂತ ಇದೆ. ಕುಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಲೇ ಹ್ಯಾಂಡ್ಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ 35. ಪೇಜ್ 35 ನಲ್ಲಿ ಸೈಟ್ ನಂಬರ್ 1178 ಅಂತ ಆಲ್ ದಟ್ ಪೀಸ್ ಅಂಡ್ ಪಾರ್ಸಲ್ ಆಫ್ ಸೈಟ್ ನಂಬರ್ 1178 ಅಂತ ಕೊಟ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ನಾರ್ತ್ ಗೆ 1179 ಅಂತ ನಮ್ದು ಕ್ಲೀನ್ ಆಗಿ ತೋರಿಸಿದ್ದಾರೆ. ವಾಟ್ ಮೋರ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಮೈ ಲಾರ್ಡ್ಸ್, ದೇ ಸೇ ಸೈಟ್ ನಂಬರ್ 37 ಅಂತ. ವಿ ಹ್ಯಾವ್ ಈವನ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಲೇಔಟ್ ಪ್ಲಾನ್ ಆಲ್ಸೋ. Layout plan is in page 39, my lords. RTI ನಲ್ಲಿ ತಗೊಂಡಿರೋದು
39. Yours is 1180.
1179.
79.
1179 ಇದೆ. ನಮ್ಮ ಪಕ್ಕದಲ್ಲಿರೋ 1178 ನಾವು ಸರ್ವೆ ನಂಬರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದೀವಿ. ಇದಾದ್ಮೇಲೆ ನಮ್ದು ಪಾರ್ಟ್ ಆಫ್ ಸರ್ವೆ ನಂಬರ್ 76 ನಮ್ದು. ನಮ್ಮ RTI ನಲ್ಲಿ ತಗೊಂಡು ಅದೆಲ್ಲ ಕ್ಲೀನ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಿದೀವಿ. ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್
76 ಏನ ಸರ್ವೆ ನಂಬರ್
BDA ನಾವು ಅಕ್ವೈರ್ ಮಾಡಿದಾಗ. ಆಮೇಲೆ ಅದಕ್ಕೆ ಹಿಂದಿಂದಿರೋದು ಅವ್ರದ್ದು ಬೇರೆ ಯಾರ್ಯಾರ್ದೋ ಪ್ರಾಪರ್ಟೀಸ್, ನಮ್ಗೆ ಅನ್ನೆಕ್ಸ್ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 38 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, RTI ನಲ್ಲಿ ಕೊಟ್ಟಿರೋದು. ನಮ್ ಜಾಗದಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರೆ we are unable to, now we have got a stay order. Now the question is, trial court, what the trial court surprisingly says is that ನಿಮ್ ಜಾಗ ಅವ್ರ ಜಾಗ ಬೇರೆ.
Before continuing, my lord, yesterday the corridor, my lord, I spoke to the senior counsel. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರಪೋಸಲ್ ಹೇಳಿದ್ರು, ಐ ಹ್ಯಾವ್ ಪುಟ್ ಎ ವರ್ಡ್ ಟು ದಿ ಪಾರ್ಟಿ. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಮಾರ್ಕೆಟ್ ರೇಟ್ ಗಿಂತ ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಕೊಡ್ತೀವಿ. ಇಫ್ ಇಟ್ ಈಸ್ ಟೂ ಲೆಸ್ ದೆನ್ ವಿ ವಿಲ್ ನಾಟ್ ಅಗ್ರಿ ಫಾರ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್. And also yesterday photograph was shown to me saying that site number 37 ಮೇಲೆ ಬೇರೆ ಇನ್ನೊಬ್ರು ಗುಲಿ ಶೆಟ್ಟಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅಂತ. I have informed the party to get the instructions what has happened and if he is ready and willing.
ಗುಲಿ ಶೆಟ್ಟಿ ಯಾರು? ನಿಮ್ಮ ಹೆಸರು, ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಹೆಸರು?
ಗುಲಿ ಶೆಟ್ಟಿ ಅಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರೆ ಹೊಸಬ್ರು ಬಂದು ಬರ್ದಿದ್ದಾರೆ ಅಂತ.
ಹೊಸಬ್ರಲ್ಲ, ಇವರೇ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಯಾರೋ
ಅದು ಸೇಲ್ ಮಾಡಿದ್ರೆ there has to be, ಯಾಕೆಂದ್ರೆ ನಾನು ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ನು ದಿನ
I will take instruction, it may be taken up tomorrow.
Status quo order be given, my lords. ಯಾಕಂದ್ರೆ
ಅಲ್ಲ, ಇದರಲ್ಲಿ injunction order, my lords, first suit was filed by the respondent, plaintiff. And in this suit, there was an injunction order. Subsequently, they filed one more suit and there is also an injunction order in their suit. That is subsequent suit.
Let him get instruction. It's the matter tomorrow.
Page 37 ಅಲ್ಲಿ ತಾವು
ನಾಳೆನೆ ತಗೊಳ್ತೀನಿ.
ಆಗ್ಬೋದು.
ಯಾಕಂದ್ರೆ ಅವರು ನೆನ್ನೆ ಪ್ರಪೋಸಲ್ ಹೇಳಿದ್ರು, ಈಗ ರೆಡಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. I don't know that.
ರೆಡಿ ಇಲ್ಲ ಅಂತ
ಹೇಳಿದ್ರಲ್ಲ ಸರ್, ನಾನು ಅದಕ್ಕೆ I did not want to into an embarrassment.
ಅದನ್ನ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ, if there is any possible.
Counsel for the appellant has filed a document, list of documents 13 in number. Counsel for respondent seeks time, list this matter tomorrow.
Even with concessions, my lords, I am making it very clear. Till the concessions crystallize, there has to be some protective order, my lords.
ನಾಳೆನೇ ಮಾಡ್ತೀನಿ, ನಾಳೆ ನೋಡೋಣ. See what is. He will make submission. ಏನ್ರಿ ಇದು ಅವ್ನ್ ಕರ್ಸೇರಿ ಕಂಪ್ಯೂಟರ್. ಇದನ್ನೆಲ್ಲ ಅವ್ನ್ ಬಂದು ಫಸ್ಟ್ ಚೆಕ್ ಮಾಡ್ಬೇಕು ಕಂಪ್ಯೂಟರ್ ಸೆಕ್ಷನ್. ಕರ್ಸಿ ಅವ್ರಿಗಿಲ್ಲ ಅಂದ್ರೆ. Yes.
To file my objection. Okay, I said 8 inches encroachment ಇದೆ ಅಂತ ಬರೀತಾರೆ. 8 inches is as good as a brick. So ಅದು ಬಹುಶಃ ಅವ್ರಿಗೆ not measure the entire property because hindsight ಸಾಧ್ಯನೇ ಇಲ್ಲ. I have just got the report. Each time
ಆಯ್ತು, counsel for respondent ನೀವು ಯಾರಿಗೆ R1 6 weeks time to file objections to the commissioner report. This matter weeks time ಆದ್ಮೇಲೆ 22/3 25th ಆಯ್ತು 25th 25th RS ಡೇನೆ 25th. But last time absent. Entry matter entry, what is the matter?
In this case, my lord, now the respondent police have put a charge sheet against the respondent number 2 for the offence punishment under 447, 427, 324, 504, 506, read with 34 acres. Same as we referred to Lok Adalat for the settlement. Both the parties are appeared before the Lok Adalat. The Lok Adalat, my lord,
Memorandum of understanding, accordingly, the accused persons number 1 and 2 are discharged for the offences.
except 324, my lord, all the offences are compounding offenses, except 324.
324?
Non-compoundable offense. Even though the 324 is a non-compoundable offense, they have discharged the accused for all the offense.
Whether you are party before the Lok Adalat or not. State.
State
Now represent ಮಾಡಿದ್ರಿಲ್ಲ?
ಮಾಡಿದ್ವಿ. ಮಾಡಿದ್ದಾರೆ.
But then why you have not raised the objection before the?
Objection ಮಾಡಿದ್ದಾರೆ ಆದ್ರೂ ಕೂಡ ಅವರು
ಎಲ್ಲಿದೆ objection ಮಾಡಿರೋದು? ಎಲ್ಲಿದ್ದಾರೆ objection ಮಾಡಿರೋದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ? ಏನ್ ಅವ್ರ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡವ್ರು ಬಿಡಿ, ನೀವ್ ಯಾಕೆ ಅದಕ್ಕೆ?
324 ಇವೊಂದು
ಏನ್ ಮಾಡೋದು?
non-compoundable offense.
ಅವ್ರು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡು ಏನೋ ಮಾಡ್ಕೊಂಡಿದಾರಲ್ಲ, ನಿಮ್ ಸ್ಟೇಟ್ ದೇನ್ ಇಂಟ್ರೆಸ್ಟ್ ಪಾರ್ಟೀಸೇ ಬಂದು ಅಗ್ರೀಡ್ ಪಾರ್ಟೀಸೇ ಬಂದ್ ಮಾಡ್ಕೊಂಡಾಗ
320
ಓನ್ಲಿ ನಾನು ಹೀನಸ್ ಅಫೆನ್ಸ್ ಕಾಂಪೌಂಡ್ ಮಾಡಬೇಡಿ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವ್ರು ಹೇಳ್ತಾರೆ.
ವಿತ್ ಪರ್ಮಿಷನ್ ಆಫ್ ಕೋರ್ಟ್
ಮಾಡ್ಬೋದಲ್ಲ, ವಿತ್ ಪರ್ಮಿಷನ್ ಇದು ಲೋಕ್ ಅದಾಲತ್ ಅಂತ.
ಲೋಕ್ ಅದಾಲತ್ ಇಸ್ ನಾಟ್
ಲೋಕ್ ಅದಾಲತ್ ಅಲ್ಲೇ ಮಾಡಿರೋದ್ರಿ ಇದು. ಯಾಕೆ ಲೋಕ್ ಅದಾಲತ್ ಮಾಡೋದು?
C. 22C. Lok Adalat Act completely ignored the section.
Adalath, you are not objected, counsel. When the matter was referred to the Lok Adalat,
Please,
state has not objected for the same. Any of parties have settled, why you are coming in the way?
please.
Hmm?
Yeah, please.
Only they ought to have filed an application for compounding the offence and permission was taken, that's all. Hmm?
Yes.
Third, the petitioner counsel for respondent is absent. The main ground in this revision petition is that the other offences except offence under section 324 are compoundable in nature. Lok Adalat has completely ignored section 22C1 of the Lok Adalat Act, which clearly curtail jurisdiction from entertaining any matter relating to offences non-compoundable under law. And section 324 of IPC is a non-compoundable offence. In spite of that, the Lok Adalat has wrongly determined the issue involving non-compoundable offence, has permitted the informant and accused respondent for compounding the offence and erroneously discharge the accused. Hence, it requires interference. The counsel also produced a copy of the order passed by the trial court in discharging the accused for the offence punishable under section 324 at least section 34 of IPC. The matter was taken before the Lok Adalat. Complainant by name Raman Nashetty and accused 1 and 2 and their counsel and also APP are present. Both jointly filed application under section 320 sub-clause 2 of CRPC to report the settlement. In spite of APP was present before the court, he had not objected. And also an application is filed under section 320 sub-clause 8 of CRPC seeking permission to compound the offence, punishable under section 324 read with section 34 of IPC. Having perused the records, they have not only filed the application under section 320 sub-clause 2 of CRPC and even an application is filed under section 320 sub-clause 8 of CRPC seeking permission of the court. And having considered the offence of section 324 and also the application filed under section 320 sub-clause 8. And both the parties have agreed to withdraw the complaints. Case and counter case ಎರಡು ಇದ್ದಂಗಿದೆಯಲ್ರಿ? And trial court taking into note of case and counter case. And compromise entered in CC 69 of 2016 and the accused persons of the present case are also the complainant in other case and CC number 89 of 2016. And having taken note of the special circumstances of case and counter case, court has given the permission and permission is granted even for the offence punishable section 324 read with section 34 of IPC. Having satisfied with the settlement arrived between the parties and compromise, trial court, after giving the permission only to compound the offence, discharge the accused persons, and hence I do not find any error committed by the trial court in passing such an order, since applications are filed under section 320 subclass 2 as well as section 320 subclass 8, and court also given the permission to compromise, even though the offence under section 324 is not compoundable, and assigned the special reasons for giving permission also, since case and counter cases are also registered against each other, and hence I do not find any merit in the revision to set aside the order. Any of the discussions made above, I pass the following order. Revision petition is dismissed. ಅದ್ರಲ್ಲೇನ ಬಂದಿಲ್ಲ ಅಂದ್ರಲ್ಲಿ TCR ಬಂದಿಲ್ವಾ? The registry is directed to issue reminder to send the TCR and list this matter. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು? ಬೆಂಗಳೂರಾ? ಕೊಡಿ 2 ವಾರ ಬಿಟ್ಟು. 28/3.
Domestic Violence Act, my lord. If a wife has filed petition, the trial court has passed an order to pay 5,000 rupees maintenance and
5,000 rupees and also
1 lakh
an
rupees.
amount of rupees 1,50,000 as compensation, and also an alternative accommodation. What is the error in the order? Respond number 1 is hereby directed to secure the alternative accommodation to the petitioner and her child at Valenarshipura, and also directed him to pay rent for the same with the household articles for the livelihood of the petitioner and the child. What is the error anta kelta idini?
Lord, petitioner has no job, petitioner has no job, my lord.
No job.
And respondent, my lord, is willfully deserted the husband. He is not ready to
ವಿಚಾರಣೆ ಎಲ್ಲ ಆಗಿದೆಯಲ್ರಿ?
ಆಗಿದೆ ಸ್ವಾಮಿ. ಅವರು ಸೆಟ್ಲ್ಮೆಂಟ್
ವಿಚಾರಣೆ ಮಾಡ್ಕೊಂಡ
ಅಲ್ಲ, ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋತೀನಿ ಅಂತ ಅವ್ರು ಬರ್ತೀನಿ ಅಂತ ಈಗಲೂ ಹೇಳ್ತಾ ಇದಾರೆ, ಬರ್ತಾ ಇಲ್ಲ. ಒಂದೇ ಊರಲ್ಲಿ ಇದ್ದಾರೆ.
ಈಗ ಬರ್ತಾ ಇಲ್ಲ ಸರ್. ಈಗ ಏನಾಗ್ಬೇಕು? ನಿಮ್ಮವ್ನು ಏನ್ ಮಾಡಿದ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 by name Shivಣ್ಣ. So and so is examined himself as RW1 in his examination in chief of profit has almost reiterated whatever the objections filed by him. He got married with petitioner without receiving any dowry. The petitioner left the house by taking gold, rupees 50,000 cash, and now residing with said A.V. Mohan. Under his instigation has filed this false petition with an intention to harass the respondent. The petitioner is working as a teacher. ಅವನು ಹೇಳಿದಾನೆ, ನೀವು ನೋಡ್ರಿ ಯಾವ್ದು
ರೆಸ್ಪಾಂಡೆಂಟ್.
Vasavi school and running tuition classes so that she has got sufficient income. On the other hand, he is a creditor and suffering from ill health and has no income. ಏನ್ರಿ ಇದು? ಕರೀರಿಂದಲ್ರಿ ಎಲ್ಲಿ ಮತ್ತೆ? ಸ್ಲೋ ಆಗಿದೆ ಅಷ್ಟೇ. ಹೇಳ್ತಾ ಇಲ್ವಾ? ಈ A.V. ಮೋಹನ್ ಅಂದ್ರೆ ಯಾರು?
ರಿಲೇಶನ್ಶಿಪ್ ಇತ್ತು ಅಂತ ಹೇಳಿ.
ನೋಡ್ರಿ ಅದೇನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ದು? Yes, counsel.
My lord, she admitted in her evidence that my lord, he has no job. She is
Hmm.
working as a teacher.
Hmm.
And she willfully, my lord, she is not ready to join with the petitioner. She is residing with.
Teacher ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ? ಹಾ?
He has not produced.
ಈಸ್ ಎ ಟೀಚರ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ರಿ? ಏನು ಕೊಟ್ಟಿಲ್ಲ.
He is not residing with the petitioner, my lord. She
Hmm.
is staying separate. Amount may be reduced.
Go to paragraph. Go to paragraph number 25. Middle ಅಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ ನೋಡಿ from bottom. He has admitted the advertisement found in exhibit P25 and also admitted that wherein he has been shown as LIC agent.
Earlier, my lord.
He denied that as per exhibit P11, he is working in a company and salary has been fixed at rupees 10,800.
My lord, in her evidence, she has admitted that.
He admits that his family has got 2 houses. But he denied that has got 2 barrel houses. He deposed that he has got documented bank, 2 bank account ಇದೆ ಅಂತ.
Cross examination, my lord. ನನ್ನ ಗಂಡ ಈಗ ಏನು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಈಗ ನನ್ನ ಗಂಡ ಕೆರೆಕೋಡಿಯಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದಾರೆ.
So you are working as LIC agent also. You have given an advertisement in terms of exhibit P25 and also exhibit P11. You are working.
He also opened medical shop with one Mohan, my lord. Medical shop, my lord. She's taken all things and amount from the that person.
Compliment letter and revised salary slip issued by the TICAL company. LIC agent reports and commission reports in terms of exhibit P12 to 19. RTC extracts. Sale notice of tobacco. Account extract of first respondent. Complimentary publication made by the first respondent. LIC commission journal for the month of June and July 2014. All these documents are produced by the petitioner in respect of you only. Then what is the error in the order? No grounds, counsel.
Some amount may be reduced. Amount may be reduced. Amount ಸ್ವಲ್ಪ ಕಮ್ಮಿ. She is not residing with the petitioner. Compensation amount ಅದು ಸ್ವಲ್ಪ. No domestic was taken. Compensation amount may be reduced. ಜೊತೆನಲ್ಲೇ ಇಲ್ಲ ಅವರು. She is not residing with the petitioner. Compensation award 1,50,000.
ಕೊಟ್ಟಿದ್ದಾರೆ 1.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನು.
ಅಲ್ಲ ಅವ್ರ
ಏನ್
ಜೊತೆನೆ
ಜಾಸ್ತಿ ಏನ್ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ ಜೊತೆನಲ್ಲೇ ಇಲ್ಲ.
ಆಮೇಲೆ ಮೇಂಟೆನೆನ್ಸ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಬರೀ 5,000 ರೂಪಾಯಿ. ಇಬ್ರಿದ್ದಾರೆ. ಅದ್ರಲ್ಲೇನು ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಅದ್ರಲ್ಲಿ 5,000 ರೂಪಾಯಿನಲ್ಲಿ ತಾಯಿ ಮಗು ಬದುಕಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ಇವ್ರು ಈ ರೆಡಿ ಇದಾರೆ ಸ್ವಲ್ಪ ಆಯಮ್ಮ ಬರ್ತೀನಿ ಕಾಂಪ್ರಮೈಸ್ ಅಂತೇಳಿ ಬರ್ತಾನೆ ಇಲ್ಲ, ಒಂದೇ ಊರಲ್ಲಿ
ಅದೆಲ್ಲ
ಇದ್ದಾರೆ.
ಮುಗ್ದೋಯ್ತು ಬಿಡಿ ಅದೆಲ್ಲ.
ಅಲ್ಲ ಒಂದೇ ಊರಿನಲ್ಲಿ ಇದ್ದಾರೆ, ನೋಟಿಸ್ ಸರ್ವಾಗಿದೆ, ಬರ್ತಾ ಇಲ್ಲ.
ಆರ್ಡರ್ ಮಾಡಿರೋದೇನ 5,000. ನೋಡಿ, heard the petitioner counsel and counsel for the the respondent those served non-represented. The trial court having taken note of material, particularly the evidence of PW 124 and also the document exhibit P 1-26. And no doubt the respondent public revision petitioner also examined himself as RW1 and also examined one witness as RW2. Got marked document exhibit R 1-11. Trial court having taken note of the material on record, both oral and documentary evidence, and also the admission on the part of RW1, wherein he has categorically admitted that he himself has given the advertisement in terms of exhibit P5. That is complimentary publication made by the first respondent himself. He has been shown as LIC agent. And apart from that, also he admitted that his family has got 2 houses. And also having account in SBI and also Canara Bank. But now he says the same are not in existence. And having taken note of the domestic violence also, invoke section 19F and order to secure the alternative accommodation to the petitioner and her child at Valanasipura, and also directed him to pay the rent for the same with household articles for the livelihood of the petitioner and her child. And also ordered to pay maintenance amount of rupees 5,000 per month to the petitioner as a monetary relief. And also directed to pay the compensation amount of rupees 1,50,000 for the mental torture and domestic violence caused to the petitioner. By invoking section 21D as well as section 22 of PWDV Act. The same is also challenged in criminal appeal number 15 of 2016. And appellate court also having reassessed the material available on record. In paragraph number 18 comes to the conclusion that trial court has not committed any error and given anxious consideration to the material on record and dismissed the appeal. The main contention of the petitioner counsel that the compensation awarded is on higher side. And also respondent is working as a teacher at SLN Primary School and drawing salary. And though contend that she is working as a teacher, no document is placed before the trial court in order to prove that she is working as a teacher. And documents which have been produced R1 to R11 are not in respect of her employment is concerned. In order to interfere the findings of the trial court and also the appellate court, I do not find any error committed by the trial court, and trial court also in paragraph number 24 in detail discussed both the documents of petitioner as well as respondent. And in paragraph number 25 also taken note of the answer elicited from the mouth of the RW1. And so also the evidence of RW2 in paragraph number 26 and in 27 considered both oral and documentary evidence and ordered for essentials for livelihood. And the fact that she is having a child also taken note of, and amount of rupees 5,000 awarded by the trial court as a monetary relief from the date of petition is also not an exorbitant. The contention that 1,50,000 awarded is on higher side and having taken note of the both oral and documentary evidence and also particularly evidence of PW 2 to 4 who have been examined with regard to the Domestic Violence Act also. I do not find any error committed by the trial court in fixing the amount of rupees 1,50,000 for the mental torture. And also taken note of capacity of the petitioner. And also it is the bond and duty of the petitioner to maintain the child and also the wife. And alternative accommodation is also ordered, directed to pay the rent for the alternative accommodation, and hence I do not find any ground to exercise the revisional jurisdiction. And the order is not suffers from any legality and its correctness. And scope of revision is also very limited, and hence no merit in the revision petition. In view of the discussions made up, I pass the parent order. Revision petition is dismissed. 21.
Filing application, my lord, joint, along with joint affidavit filing application, my lord.
Told you then.
Matter settled with respondent, my lord.
Both the parties have filed an application under section 147 of NA Act and also the joint affidavit settling the issues between the parties. In terms of settlement,
My lord, 4,82,000 trial court ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ
4,82,000 deposit
ಡೆಪಾಸಿಟ್ ಆಗಿದೆ, ಅದು ರಿಲೀಸ್ ಮಾಡ್ಕೊಂತೀವಿ. ಮತ್ತೆ ರಿಮೈನಿಂಗ್ 3,18,000
agreed to receive rupees 8 lakh as full and final settlement. ಅದೇನಾಯ್ತು ಕೊಟ್ಟಾಯ್ತಾ?
ಅಲ್ಲ ಸುಮ ಅದು 8 lakhs ಅಲ್ಲಿ 4,82,000 ಅಲ್ಲಿ ಕಟ್ಟಿದೀವಿ. ಇನ್ನ 3,18,000
Remaining 3,18,000
26ನೇ ತಾರೀಕು ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇದೆ, ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅವ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಡೇಟ್ ದಿವಸ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಕೊಡುತ್ತು ಅಂತ
ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ.
ಏನ್ರಿ ಕೊಡ್ತೀನಿ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್. ಪಾರ್ಟೀಸ್ ಒಪ್ಪಿಕೊಂಡು. In terms of the joint affidavit, it was settled for full and final settlement for an amount of rupees 8 lakh. Out of that, already amount in deposit to the tune of rupees 4,82,400 before the trial court. And remaining amount of rupees 3,18,000 agreed to pay on 26/3/24. In an execution petition, na?
ಹೌದು ಸ್ವಾಮಿ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
DD ಅಂತ ಮೆನ್ಷನ್, ಡಿಮ್ಯಾಂಡ್ ಡ್ರಾಫ್ಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಬೈ ವೇ ಆಫ್
ಇಲ್ವಲ್ಲ, ಏನು ಬರ್ದಿರಲ್ಲ ಡಿಮ್ಯಾಂಡ್ ಡ್ರಾಫ್ಟ್.
ಅಲ್ಲ 3,18,000 will be paid by way of DD ಅಂತ. 3,18,000.
3,18,000
18,000 ಇದೆ ರೀ. ಅಂದ್ರೆ ನೀವು ಬೈ ವೇ ಆಫ್ ಡಿಡಿ
By way of DD.
ಬರ್ದಿದ್ದೀರಿ.
ಹೌದು sir.
ಬೈ ವೇ ಆಫ್ ಡಿಡಿ. In view of settlement arranged between the parties, an application filed under section 147 of negotiable instrument is allowed and permitted them to compound the offence punishable under section 138 of negotiable instrument act. ಏನಾಯ್ತು? ಫೈನ್ ಅಮೌಂಟ್ ಕೊಡ್ರಿ.
ಫೈನ್ ಅಮೌಂಟ್ 5,000 ಇದೆ. 5,000 ಇದೆ ಮಂಗಲ್.
ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಕಟ್ಟಿ 15 days.
The petitioner is permitted to deposit the fine amount of rupees 5,000 before the trial court within 2 weeks
2 weeks.
and produce the receipt for having deposited the amount of rupees fine amount before the registry within 20 days.
ಆಗ್ಬೋದು sir.
If fails to pay the fine amount and produce the receipt, the matter will be revived.
Great sir.
Petitioner is convicted for the offence under section 279 304A.
2 ವರ್ಷ ಇದ್ದಿದ್ದು 1 ವರ್ಷ ಮಾಡಿದ್ದಾರೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ದೋಷ ಮಾಡಿದ್ದಾರೆ. ಇವ್ರು ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ಗುದ್ದಿದ್ದಾನೆ. ಹಿಂದ್ಗಡೆಯಿಂದ ಬೈಕ್ ನವನು.
ಎಲ್ಲಿಂದ?
ಹಿಂದ್ಗಡೆಯಿಂದ.
ಹಿಂದ್ಗಡೆಯಿಂದ.
ಅಲ್ಲಿ ಪೇಪರ್ ಅಲ್ಲೂ ಬಂದಿದ್ದು 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು.
ಹಿಂದ್ಗಡೆಯಿಂದ ಹೋಗಿ ಡಿಕ್ಕಿ ಹೊಡೆದಿದ್ದ?
ಹೌದು ಹಿಂದ್ಗಡೆಯಿಂದ ಹೋಗಿದ್ದು.
ವೆಹಿಕಲ್ ಮುಂದೆ ಹೋಗ್ತಾ ಇತ್ತು.
ಅವರು ಎವಿಡೆನ್ಸ್ ಪ್ರಕಾರ PW
being the driver of the mini goods vehicle.
ಎವಿಡೆನ್ಸ್ ಆಫ್ ದ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇವರು ಓವರ್ಟೇಕ್ ಮಾಡಿದಾಗ ಅವ್ನು ಹಿಂದ್ಗಡೆಯಿಂದ
towards Shikaripura, and when he reached near Mahadeva rice mill, he drove the same in a rash and negligent manner, endangering the human life, and overtook the bike bearing registration number so and so, which was driven by the deceased Harish. and stopped the lorry all of a sudden without giving any signal, due to which the rider of the bike lost control over the bike and dashed to the lorry which was driven by the accused.
The sketch no produced madilla in order to prove that. Sketch was not produced before and sketch was not marked.
Court records for
But there's a 3 eyewitnesses supported the case.
Support madidara?
Support.
Eyewitness.
Independent eyewitness.
Independent, they are PW2 is the working, PW3 is working under the deceased. PW2 is also known to the deceased, and PW5 also the same village, my lord. There is
You accident deny madilla anta cross examination alli matter cases
signal
are denied.
suggestion ಹಾಕಿದ್ದಾರೆ ಸಿಗ್ನಲ್ ಕೊಟ್ಟು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಸಜೆಷನ್ also. Al 313 statement
On the other hand, from the cross examination done to PW 1 to 3 and 7, it goes to show that the accused is admitting that he had overtaken the bike of the deceased on the left said road and he stopped the lorry in front of the bike.
ಸಿಗ್ನಲ್ ಕೊಟ್ಟು ನಿಲ್ಲಿಸಿದಂತ there is one suggestion put forward to the witnesses. ಅಲ್ಲೇ 313 statement ಅಲ್ಲಿ there is a
ರೋಡ್ ಅಲ್ಲಿ ಹೆಂಗೆ ನೀವು ಸಡನ್ ಸ್ಟಾಪ್ ಮಾಡಕ್ ಆಗುತ್ತಲ್ಲಿ?
ಅಲ್ಲ ಅವನು ಇದರಲ್ಲಿ PW7 only 4 to 5 feet back gap ಇದೆ ಅಂದ್ರೆ there is no gap is also not maintained by the ಅಂತ ಹೇಳ್ತಾರೆ. 313 statement ಅಲ್ಲಿ ವಿಜಯ ಕರ್ನಾಟಕ ಪೇಪರ್ ಇದೊಂದು ಕಟ್ಟಿಂಗ್ ಅಲ್ಲಿ ಇದಾಗಿದ್ದು ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ಶೂರೆನ್ಸ್ ಕ್ಲೈಮ್ ಮಾಡೋದಕ್ಕೆ then they have planted the witnesses. ಜೊತೆ ಒಂದು ವಿಜಯ ಕನ್ನಡ ಪೇಪರ್ದು ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ಸಿ ದಟ್ ನಂಗೆ ಸಿಕ್ಕಿಲ್ಲ ಅದು 313 ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ನಿಮ್ಮವನ್ಗೆ ಸಜೆಷನ್ ನೋಡ್ರಿ PW2 ಗೆ
ನೋಡಿದ್ವಿ.
ಕೃತ ಹರೀಶ್ ರವರು ಕ್ಯಾಂಟರ್ ಲಾರಿಯ ಮುಂಭಾಗದಲ್ಲಿ ಬರುತ್ತಿದ್ದರು ಅಂದರೆ ಸರಿ ಅಂತ ಕ್ಯಾಂಟರ್ ಗಿಂತ ಮುಂದೆ ಇದ್ದ ಅಂತ ಆಯ್ತು. ಸಾಕ್ಷಿ ಸ್ವತಃ ಓವರ್ಟೇಕ್ ಮಾಡಿ ಬಂದು ಮುಂದಕ್ಕೆ ಏಕಾಏಕಿಯಾಗಿ ನಿಲ್ಲಿಸುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸಿಗ್ನಲ್ ಕೊಟ್ಟು ನಿಲ್ಲಿಸ್ತಾ ಅಂತ ಮತ್ತೆ ಅದು ಬೇರೆ ಸಜೆಷನ್.
ಇವರೇ ಮೈ ಮೇಲೆ ಹೇಳ್ಕೊಂಡು ಹಾಕಿದ್ರಲ್ಲ
ಕ್ರಾಸ್ ಅಲ್ಲೆಲ್ಲ ಅವರೇ ಮೈ ಮೇಲೆ
ಹೌದು.
First of all, is not denied the overtaking the bike.
ಏನಿಲ್ಲ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ.
ಇದ್ರಲ್ಲಿ 313 ಅಲ್ಲಿ ಒಂದು ಅಲ್ಲಿ 313 ಅಲ್ಲಿ ಒಂದು ಪೇಪರ್ ಕಟ್ಟಿಂಗ್
ಓವರ್ಟೇಕ್ ಮಾಡುವ ಪೂರ್ವದಲ್ಲಿ 2 ವಾಹನಗಳ ಮಧ್ಯೆ 6 ಅಡಿ ಅಂತರ ಇತ್ತು. ನಾನು ಅಂಗಡಿಯಲ್ಲಿ ಹೊರಗಡೆ ಕೆಲಸ ಮಾಡುತ್ತಿರುವಾಗ ಈವನ್ ಸಜೆಷನ್ ಆಲ್ಸೋ ಓವರ್ಟೇಕ್ ಮಾಡುವಾಗ 6 ಅಡಿ ಅಂತರ ಇತ್ತು. ನಾನು ಅಂಗಡಿಯಲ್ಲಿ ಹೊರಗಡೆ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಈ ಅಪಘಾತವನ್ನು ಕಣ್ಣಾರೆ ನೋಡಿರುತ್ತೇನೆ. 2, 3 are the eyewitnesses.
ಅವ್ರ ಪೇಪರ್ ಅಲ್ಲಿ ಬಂದಿದ್ದು ಒಂದು 313 ಅಲ್ಲಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಪೇಪರ್ ಕಟ್ಟಿಂಗ್.
ಏನಂತ ಕೊಟ್ಟಿದ್ರಿ?
ನನಗೂ ಸಿಕ್ಕಿಲ್ಲ ಅಲ್ಲಿ 313 ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ವಿಜಯ ಕರ್ನಾಟಕದ ಕಟ್ಟಿಂಗ್ ಅವ್ರ ಪೇಪರ್ ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿರೋದು.
PW2 ಅಲ್ಲ 2, 3, 7
7 are eyewitness.
Four is also eyewitness, but he is not supported the case. Four is also eyewitness, is not supported the case.
Police also
Eyewitness,
eyewitness.
PW four.
ಯಾರದು PW?
Four is not supported the case of prosecution.
PW?
Four,
Four not supported.
Not supported.
not supported.
ಹಾ ಗಾರೆ ಕೆಲಸ ಪೊಲೀಸ್ ಅಲ್ಲ ಅವನು.
Police ಅಲ್ಲ.
PW four
Independent eyewitness is not. ಕರಿಯಪ್ಪ.
Kariappa.
ತ್ರೀ ಅಲ್ಲಿ ಒಂದು ವಿಜಯ ಕರ್ನಾಟಕ ಅವತ್ತಿನ ಇನ್ಸಿಡೆಂಟ್
ಏನಂತಿದೆ?
ಅದು ಗೊತ್ತು, ನನ್ಗೂ ನೋಡಕ್ಕಾಗಿಲ್ಲ.
ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಪೇಪರ್ 313 ನಲ್ಲಿ.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. Page 4 of the judgment, CC number 510 ಮೇಲೆ. Accused, but he has produced the newspaper by name Vijay Karnataka dated 4/1/2018. ಈ judgment ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ತಾರೆ. Accused, but he has produced the newspaper by name Vijay Karnataka dated.
ತಪ್ಪು ಮಾಡಿಲ್ಲ, ನನ್ನ ಪಾಡಿಗೆ ಹೋಗುತ್ತಿದ್ದೆ, ದಿನಪತ್ರಿಕೆಯಲ್ಲಿ ಕೂಡ ಅಪಘಾತದ ಬಗ್ಗೆ ಬಂದಿರುತ್ತದೆ ಅಂತಾನೆ.
He has produced the newspaper by name Vijay Karnataka dated 4/1/2018 in which the road accident is reported ಅಂತ ಇದು judgment ಅಲ್ಲಿ ಇದೆ.
ಹೇಳ್ದಾಗ ಕೊಡ್ಬೇಕಲ್ಲ ಪೇಪರ್ನ.
ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಇದರಲ್ಲಿ even mentioned in the judgment also.
ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀ 313 ನೋಡ್ಕೊಂಡು ಮಾಡಿರ್ತಾರ ಅಷ್ಟೇ. ಎಲ್ಲಿದೆ ಪೇಪರ್? ಅವ್ರು ಹೇಳೋದು ಬಂದಿದೆ ಅಂತ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಅಂತ ಇದೆ ಇದರಲ್ಲಿ. Kindly see page number 4 of the judgment, my lord. He has produced ಅಂತ ಇದೆ.
ನಾನು ತಪ್ಪು ಮಾಡಿಲ್ಲ, ನನ್ನ ಪಾಡಿಗೆ ಹೋಗುತ್ತಿದ್ದೆ, ದಿನಪತ್ರಿಕೆಯಲ್ಲಿ ಕೂಡ ಅಪಘಾತದ ಬಗ್ಗೆ ಬಂದಿರುತ್ತದೆ ಅಂತ ಇದೆ ಅಷ್ಟೇ. ಹಾಜರುಪಡಿಸಿದೀನಿ ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ ಇಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ರೀ, ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲೇ ಇಲ್ವಲ್ಲ.
Not been marked.
ಅಲ್ಲಿ ಮಾರ್ಕ್ 313 ಅಲ್ಲಿ
ಮಾರ್ಕ್ ಅಲ್ಲ,
313 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
ನಾನು ಸ್ವಲ್ಪ ನೋಡಿ
ಕೊಡ್ರಿ, ತೋರ್ಸಿ ನೋಡೋಣ ಅಟ್ಲೀಸ್ಟ್ ಪೇಪರ್ ಏನಾಗಿದೆ ಅಂತ ನೋಡೋಣ.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ, he has produced ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಯಾವ ಪೇಪರ್ ಇದೆ? ಪ್ಯಾರಾದಲ್ಲಿ
ಇಲ್ಲಿ ಪ್ಯಾರಾ 4, my lord, page number 12 of the petition.
ಪ್ಯಾರಾ 4.
ಪ್ಯಾರಾ 4. Page number 4.
This defense is one of the total denial of the allegations leveled against him. No evidence is adduced on behalf of the sponsor, but he has produced a newspaper by name Vijay Karnataka dated 4/1/2018 in which the road accident is reported. Produced ಅಂತ ಬರ್ದಿದ್ದಾರೆ, ಬಟ್ ಅಲ್ಲಿ ನಿಮ್ 313 ನಲ್ಲಿ ಹಂಗಂತ ಹೇಳಿರೋದ್ ಬಿಟ್ರೆ ಮತ್ ಬೇರೆ ಏನೂ ಇಲ್ಲ.
First of all, he has not been examined as a defense witness. First of all, he has not been examined as a defense witness.
ಅವನು ವಿಚಾರಣೆ ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಪೇಪರ್ ಇಲ್ಲ, ಅದೇ ನೋಡಿದೆ.
ಪೇಪರ್ ಅಲ್ಲಿ ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ಗುದ್ದಿದೆ ಅಂತ ಬಂದಿದೆ ಅವತ್ತು. ಇದು ಇನ್ಶೂರೆನ್ಸ್ ಕ್ಲೈಮಿಗೋಸ್ಕರ ಆಮೇಲೆ
ಬಟ್ ದಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಡಿಸ್ಪ್ಯೂಟ್. ಹಿಂದಿಂದ ಗುದ್ದಿರೋದೆ, ನಾವು ಸಡನ್ಲಿ ಸ್ಟಾಪ್ ಮಾಡದ ಅಂತ.
ಹೆಲ್ಮೆಟ್ ಹಾಕಿರ್ಲಿಲ್ಲ ಅವನು. Sketch is also in order to prove that in what which manner the accident was happened. It was not proved. Motor vehicle inspector is also not. Probation, my lord.
Probation ಇಲ್ಲಿ 6 ತಿಂಗಳು ಮಾಡೋಣ ಅಷ್ಟೇ. 2 ವರ್ಷ ಇತ್ತು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ, ಇದರಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ, ಒಂದ್ ವರ್ಷಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 19 ಪ್ಯಾರಾ 25 ಅಲ್ಲಿ ರೂಲಿಂಗ್ ಆಫ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಸ್ ದಟ್ PO is not applicable ಅಂತ ಹೇಳಿದ್ದಾರೆ. PO Act is not applicable to the case ಅಂತ ಹೇಳಿದ್ದಾರೆ. Later on the Supreme Court by relying that ಅದನ್ನು ಕೋಟ್ ಮಾಡಿ then PO ಅಲ್ಲಿ given cases ಅಲ್ಲಿ ಕೊಡಬಹುದು ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಹಿಂಗಡೆಯಿಂದ ಗುದ್ದಿದ್ದಾಗಿ the facts of the case, my lord. PO ಅಲ್ಲಿ 2015 SCC 4444 ಇದರಲ್ಲಿ
ಅದೇನ್ ಕೊಡ್ತೀರಿ?
ಪ್ಯಾರಾ 22 ಅಲ್ಲಿ which was reported the
ಯಾವ ಇಯರ್ ಆಗಿರೋದು?
2018 3/1/2018.
18
ಹೌದು. ಪ್ಯಾರಾ 22 ಅಲ್ಲಿ the judgment which was referred by the magistrate ಮಾಡಿದ್ದಾರೆ.
ಏನು ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಕೇಸ್ ಇತ್ತು
ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 22. ಅದು ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ಸ್ PO ಬಗ್ಗೆ ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿ ಪ್ಯಾರಾ 22 ಅಲ್ಲಿ it does appear that depending on the facts of each case, causing a death by what appears to be a rash and negligent act may amount to an offence punishable under part 2 of the section 304A, not warranting the release of the conviction under the probation. There may be also a situation where the offences is punishable under section 304A IPC is an accident where mens rea remains absent, and refusal to release the conviction probation in such a case may be too harsh on approach to take. An absolute principle of law cannot be laid down that in a case, no case falling under section 304A IPC should be convict to be released on probation. This is certainly not to say that in all cases falling under section 304A of IPC, the convict must be released on probation. It is only that the principle laid down in section 360, 361 of the Criminal Procedure Code and the Probation Offender Act should not be disregarded, but should be followed and an appropriate decision depending on the facts of the case be taken in each case. Really, ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ಗೊತ್ತಿದ್ರಿಂದಾಗಿ there is no vicarious liability ಇದೆ. ಅಲ್ಲದೆ ನಮ್ಮವ್ರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಂದಾಗಿ in fact my lord sketch is also my lord.
All admitted the very how an accident was taken place.
But he has not denied this thing.
Even accident also not denied, and even
Case of accident also not denied.
motorcycle also not denied.
Also parking of the lorry was not denied.
In fact,
Parking of the lorry was not denied.
Sorry, third. How did the petitioner counsel and also the counsel appearing to the respondent? The factual matters of case of prosecution before the trial court, while invoking the offence punishable under section 279, 304A of IPC and section 134A, B, 187 of IMA Act. It is alleged that the petitioner herein is the driver of the mini goods vehicle bearing registration number K14/B.5346, on 3/1/2018 at about 9 AM. And drove the same from Shivamogga towards Shikaripura. And when he reached near Mahadeva Rice Mill, he drove the same in a rash and negligent manner, endangering human life, and overtook the bike bearing registration number K15/S.3328, which was driven by deceased Harish, and stopped the lorry all of a sudden without giving any signal, due to which the rider of the bike lost control over the bike and dashed to the lorry which was driven by the accused, result of which the rider of the motorcycle fell on the road and sustained grievous injuries and succumbed to the injuries on the way to the hospital. Hence, case has been registered and investigated the matter and filed the charge sheet. The prosecution, in order to prove the charges leveled against the accused, examined PW 12 10, also got marked document exhibit P 1 to 15. The revision petitioner has not led any defense evidence, and trial court having taken note of the particularly the eyewitnesses evidence of PW 2, 3 and 7 comes to the conclusion that accident is on account of negligence on the part of the petitioner, and also comes to the conclusion that accident has not been denied, even overtaking of the motorcycle is also not denied. And only suggestion was made that he stopped the vehicle with signal. The fact that the fact of defense
Probation. Weeks time, my lord. Weeks time. 138 matter, my lord. I already suggested them to settle the issue, my lord. Settle the matter, my lord. Okay, I'm telling you. 1 week. How? 1 week.
ಹೇಳಿದ್ದಾರೆ they saying that ಅವ್ರ possibility ಇಲ್ಲ my lords, my instructions are possibility ಇಲ್ಲ. My lords, application for withdrawal of the amount and deposit. On the application for withdrawal of amount ಹಾಕಿರ್ಲಿಲ್ಲ my lord. I thought ಏನಾದ್ರು ಒಂದು ಆಗ್ಬೋದು.
28th ಇದಾಗಿಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು. ವಿಡ್ರಾಲ್ ಅಲ್ಲ 28th ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿ.
Please.
Negotiation is going on, man. 2 weeks time and begin. Settlement matartare 2 weeks.
First time it is coming before the.
Right.
The petitioner.
Your Lordship, in this case, I am appearing for the respondent. Your Lordship, total amount 30 lakhs.
3
Out
lakhs.
of 30 lakhs, 27 I have received, and remaining
3
due amount
lakhs.
is 3 lakhs. 3 lakhs.
Balance.
Yes, Your Lordship. 3 lakhs you were supposed to pay on 19th of February. On that day, he has not paid, and he no representation. Today, petitioner is present. Yes, Your Lordship. Today,
This month
petitioner is
26th I paid. This month 26th. Balance amount, my lord. Yes, my lord. 1.5.
Your Lordship, he said that like 26th, 1.5 lakhs he is going to pay him, and next
Next month, 11th.
12th of April, 1.5 lakh. Petitioner is present before the court. He is undertaking to make the payment on 26th and 12th of already agreed. Yes, Your Lordship.
March.
Yes, sir.
12th.
Not 10th, 12th. 12th of
12th of-
April. April. 26th.
Yes, ma'am. Okay.
Please, Your. 26th. No, 25th is holiday, 26th working.
26th payment.
Order of externment, my lord, from Shimoga district to, yes, my lord. From Shimoga district to Kalburgi. Yes. Page number 7 is the, my lord, impugnment order. My lord, as per my lord, he is not convicted, my lord, in any case. The main, there are only 4 cases are mentioned, my lord, as per the order. That is, my lord, under section, my lord, 87 of the KP Act. My lord, 87, my lord, is just, my lord, gaming in the, my lord, public place. And the only one case, my lord, in serial number 4, in page number 8, my lord. No, my lord, no, my lord. And only one IPC offense, my lord, in mentioned, my lord, I produced the order sheet in page number 12. That is, in that, my lord, he is accused number 9. 87 KP Act, my lord, in page number 7. 87 KP Act.
Act
Yes.
and,
It is mentioned in the order sheet itself, improved order itself.
need to take. That's another case, 143, 147 is also involved in 353. 143, 147, 353, 332.
Serial number 4 ಅಲ್ಲಿ, page number 12 I produced the order sheet.
143, 147, 353, 332.
IPC ಅದೇ ಒಂದು ಕೇಸ್ ಇದೆ ಅದರಲ್ಲಿ
Last is threatening to the public. ಇದೆ ಒಂದಿದೆ 332 is obstructing the general public's 107. KP Act ಅಲ್ಲಿ ಇನ್ನೊಂದು ಇದೆ ಸುಮ್ಮನೆ 353.
Milord is doing some business, Milord.
According to his, he is a rowdy sheeter. According to the commissioner, he is a rowdy sheeter. He is a rowdy sheeter. Lordship kindly page number 152 minute. ಇದು ಇದೆಯಲ್ಲ ಸುಮ್ಮನೆ 143, 147, 353, 332 and 426. 143, 140, 332.
Page number 12, Milord. The order sheet I produced, in that, Milord, he is accused number 9. Pramod. Yes.
Pramod. Charge
sheet. ಇಲ್ಲ sir.
Please.
Yes. Yes. I produce. Next week I'll produce.
Please.
Crime number.
Investigation is complete.
Vinod Nagara Police Station. Vinod Nagara Police Station.
Shimoga. CC number 28/22. 22.
Please. Intimator maybe. Yes. Please.
Okay, petition. So Domestic Violence Act. Granting of the interim order by the court. Seven, 2017 is the date of. ಹೌದು 4,000 ಮೀಟರ್ ಸೆಷನ್ ಕೋರ್ಟ್. ಹೌದು. Kindly see the order sheet, page 27. Page 27, 27. 27/12/2022 ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಆಯ್ತು. ಅಲ್ಲಿಗೆ ವೆಯ್ಟ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಸ್ವಲ್ಪ. ಅದನ್ನ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ತಾರೆ 4/1/23ಗೆ. ಹೌದು, ಅಡ್ವಾನ್ಸ್ ಮಾಡಿಬಿಟ್ಟು ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಡ್ತಾರೆ. ದಿಸ್ ಈಸ್ ರಾಂಗ್ ಅಂತ ನನ್ನ ಪ್ರಶ್ನೆ. ಹೌದು. We should have hold an enquiry. We should have waited for service of the summons.
Sir, the one domestic violence act, there is no enquiries required, my lord. Matter may be remanded for.
ಈಗ ಅಪಿಯರ್ ಆಗಿದ್ದೀವಿ. ಈಗ ಅಪಿಯರ್ ಆಗಿದ್ರೆ NBW ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ. ನಮ್ಮ FLW ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ. ಕೊಡ್ರಿ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಹಾಕಿದೀವಿ. FLW ಮಾಡ್ತಾರೆ. ಕರೆಕ್ಟ್. ಇದು ದಿಸ್ ಇಸ್ ನನ್ನ ಜೊತೆಲಿ ಇದ್ದಿದ್ದು ಓನ್ಲಿ ಫಾರ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ 15 days. 15 ದಿವಸ. ಪ್ಲೀಸ್ ಏನ್ ಮಾಡಕ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಜಾಸ್ತಿ ಮಾಡಿರ ಅಷ್ಟೇ. ಜಾಸ್ತಿ ಮಾಡಿದ್ರೆ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಕರೆಕ್ಟು. 4/1 ಅಡ್ವಾನ್ಸ್ ಮಾಡಿಸ್ಬಿಟ್ಟು 4/1 ಅಪ್ಲಿಕೇಶನ್. ಹೌದು, 4/1 ಅಪ್ಲಿಕೇಶನ್ ಆಗಿ ಅವತ್ತೇ ಆರ್ಡರ್ ಆಗುತ್ತೆ. ಮೈನ್ ಪಿಟಿಷನ್ ಮೇಲೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಯ್ತು. ಹೌದು,
ಅಪ್ಲಿಕೇಶನ್
ಅವತ್ತೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅವತ್ತೇ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿ ಅವತ್ತೇ ಎಂಟ್ರಿ ಮಾಡ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಏನಿಲ್ಲ. ಅದಕ್ಕೆ ನೆಸೆಸರಿ ಯಾಕೆ ತಪ್ಪು ಅಂತ ಹೇಳಿದೆ ಅಂದ್ರೆ, ದೇರ್ ಆರ್ ಪ್ರೀವಿಯಸ್ ಪ್ರೊಸೀಡಿಂಗ್. ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ Marriage was 7/12/2017. Divorce petition was filed. She appeared before the court. Mediation was referred to. Mediation has been filed. Next day went to the police station, 498 petition haki. Avatte domestic violence. This is how the proceedings have been taken place. She appeared before the MC court. And the mediation has been filed. Then 26/12/2022, 498 a complaint ಕೊಡ್ತಾರೆ. Next day domestic violence. ನೋಡಿ ಹೆಂಗಿದೆ chronological events.
Domestic violence is filed for maintenance, madam. Actually.
ಹೌದು. And crime number. Judgment of this court, 2006 Criminal Law Journal 1970. When once the notice has been ordered, it is the bounden duty of the court to record the evidence and grant the interim maintenance. There is no question of interim maintenance ex parte. Paragraph 21. 21. ಈಗ ನಮ್ಮದ್ರಲ್ಲಿ even it is still worse. Paragraph 25 ಹೇಳ್ತಾರೆ ನೋಡಿ. Petition therefore allowed. Impugned order is set aside. Appellate court ಅಲ್ಲಿ 125 proceedings ಅಂತ ಡೀಲ್ ಮಾಡ್ತಾರೆ. ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಅಂತ ಡೀಲ್ ಮಾಡಲ್ಲ. ಪ್ಯಾರಾ 16, ಪ್ಯಾರಾ 6. ಪ್ಯಾರಾ 6 ನೋಡಿ, ಪೇಜ್ 16 ಅದು.
For the petition. That's all.
For R7, my lord.
Lordship.
Also appear for respondent number 1, 2, and 5.
Appearing for respondent 3, 4, and 6.
Yes, my lord. Appearing for R7. Yes, ma'am. My lords, morning we had sought for adjournment, my lords. Respondent number 1, 2, and 5. My lords, senior is unwell, my lords. Senior is unwell, my lords. Actually, we are the ones who had moved the memo. Anand Muttali, my lords. Anand Muttali, my lords.
My lords, in this matter, my lords. I don't have no objection for their adjournment.
State is also, state is responsibility. R8. R8. R8.
Please. Please,
Yes.
Much of this.
grateful, ma'am.
This matter is connected along with 1195 of 2023. That is admitted. I am for the complainant wife before the trial. Criminal RP 1195/2023, wherein the husband has challenged the order of the appeal. Its compensation amount of 15 lakhs has been awarded, along with 5 lakhs towards the jewelry which is held by the husband. That is, so that was challenged by the lords, the husband, as well as the wife, the complainant. 2 appeals were filed. No, my lords, this is by the wife complainant, my lords, challenging the quantum of the compensation awarded. ಅವ್ರದ್ದು admit ಆಗಿದೆ. Please, my lord, same order. My lord, so far as the interim order which was granted by this court, my lords, the same is not complied by the accused. My lords, the order dated, my lords, ಫೈನಲ್ ಹಿಯರಿಂಗ್, ಬಟ್ ಅದಕ್ಕೆ ಮುಂಚೆ 7.5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕಾಗಿತ್ತು. ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಿಂದ ತಗೊಂಡೋಗ್ಬಿಟ್ಟು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ 20% ಅಲ್ಲ 50% ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನಾವು 4.5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ. ಸೊ ಅದಕ್ಕೋಸ್ಕರ 2.5 ಲಕ್ಷ ಕಟ್ಬಿಟ್ರೆ ನಮ್ದು ಡೆಪಾಸಿಟ್ ಮುಗ್ದೋಯ್ತು ಅಂತ ಆರ್ಡರ್ ಅಲ್ಲಿ 50% ದಿ ಎಂಟೈರ್ ಕಾಂಪನ್ಸೇಷನ್ ಇಲ್ಲ ಅದು ಎಲ್ಲೂ ಇಲ್ಲ. ದಿ ಆರ್ಡರ್ ಓನ್ಲಿ ಸೇಸ್ 50%. ಹೌದು. Like
For the petition, this is the matter 138. So there was a Lokadarat order and we have paid out of 15 lakhs, we have paid 9 lakhs already. And they have filed execution also for the same amount. Same amount they have filed execution also. Awesome. So but they have taken both FLW and NBW and also execution. We have paid almost, that is out of 15 lakhs, 9 lakhs we have paid. And only 6 lakhs is left, my lord. How's it? Because we have paid last, before the sum court, as per the order of the sum court, we have paid 6 lakhs.
At page 42, my lord. 42 of the in book, my lord. 42, where the trial court records the award passed by the Lok Adalat, my lord. 40 in page 42, my lord. The complaint and the accused are present, counsel for the, this is on 28/5/2018, my lord. Order sheet dated is on 28/1/2018, my lord.
ಹೌದು.
Yeah. This was supposed to be paid on 28/5/2018, my lord.
We are ready to pay that
And-
6
and-
lakhs balance, we are ready to pay, my lord.
And my lord, the respondent is also aged about 80 years, my lord. And this is exactly the case which has been decided by the coordination bench of this court, my lord.
So some problem because he's also aged over 65 years.
80 years,
We are ready to
respondent
pay
is
it.
80 years, my lord.
Please, brace, my lord.
Yes, my lord.
They have filed execution also. my
My lord, in fact, he was absconding with all, respondent is aged about 80 years, my lord. This entire money is required for medical expenses, my lord. 80 years old and. Yes, my lord.
Some, within certain time, we'll deposit the balance amount, my lord.
ಆಮೇಲೆ ಮತ್ತೆ abscond ಆಗ್ತಾರೆ. ಮತ್ತೆ pay ಮಾಡಲ್ಲ.
Within, entire amount we are ready to pay. 6 lakhs within 3 months we'll pay.
No, my lord. In fact, all this money is required for the
He's
medical.
65 years, he is. We could not pay earlier because.
ಜನವರಿಯಲ್ಲಿ 3 months time ಕೇಳಿದ್ರು ಸರ್ ಅವರು. ಅವಾಗ ಅಂದ್ರೆ
Yes, sir.
ಮಾಡಿ issue ಮಾಡಿದ್ರು ಸರ್. ಜನವರಿಯಲ್ಲಿ ಕೇಳಿದ್ರು.
My lord, they have not paid any money.
As per the order of the sum court, we have paid 6 lakhs, my lord.
No, this is December 2023, my lord.
Before the trial court, we paid 3 lakhs. Once we offered 1 lakh, that is there, my lord. That is there, my lord. I'll take your lordship to the.
2011-2023, my lord.
In fact,
2011-2023, they have paid 3 lakh rupees, my lord. They did not pay a single rupee, my lord.
King paid 73, my lord.
ಅರೆಸ್ಟ್ ಮಾಡಿದಾಗ ಸರ್.
King
No,
paid
not
73, my
in
lord.
On the January of 2024, my lord, the accused appeared he has been arrested, produced before the court, and he has undertaken to pay within 3 months' time, my lord, in January. Now the counsel is asked 24, my lord, 24 January. And now counsel is asking for another 3 months, my lord. All this money is required for medical expenses, my lord. He is 80-year-old. And actually the check amount was 20 lakh rupees, my lord. Based on his undertaking to pay within 1 month's time.
Well, that's what I am not denying, my lord. I am ready to pay, my lord. ಅದಕ್ಕೆ ಒಂದು ಸ್ವಲ್ಪ reasonable because he is also 65 years. ಅವ್ರ ತಾಯಿ admit ಆಗಿದ್ದಾರೆ, that's what. There's some reasonable time to be granted.
My submission, my lord, on the similar.
They have filed both execution and also. At the most, they could have filed a revision, that is, execution petition before the civil court.
To set aside the order passed by FLW and.
I am denying, not denying, my lord. That's what. Correct, my lord, that is there.
Issuing FLW and. Please, yeah.
The ring page 10, my lord, prayer.
ಇಲ್ಲಿದೆ. 6/1/2024, my lord.
Please, other sir, 3 lakh.
So balance is only 6 lakhs, my lord. Was not well and he is also ageable. No, to show his bona fide, he has deposited 6 lakhs.
2018.
No, when he was arrested, he has paid 2 lakhs, and when he has offered 1 lakh, the magistrate has refused the amount, my lord. I am not denying that amount, my lord. Because of some unavoidable circumstances, I could not pay.
What?
Some time may be given, sir. I'll pay the entire amount and
What? One.
Consent only, you wanted to pay the amount of meeting. How before then
because as he has filed both
One
exhibits, he
submission,
cannot claim the both the amount here, my lord.
One
At least he has to go for effect.
in January, he has undertaken to pay within 3 months time. January 2024. There is no, it is not mentioned. It is not been referred in the order sheet, my lord. But he has only undertaken before the trial court that within 3 months time. Order copy is there, so but otherly, he has not. It has not been recorded, my lord. This undertaking is not been recorded.
So ink page, your lordship may kindly see. He was arrested on, that is
2011,
2011, my lord. Ink page 47, my lord. Yes, ma'am. He was arrested on the same day. He has paid about 2 lakhs, my lord.
3 lakhs payment. That is only after 5 years of 6 years of time, my lord. My lord, one submission, my lord.
And once he wanted to.
He was arrested on 2011, 2023, my lord.
It is ink page 47, my lord.
Okay, sir, arrest ಆಗಿದ್ದು ನಾವು
One occasion, I wanted to pay 1 lakh, my lord. And the complainant also refused, and court also did not accept rupees 1 lakh, my lord. That ink page 50, my lord. Peruse the order sheet. The predecessor in the office issued NBW FLW against accused on 13/2, and on the 2011, the accused was secured and produced with the court. On that day, the accused was undertaken to pay rupees 3 lakhs. Accordingly, on 2011, the accused has furnished a DD so and so for 3 lakhs. Thereafter, matter was posted for today for payment of remand. Today, the accused counsel has ready to pay rupees 1 lakh. However, the complaint declined to receive the said amount as per the terms of the compromise.
One submission, my lord.
Swami? ಅದೇ ರಿವಿಷನ್ 15 is ಓದಿ ಸ್ವಾಮಿಗ.
Three lakhs.
ಅಲ್ಲ 1 lakh rupees ನಾವು ಕೊಡಕ್ಕೆ ಅಲ್ಲ 1 lakh rupees ಕೊಡಕ್ಕೆ ರೆಡಿ ಇದೀವಿ ಸ್ವಾಮಿ ಅವತ್ತು. Remaining I could not. I was.
But what? One submission, my lord. The petitioner is always looking around for the senior citizens. Take the money. There are so many cases are pending against him, my lord.
That is not his
Yes.
relevant, it is not relevant for him
My
to,
lord,
says he, let him restrict to his case, my lord.
My lord, please, my
Why
lord, please,
he's-
my lord. Yeah, he was supposed to pay 20 lakh rupees, my lord, and the local
I'll pay
Adalat
my-
was compromised for.
I'll pay within 1 month, my lord. Let there be order, my lord. I'll ready to pay 1 lakh rupees, my lord. Please, my lord. Well, I'm ready to pay deposit rupees 6 lakhs. Balance 6 lakhs association.
Another 6 lakh rupees is pending, my lord. 6 lakh rupees is pending for the trial court, my lord.
1 month time
Lord,
association.
in fact, this 6 lakh, whatever the money is required, he's 80 years old, my lord.
Allah, we are ready to pay 6 lakhs rupees.
He
1
never,
month.
the court has said, my lord, he's not a law abiding citizen.
We have paid, my lord, as per the directions of the Assam
My
code, we have paid
no.
6 lakhs, my lord.
My lord, my submission is, my lord, whatever this court deems to fit. Yes, 10 days, my lord. No, we did not consent it, my lord. No, they saw it, but it was not consented, my lord. My submission, my lord, another week, 10 days time could be the reasonable, my lord. Because this, whatever the money is been paid, it will be paid to taking, sir. Like release money. And
Please,
one submission, my lord. The petitioner has deposited 6 lakh rupees. A direction may be given to the trial court to release that. I filed an application for the trial court. Direction may be given to the trial. Allah, 6 lakh rupees is already pending before the trial court. Yes, my lord. Akide, my lord. I'll trial court mundide. Allah,
He has to file there only.
One direction. No, in fact, what trial? My submission, my submission, my lord. Any application is filed, may be released, my lord. In fact, he's 80 years old, my lord.
Endly 2 weeks grant time of producing the order sheet. Last occasion argument opportunity ಕೊಟ್ಟಿಲ್ಲ ಅಂತೇಳಿ order sheet produce ಮಾಡಿ ಅಂತೇಳಿ I am not getting order sheet. I have filed a application. I am trial court advocate ನಾನಲ್ಲ ಸುಮ್ಮನೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ get it. 2 weeks.
Where on behalf of the petitioner, this is a 138 matter, 138 proceedings matter minutes. The petition has been convicted both by the trial court as well as the first appellate court. The check amount is for the amount of 2 lakh rupees. Along with the compensation imposing 4 lakhs ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. Double the amount ಮಾಡಿದ್ದಾರೆ. I have spoken to the party and my instruction is that he's ready to pay the entire check amount anta. The dispute between both the parties arising out of a chit fund business. So what he says is, I have paid certain amount in cash which the complainant did not acknowledge in the proceedings at least. So therefore, he said, he's ready to pay the entire check amount within a span of 3 weeks, my lord. Well, I just made a submission on those lines, my lord, irrespective of what my merits are.
Lord, before the first applied court, my lord, the accused was directed to deposit 20% of the this thing amount, convicted amount, my lord. Even he has not deposited that also before the trial. Allu, no, my lord. He has not. No, my lord. For the first time it has. Yes, my lord. No amount has been deposited, my lord.
Well, I am ready to deposit the money.
You obtained the stay of the conviction order, and the first applied court had directed him to pay 20% amount within 30 days. No such deposit has been made even before the first applied court, my lord. That is forthcoming in the appellate court's order at internal page number 6, my lord. Para number 7, your lordship may kindly see. After filing of this appeal, para number 7, my lord, of the first appellate court or judgment, my lord. The court suspended the execution of the order of sentence passed by the trial court subject to deposit of 20% of the compensation amount awarded by the trial court within 30 days from the date of the order. So he was supposed to pay at least 80,000 rupees before the first appellate court, my lord.
What my
Even as
instructions
per
are,
this order, my lord.
I asked my colleague who appears in the before the trial court as a. But yes, I do understand. But what he informed me was they have deposited before the trial court. But I would stand subjected to correction, minutes, because
No, my lord.
the first appellate court has observed in the order saying that I have not deposited. I should bow down to it.
Yes, my lord.
I'm ready to deposit the total check amount, my lords. I'll deposit the check amount, whatever is there. Sure. 2022, my lords.
22, my lord.
2019 is a check amount.
And for the remaining amount of 2 lakhs rupees, my lord, this check was issued, my lord. Yes, my lord. Lord, he has lost on.
Within 4 weeks, I'll do it, my lords. Without any miss.
Within 2 weeks, my lord, kindly, my lord. From 2019, he has been waiting, my lord.
It's 3 weeks, my lords. I will instruct the parties, my lords. Within 3 weeks, I'll do it.
No, my lord. I will talk to my complaint. Yes, he's making submission. Yes, ma'am.
Much obliged.
And 2 lakhs to be deposited before this honorable court, my lord. Let it be deposited here only, my lord. Yes, my lord.
On or before 4th of April, I'll deposit, my lords. On or before 4th of April, I'll deposit. 3 weeks, my lords, yes. Obliged, my lords, deeply
Grateful.
obliged.
Petition in this case, my lord. My lords, 130 of next, my lords. Check amount is of 18 lakhs, my lords. Convicted is for 20 lakhs. Yes, please, my lords. Are ready to pay 50% of the fine amount. 50% of the fine amount, my lords, including the trial court deposit, my lords. My lords, we had handed over the check to the other person, my lords. That's what the defense evidence we have uttered, my lords. Including the trial court deposit, my lords. Please, my lords. Grateful, my lords.
Appeal for petitioner, my lords. With the leave of the court, may I make submission, my lords? On last occasion, my lords has directed me to place an FSL report, my lords. Please, my lords, which I have filed, my lords, on, please, my lords. On 7th March, my lords. My lords, in a criminal petition 10598 of. Please, my lords. My lords, kindly see the page number 3, my lords. Serial number 1, my lords, which says. Please, my lords.
Please. Please. Please, my lord. Please, please, my lord. 21 gram illam. That is not there. Where's the FSL report? Please. Please, my lord. How's my lord? 21, 40 and 3 grams. Please. That's not. That
With regard to Amsterdam. That's with regard to Amsterdam.
that, my lord, if you lordship may, we don't copy ilva. Blood, that is passed on. No, my lord, she has filed a, with a memo.
On 7th March.
No. Madam, ಅದು memo file ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ. No, ಅದು ಕೊಡಿ. Lord, Lord, they have sent only 1 gram, 1.27 grams, my lord. That is what is sent to FSL. The rest, my lord, they should have done it. Illa, my lord, otherwise. They should have.
It's true. It's, my lord, if you're, ಹೌದು.
Weighing 40 grams. Weighing 3 grams. The concept of
Lord, if your lordship may kindly come to the last para, my lord, result of examination. FSL. Hello, we have filed it on 7th March. Please, please, my lord. If your lordship may kindly look at it, result of examination. ಅದು
S1.1 to S1.9. Our surplus has been detected in exhibit of data. Now we report ಕೊಡ್ಬೇಕಾದ್ರೆ first is ಏನ್ consider is.
That's true, my lord. That's true, my lord. That is that.
Page number 1 is S1.4, S1.6 something. Other ಪ್ರಕಾರ Abatement have been detected. There is a 1.27 grams. These are 21 grams.
Lord, if your lordship may kindly see, my lord, MDA has not been detected in exhibit 1 to 19.
21 grams they are not sending to the FSL. 21 grams of APMC.
That is not there, my lord. That, please. That, my lord, 21 grams, that is not forthcoming in the. Okay, yeah, please.
21 grams is
That is not there. That is not there.
otherwise you are paid at the game in filing the tax sheet instead of commercial quantity, he made it as, okay? To get your
Please, please.
like that.
Please, my lord, please, my lord. I'll keep him present, my lord. I'll keep him present before the court. Please, my lord.
I want to be present before the
21st. First. Great. Please.
ಪಾರ್ಟಿ ಸಿಗ್ತಾ ಇಲ್ಲತ್ತೆ ಸ್ವಾಮಿ. ಚೆಕ್ ಅಮೌಂಟ್ ನಾವು ಪಾರ್ಟಿ ಸಿಗ್ತಾ ಇಲ್ಲ. ಇಲ್ಲ ನಾನು ಅವರು ಪ್ರಾಮಾಣಿಕವಾಗಿ ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಫೋನ್ ನಂಬರ್ ಏನೋ ಸಿಗ್ತಾ ಇಲ್ಲಂತೆ.
ನಾವು ರೆಡಿ ಇದೀವಿ.
ನಾನು
ಅದನ್ನೇ ಕೇಳಿದೆ, ಏನಾರ
ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ನಮ್ದೇನಿಲ್ಲ.
ಅಲ್ಲ ಕೇಳಿದೆ, ಅದಕ್ಕೆ ಏನಾರ ಇದಾರ ಸತ್ತೋಗಿದಾರ ಅಂತಲೂ ನಾನು ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾಟ್ ಫಾರ್ ಇದು, ಯಾಕಂದ್ರೆ he was absent before the first appellate court also. ಅದನ್ನೇ ಕೇಳಿದೆ. ಅವರು ರಿವಿಷನ್ ಪಿಟಿಷನರ್ ಬೆಂಗಳೂರಲ್ಲಿ ಇದಾರೆ, ಅವ್ರ ಫ್ರೆಂಡ್ ಇದ್ ಮಾಡಿ ನಾನೇ ಪರ್ಸನಲಿ ಮಾತಾಡಿದೆ ಅವ್ರಿಗೆ. ಅವರು ಇದ್ರು ಅಂತ ಹೇಳಿದ್ರು. ಇವಾಗ ಅದಕ್ಕೆ ಕೇಳಿದೆ, ಇವಾಗ ಇದಾರ ಅಂತ ಕೇಳ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು. ಹೌದು, ನಾನೊಂದು ಅಟೆಂಡ್ ಮಾಡಿಸ್ತೀನಿ.
ಈಗ ಬೇಲೆಬಲ್ ವಾರಂಟ್ ಮಾಡಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಯಾರ ಕರ್ಕೊಂಡು
ಅಲ್ಲ ಅವ್ರಿಗೆ ನಾನು ಅವರು ದೇ ಆರ್ ಅಲೈವ್ ಆರ್ ಅದು ಕೇಳ್ತೀನಿ, ಯಾಕೆಂದ್ರೆ ಆ ಫಸ್ಟ್ ಅಪ್ಲೈಡ್ ಕೋರ್ಟಲ್ಲಿ ಆಬ್ಸೆಂಟ್, ಈ ವಾಸ್ ನಾಟ್ ಕಂಟೆಸ್ಟ್. ಪ್ಲೀಸ್ ಪ್ಲೀಸ್. ನೀಟ್ ಒಂದು
ಅಲ್ಲ ಸಿಕ್ಕಿದ್ರೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ನಂಬರ್ ಎಲ್ಲ ನಮ್ಗೆ ಈಸಿ ಆಗುತ್ತೆ ಅವ್ನು ಕರ್ಕೊಬರಕ್ಕೆ.
ಇನ್ನೊಂದು ಅಲ್ಲ ನಾನು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಊರಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ, ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಕೇಳ್ತೀನಿ ಅವ್ರು ಬೇರೆಯವ್ರನ್ನ. ಇನ್ನೊಂದು ಅಲ್ಲ 28ಗೆ 28ಗೆ ಹಾಂ 28ಗೆ ಅಲ್ಲ ಆಗಲಿ ಸ್ವಲ್ಪ, ಯಾಕಂದ್ರೆ ನಾನು ಹೋದಾಗಲೂ ಸ್ವಲ್ಪ ವಿಚಾರಿಸ್ತೀನಿ. ಎಲ್ಲ ನಾನು ಊರಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ, ಹೇಗಿದ್ರು ಅಲ್ಲಿ ವಿಚಾರಿಸ್ತೀನಿ.
Your Lordship, last application, your Lordship. ಇಲ್ಲ, ಇದು ಲಾಸ್ಟ್ your Lordship will direct me to secure the documents pertaining to the wound certificate. wound certificate ತಗೋಬೇಕು, wound certificate ತರಿಸಿ. ಅಲ್ಲ ವೆಹಿಕಲ್ ಅಲ್ಲ, ಅಸಾಲ್ಟ್ ಕೇಸ್, ಅಸಾಲ್ಟ್ wound certificate ತಗೋಬೇಕು ಹೇಳಿದ್ರಿ, ಪ್ರಾಸಿಕ್ಯೂಟರ್ಗೆ ಹೇಳಿದ್ರಿ.
ಇದರಲ್ಲಿ I was submitting that there was one more counter case. I secured that it was tried by the other judge, but it was tried by the same judge. Same judge. ಹೌದು ಏನಿಲ್ಲ ಅದೇ, ಬಟ್ ಹೌದು ಏನ್ ಮಾಡಕ್ಕಿಲ್ಲ. ಹೌದು ಅಲ್ಲ ಆನ್ ಮೆರಿಟ್ ಇದೆ. ಮೆರಿಟ್ ಅಲ್ಲಿ ಆಕ್ಚುಲಿ there is no particularly overt act has been alleged against particular accused. Particular accused ಗೆ overt act has not been alleged. Actually, omnibus allegation against all wound certificate of 326 ಗೆ ಮಾಡಿದ್ದಾರೆ. ಹೌದು, ಬಟ್ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ ಒಬ್ಬನಿಗೆ, ಮೆಟಟಾರ್ಸಲ್ ಬೋನ್, 4th and 5th metatarsal bones. But that allegation is only against accused number 2 ಗೆ ಆಗುತ್ತೆ. 1 and 3, accused number 4 is died, no more. Accused number 1 and 2 ಗೆ ಏನು ಇಲ್ಲ actually, there is no ನಾನು 1 and 3 ಹೌದು, 4 is no more.
1 to 3, 1 and 3.
Yes, 1 to 3.
1 to 3.
1 to 3. But our material prakala Yashwant Kote, that's one. All the.
All the.
1-3 against there is no material actually. Even the evidences. One is that there was a civil dispute between the parties that is admitted fact by both the parties, even the accused. And the trial court has only totally gone again to convict these accused with that they were digging a well in a government land, and the complainants herein, the injured herein, who have asked them, why are you digging the well in the government land, which is a disputed land, over which there is a case, voice suit was pending. And the suit was between the parties for almost 15 to 20 years. They were fighting for the, on that ground, the trial court convicts actually. In fact, the complainants themselves or the aggressors they have visited the spot wherein the person acquittal ಆಗಿದ್ದಾರೆ, ಅವರಿಗೆ acquittal ಮಾಡಿದ್ದಾರೆ, ಅದರಲ್ಲಿ acquittal ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ಬಟ್ so far as accused number 1 and 3 ಗೆ ಏನೇ ಇಲ್ಲ, only assaulted with the hands ಅಂತ ಇದೆ, ಬಟ್ still assaulted with the hands ಅವರು ಅಷ್ಟೇ ಇದೆ ಅಲ್ಲ. ಹೌದು, ಬಟ್ accused number 3 was not even present. ಅಲ್ಲ, accused number 3 was not even present actually. ಅಂದ್ರೆ she was sitting inside the house. ಆಗ ಬೊಬ್ಬೆ ಕೇಳಿ ಅವಳು ಕೂಡ ಬರ್ತಾಳೆ. Then she was also been assaulted by the ಇಲ್ಲಿ ಯಾವ್ದು ಇನ್ನೊಂದ್ರಲ್ಲಿ acquittal ಆಗಿರುವ accused. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನು actually 1 and 3 against ಏನಿಲ್ಲ, even in the evidence also. Only accused number 3 ಒಂದು, ಬಟ್ ಅವ್ರ against ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಏನು ಹೇಳಿಲ್ಲ. ಒಂದ್ ಕಡೆ ಇದ್ ಮಾಡ್ತಾರೆ, one accused one is Pushpa. Pushpa
4. Injury number one is simple and injury number two is grievation. Support the case.
ಅಲ್ಲ ಅದು ಒಂದೇ ಬಟ್ ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಇಂಜುರಿ ಆಗಿದೆ ಬಟ್ ಅಲ್ಲ ಹೌದು ವಿ ಆರ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ಬಿಕಾಸ್ ಹೌದು ಇವನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಗಿವನ್ ಎ ಫೈಂಡಿಂಗ್ ಆಕ್ಚುಲಿ ಅಲ್ಲ ಈಗ ನಾವು ಓನ್ಲಿ ಅವರಿಗೆ ಇಂಜುರಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಮಾತ್ರ ವಿ ಹ್ಯಾವ್ ಬಿನ್ ಕನ್ವಿಕ್ಟೆಡ್ ಅದರ್ವೈಸ್ ದಿ ಪರ್ಸನ್ ಹೂ ವೇರ್ ಎಂಗೇಜ್ಡ್ ಬೈ ಅಸ್ ವೇರ್ ಡೂಯಿಂಗ್ ದಿ ವರ್ಕ್ ದೇರ್ when these accused these petition appellants were there, the complainants themselves came there. We also filed a complaint. Our complaint was registered. ಅಲ್ಲ ಅದು ಒಂದೇ ಬಟ್ ಹೂ ಹ್ಯಾಸ್ ಅಸಾಲ್ಟೆಡ್ ಅಂತ ಏನಲ್ಲ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ A2 ಒಬ್ರು ಹೇಳ್ತಾರೆ ಬಟ್ ನಾಟ್ ಆಲ್ ದಿ ವಿಟ್ನೆಸಸ್ ಡೋಂಟ್ ಸೇ ದಟ್ ದಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಆರ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳೋದಿಲ್ಲ. ಅವರು 2ಗೆ ಹೇಳ್ತಾರೆ A2ಗೆ ಮಾತ್ರ ಹೇಳ್ತಾರೆ.
Exhibit P1 indicates that all the accused are assaulted.
ಆಲ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಬಟ್ ಎಲ್ಲಿ ಯಾರಿಗೆ ಅಂತ ಹೇಳಲಿಲ್ಲ.
Tomorrow ಇಲ್ಲ ರಿಕ್ವೆಸ್ಟ್ ಪ್ಲೀಸ್ ಆಯ್ತು ಮಾಡ್ತೀನಿ ಪ್ಲೀಸ್.
Serial number 56, madam.
42, madam. Based on which time? Others will get informed.
I am here.
$51 million. 51 I applied for the certificate ಇದು ಎವಿಡೆನ್ಸ್ ಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ದೆ ಅದು ಸರಿ ಇದಾರೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಇದಾರೆ 27th ಗೆ ಖಂಡಿತ ಹೌದು ಅದ್ರಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡಿದ್ದೆ ಇದು ಸಿಕ್ಕಿಲ್ಲ ನಾನು ಇವಾಗ್ಲೂ ಹೋಗ್ತಾ ಟ್ರೈ ಮಾಡಿದೆ 27th 27th
56, my lord. My lord, 56, in this matter, my lord, the trial court record has not yet Rajesh. ಇಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಇರ್ಬೇಕು ಸರ್, ಅಡ್ವೊಕೇಟ್ ಸ್ವಾಮಿ ಇವರು ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ ಇದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಇನ್ನೂ ರಿಸೀವ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ದಟ್ಸ್ ವೈ ಐ ಆಮ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್. My lord, immediate after receipt of the trial court record, it will be. ನಂದೇನಿಲ್ಲ ಸರ್ ಮತ್ತೆ ಬಂದ್ರೆ ಎಸ್ ಮೇಡಮ್ ಎಸ್ ಮೇಡಮ್ 20 ಎಸ್ ಮೇಡಮ್
Serial number 55, my lord. I am for the petitioner in this matter. 55, my lord. I need a 2 weeks time in this matter. I have already informed the other side. Other side inform ಮಾಡಿದ್ದೀನಿ sir. ಮಾಡಿದ್ದೀನಿ sir. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ 50% we have already deposited. ಇಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಸ್ವಾಮಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಹೌದು ಸ್ವಾಮಿ much obliged.
My lord, serial number 40 minutes. 40 minutes. 40. My lords, ಇದರಲ್ಲಿ on the last occasion, my lords, ನಾನು document produce ಮಾಡ್ತೀನಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದೆ. My lords, the petitioner has applied, my lords, she has not opened. ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರ್ ಸೈಡ್ ಯಾರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ. ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ಸರ್ವ್ಡ್ ಬಟ್ ನಾಟ್ ರೆಪ್ರೆಸೆಂಟೆಡ್. ಹೌದು my lords, ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ. ನಾನೇನು ಪ್ಲೀಸ್ my lords. My lords, myself Bimbadar, my lords. ನಾನೇ ಪೆಟಿಷನರ್ ಸ್ವಾಮಿ. ಅದರ ಆಪೋನೆಂಟ್ ಯಾರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ. ಸೊ my lords, ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಅಪಿಯರ್ ಆಗಿರಲಿಲ್ಲ. ಸೊ my lords, ಇಲ್ಲ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಯಾರು ಅಪಿಯರ್ ಆಗಿ ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನು ಆಫ್ಟರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ my lords ಇರಲಿಲ್ಲ. ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ my lord. Please, my lord.
Serial number 50, my lord. 50, 50. ಇದರೊಳಗೆ I am for the yes. ಅದರೊಳಗೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 2 ಮ್ಯಾಟರ್ ಇದೆ. There are 2 matters. ಅದರೊಳಗೆ TCR ಬರಬೇಕಿತ್ತು. ಅವೈಟೆಡ್ TCR ಅವೈಟೆಡ್ ಅಂತ ಇದೆ. ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ ಅಂತಂದ್ರೂ TCR ಬಂದಿಲ್ಲ.
My lord,
I have some inconvenience in the afternoon. Could it be taken up some other?
interim order may kindly please. See, serial number 40 minutes.
Could it? My Bangalore this one. Bangalore. Tuesday or Wednesday afternoon something.
ನೋಡ್ಬೇಕು
Please. Tuesday or Wednesday. ಆಗ್ಬೋದು.
Other side is the I am intimated. Okay. 2 weeks.
Sixteen ಮತ್ತು 16.1 RSA 815, 819. Commissioner 25(3) na.
ಮೇಡಮ್ 43 ಇದೆಯಲ್ಲ.
230 ಗೆ 41.
ಮೇಡಮ್ ಅದ್ರ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. From 13 records. Madam.
ಮೇಡಮ್ 43 ಇದೆಯಲ್ವಾ?
13 records. 563. Committee ಬಂದು.
Serial number 48. ಏನಾಗಿಲ್ಲ.
Serial number 14, 48.
ಈ ತರ ಬಂತ ಇದ್ರಲ್ಲಿ
Check 1, 2, 3. Check 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Hmm. Hmm. Also. Hmm.
39.
ಹಾ. ಹಾ? ನೋಡ್ಲಿ ಬಿಡಿ ಅವ್ರು ನೋಡ್ಕೊಂಡೆ ಹೇಳಿ. ನೀವು ಓದಿ ಆಮೇಲೆ ನೋಡೋಣ. ಆಯ್ತು. ಈಗ ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಯಾವ್ದು ಪಾಸ್ ತಗೊಳ್ತೀವಿ ಬೆಳಗಿಂದ. ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಇಲ್ಲ ಈಗ ಅವ್ರದೇ ಪಾಸ್ ಓವರಾ?
ಪಾಸ್ ಓವರ್ ಇಲ್ಲ, ನಮ್ದು ಕಂಟಿನ್ಯೂಷನ್ 130ಗೆ ಆಯ್ತು ಕಂಟಿನ್ಯೂ.
ಅದರಿಂದ ಹಿಂದೆ ಯಾವ್ದು ಪಾಸ್ ಓವರ್ಸ್ ಇಲ್ಲೋ ಮೇಡಮ್? ಆಯ್ತು, ನೀವು ನೋಡ್ಬೇಕ ಈಗ ಒಂದ್ 10 ನಿಮಿಷ ನೋಡೋಣ, ಅವ್ರದ್ದೇನೋ ನೋಡ್ತಾರಂತೆ.
ಆಯ್ತು, ಅಲ್ಲಿ ತನಕ ನಾನು ಹೇಳ್ತೇನೆ.
ಆಯ್ತು ಹೇಳಿ.
ಇದರಲ್ಲಿ ಅವರು ಹೇಳೋದು PW1 says only that she is.
ಎವಿಡೆನ್ಸ್ ಕೊಡಿ ಮೇಡಮ್. ಅವ್ರ ಹತ್ರ ಇದೆಯಾ? ಬೇಡ ಬಿಡಿ, ಬನ್ನಿ ನೋಡ ಹೇಳಿ. ಏನ್ PW1 ಯಾರು?
PW2 ಸಂಧ್ಯಾ. She says she was assaulted.
Actually, who is the injured with the wooden club? Pushpa. PW4.
PW4.
What she says, PW4 evidence.
She was assaulted by A2 ಅಂತ ಹೇಳ್ತಾರೆ. A2 assaulted.
A2 assaulted with club ಅಂತ.
Reaper ಅದು. And so far as ಇನ್ನೊಬ್ಳು ಸಂಧ್ಯಾ ಅಂತ ಹೇಳುವವರಿಗೆ A1 and A3 has assaulted Reaper ಅಂತ ಹೇಳ್ತಾರೆ.
With reap.
ಹೌದು, reap. But there is no fracture for her.
No fracture ಆಯ್ತು, ಬಟ್ reap ಸೀಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ, ಸೀಸ್ ಆಗಿದೆ. MO1 ಅಂತ ಹೇಳಿ ಒಂದೇ ಇದಾಗಿದೆ. ಬಟ್ even no other eyewitnesses say that they have assaulted her.
ಮತ್ತೆ ಯಾರು ಹೇಳೋದು ಅದನ್ನ?
Only
1 and 3 assaulted.
PW4 ಗೆ ಇಂಜುರಿ ಆಗಿತ್ತು, she is the fracture ಆಗಿತ್ತು. But she was taken to hospital on the particular day. There was no fracture found. Exhibit D1 ಅಂತ ಒಂದು ಮಾರ್ಕ್ ಆಗುತ್ತೆ. Wherein it was said that in the previous day she had come for
case sheet of Enlock Hospital.
ಹೌದು. She had come with the same this one. There was
first she was taken to which hospital?
Same ಅಲ್ಲೇ
Enlock only.
ಅಲ್ಲಿ ಏನು ಆಗಿಲ್ಲ ಅಂತ ಬರ್ತಾರೆ.
ಅಡ್ಮಿಟ್ ಆಗೋದಿಲ್ವಾ?
ಏನೂ ಇಲ್ಲ.
ಔಟ್ ಪೇಷಂಟ್.
ಹೌದು. ನೆಕ್ಸ್ಟ್ ಡೇ ಮತ್ತೆ she complains ಅಂತ ಹೋಗಿ ಬಿಟ್ಟು ಇದು ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ ಅಂತ ನೆಕ್ಸ್ಟ್ ಡೇ ಇಲ್ಲ. As per exhibit D1.
ಅಲ್ಲ, ಬಟ್ ರಿಪೀಸ್ ಏನು ಅಂತ ಹೇಳ್ತಾರ? ರಿಪೀಸ್ ಸೀಸ್ ಆಗಿಲ್ವಲ್ಲ?
Exhibit P5 ಪ್ರಕಾರ wound certificate. That is dated 7/3/2007. 7/3/2007. Incident had taken place on 25/7/2007.
On the very next day when they went to hospital, whether again she has admitted?
No, there was no
admission.
Yes. And ಅಷ್ಟೇ, ಮತ್ತೆ A2 assaulted ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ as per exhibit D1, the injury cannot be believed. It was caused because of the assault by A2. And there are no injuries for
only metatarsal fracture. That's all.
That's
ಏನ್ ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
even aged 58 now. That she might have
ಪನಿಷ್ಮೆಂಟ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಈಗ
1, 2, 3 are sentenced to pay fine of ₹5,000 each for the offence punishment 326 reduced section 34 of IPC. In default of payment, fine. 1 year ಕೊಟ್ಟಿದ್ದಾರಾ?
ಹೌದು. And even it's a case and counter case. Civil dispute was pending, and the complainants have themselves have gone to the place of incident. And the trial court has only stated that who is the more aggressor anta. It comes to a conclusion that both are aggressors. But who is more aggressor anta ಹೇಳಿಬಿಟ್ಟು ನಮ್ಮನ್ನು conviction ಮಾಡಿದ್ದಾರೆ. Only because that we have been digging a well in the disputed area. But we have not assaulted them.
ಸೆಂಟೆನ್ಸ್ ಮಾಡಿರೋದು only in one offense ಗೆ. 326 ಮಾತ್ರ. ಬಾಕಿದೆಲ್ಲ ಫೈನ್.
ಹೌದು, ಬಾಕಿದೆಲ್ಲ ಫೈನ್ ಮಾಡಿ
ಅಲ್ವಾ?
ಇನ್ ಡಿಫಾಲ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಹೌದು, ಇನ್ ಡಿಫಾಲ್ಟ್ ಉಳಿದವರಿಗೆ
ಮಿನಿಮಮ್ ಸೆಂಟೆನ್ಸ್ ಇರ್ಬೇಕ್ರಿ ಈ ಅಫೆನ್ಸಸ್ಗೆಲ್ಲ.
ಅಲ್ಲ, ಬಟ್ 326 ಮಾಡಿದ್ರೆ ಮಿನಿಮಮ್ ಕೊಡ್ಬೇಕು.
324 ಗೆ ಮಿನಿಮಮ್ ಸೆಂಟೆನ್ಸ್ ಇಲ್ವಾ? ಡಿಫಾಲ್ಟ್ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? already sentenced, hereby sentenced to pay fine of rupees 1,000 each for the offence punishment of 324. 323, 324.
504 ಎಲ್ಲದಕ್ಕೂ ಒಂದೇ ರೀತಿ ಮಾಡಿ. Concurrently running. No punishment so far as 324 ಗೆ ಮಾಡಿಲ್ಲ.
ಸೆಂಟೆನ್ಸ್ 3 ವರ್ಷ ಇದೆ 324 ಗೆ ಮೇ ಎಕ್ಸ್ಟೆಂಡ್ ಟು 3 years ಇದೆ ಬಟ್ ಸೆಂಟೆನ್ಸ್ ಮಾಡ್ಲೇಬೇಕು ಆರ್ ವಿತ್ ಫೈನ್ ಆರ್ ವಿತ್ ಬೋತ್ ವಿತ್ ಫೈನ್ ಆರ್ ವಿತ್ ಬೋತ್. ಇವ್ರು ಬರೀ ಫೈನ್ ಮಾತ್ರ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಬಟ್ 326 ಗೆ ಎಲ್ರಿಗೂ ಮಾಡಿದ್ದಾರೆ. ದೋ ದೇ ಆರ್ ನಾಟ್
326 ಯಾವಾಗಲೂ ಮಾಡ್ಲೇಬೇಕು. ಇಟ್ಸ್ ಎ ಇದು ಕಾಮನ್ ಇಂಟೆನ್ಷನ್, ಶೇರಿಂಗ್ ಆಫ್ ಕಾಮನ್ ಇಂಟೆನ್ಷನ್. ಬಟ್ 1 year ಮಾಡಿದ್ ಜಾಸ್ತಿ ಇದೆ. ಅದೇನಾದ್ರು ಮಿನಿಮಮ್ ಸೆಂಟೆನ್ಸ್ ಇದೆಯಾ 324 ಪನಿಷ್ಡ್ ವಿತ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಫಾರ್ ಲೈಫ್ ಆರ್ ವಿತ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಆಫ್ ಐದರ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಫಾರ್ ಟರ್ಮ್ ವಿಚ್ ಮೇ ಎಕ್ಸ್ಟೆಂಡ್ ಟು 10 years and shall also be liable to fine. Nature of injuries?
ಅದೇ metatarsal bone ಗೆ so far as ಅವರಿಗೆ injury 4th and 5th metatarsal bone.
Because when person has sustained fracture injury and such injury might have swelling around the fracture site at least for a period of 2 weeks. Therefore, evidence of DW not helpful to the case of accused to discard the evidence of prosecution witness. DW ನಾವೊಂದು ವಿಚಾರಣೆ ಆಗಿದೆಯಾ?
ಹೌದು, ಡಾಕ್ಟರ್ ಬಂದು ವಿಚಾರಣೆ ಮಾಡಿದ್ದಾರೆ. They have not issued the wound certificate. ಅವರು ಹೇಳ್ತಾರೆ ನಾವು we have not done.
DW1
DW1 ಹೌದು.
DW1 ಯಾರು accused?
ಡಾಕ್ಟರ್. ಡಾಕ್ಟರ್.
ಡಿಫೆನ್ಸ್ ವಿಟ್ನೆಸ್ ಯಾರು?
ಡಾಕ್ಟರ್. ಹೌದು.
ಡಾಕ್ಟರ್ನ
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ it's a case where she was
pathologist.
She was previously injured ಅಂತ ಹೇಳಿ.
There is fracture of 2 metacarpal bones. That is, one is on ring finger and another one is on the little finger of left hand.
It was ಡಾಕ್ಟರ್ ಹೇಳ್ತಾರೆ ಅದು old unhealable fracture ಅಂತ ಹೇಳಿದೆ. Because it was there.
DW1 and 2 ಯಾರು ಇದ್ದಾರೆ? Accused examine ಆಗಿದಾನಾ?
ಇಲ್ಲ, ಬರೀ ಡಾಕ್ಟರ್ಸ್ ಅನ್ನು ಮಾತ್ರ.
ಇಬ್ರು
ಡಾಕ್ಟರ್ಸ್.
ಎವಿಡೆನ್ಸ್ ಆಫ್ DW1 and 2 ಇಬ್ರು ಡಾಕ್ಟರ್ಸ್.
ಇಬ್ರು ಡಾಕ್ಟರ್ಸ್.
ಅದನ್ನ ಯಾರು ಡಿಫೆನ್ಸ್ ಎಕ್ಸಾಮಿನ್?
ಸೊ ಅವರು ಹೇಳ್ತಾರೆ that wound certificate was not issued or signed by them and it was issued by the PG students ಅಂತ.
ನೀವು ಯಾರು wound certificate ಯಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಿರಿ? ಡಾಕ್ಟರ್ ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ?
PW 6 and 7.
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವರು?
PW 6 and 7.
6 and 7. Who are the medical officers? Their evidence is quite corroborating with evidence of victim. PW 6.
Dr. Vikram Majare.
He has examined injured. That is PW1 who came to hospital with history of assault by Lata, Yashwant, Nissan, Soumya. But ಇಲ್ಲಿ 5 ಜನ ಇದ್ದಾರೆ accused. Further he has deposed.
ಬಿಟ್ಟಿದ್ದಾರೆ against Nishant.
Is deleted from the charge sheet.
Say he is a student actually.
ಹೌದಾ?
They repeatedly in
examination he has noticed
assaulted. But he was not in the charge sheet. But however, no alteration ಏನು ಮಾಡಿಲ್ಲ, accused ಅನ್ನು ಮಾಡಿಲ್ಲ.
ಇದೇನ್ರಿ PW4 has taken treatment as inpatient for about 11 days.
11 days.
ಇಲ್ಲ ಇಲ್ಲ ಅಂತೀರಿ ನೀವು.
ಅಲ್ಲ, ಅದು
Exhibit
later-
P14
later
ಪ್ರಕಾರ?
ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇ ದಲ್ಲಿ ಮಾಡಿಲ್ಲ. ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇ ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಎಕ್ಸಿಬಿಟ್ D1 my lord.
P14 ಹೇಳಿ. Initial stage PW6 has admitted if a person falls on a ground.
ಎಕ್ಸಿಬಿಟ್ P5 wound certificate ಅದರಲ್ಲಿ ಹೇಳುದಿಲ್ಲ ಇವರು. ಎಕ್ಸಿಬಿಟ್ D1 that is the wound certificate of very same.
Exhibit P12 to 14 ಕೊಡಿ ಮೇಡಮ್. P12 injured Sandhya.
ಸಂಧ್ಯಾನಿಗೆ there is no fracture at all. ಅವಳಿಗೆ ಫ್ರಾಕ್ಚರ್ ಇಲ್ಲ.
Fracture ಇಲ್ಲ, tenderness ಇದೆ. Tenderness over the left forearm. Tenderness over the left middle finger. 3 ಜನ injured ಇದಾರ್ರಿ. Simple in nature.
ಎಲ್ಲ simple in nature. Fracture is only for that Pushpa who is the PW4. He was not hospitalized. Yellow.
Injured ಯಾರು ಸಂಧ್ಯಾ ಅಂಡ?
And Sandhya.
Sandhya?
Sandhyaನಿಗೆ no fracture.
ಸಂಧ್ಯಾ?
There is no fracture as per wound certificate ಮತ್ತೆ ಎಲ್ಲ. Pushpa was the
X-ray
injured and-
of fourth and carpal left hand swelling seen. One is simple, injury number 6, 2 is grievous in nature. Fracture of metatarpal.
PW2 Sapna also injured. PW2 Sapna. It's also injured. Okay, number 2 also assaulted PW2 Sapna.
Sandhya, Swapna,
Swapna.
and Pushpa.
Pushpa.
Kindly see exhibit D1 also. Page number 125 ಅಲ್ಲಿ.
Page number 125.
125.
ಅದೇನು?
ಅದು that Pushpa's wound certificate actually. That the doctor says that.
125 medical legal case.
ಅದು it is on the date.
Inpatient case ಇಟ್ರಿ ಅದು. Now you are relying upon exhibit D1 of Pushpa.
ಹೌದು.
She is inpatient. Date of admission 12/50. ಬಿಡುಗಡೆಯ ದಿನಾಂಕ 7/3. ಬಟ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದು ಯಾವತ್ತು? 25th February. 11 days.
ಅಲ್ಲ ಬಟ್ ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಡೇ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Pain and swelling left hand. One day
Bottom of
following.
the- The patient came with
Assault
the-
by
ಹೌದು.
her neighbor.
ಹೌದು. Previous day she had come to the hospital, there was no fracture ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ಪೋರ್ಷನ್ ಅಲ್ಲಿ. Today she
Patient was apparently all right. One day back.
ಹೌದು.
When she said to have been assaulted by her neighbor. Following that, she developed severe pain in the left hand associated with progenic swelling over the, ಅದೇ ಊದ್ಕೊಂಡಾಗ ಗೊತ್ತಾಗಿದೆ ಅಂತ. She also pain in the.
But that might have been caused even for any
There is
other
no
reason, also not only
history suggest incident ಆಗಿದೆ ಯಾವತ್ತು?
25/7 ಗೆ.
ಅವತ್ತೇನಾ? ಅವತ್ತೇ ಅಡ್ಮಿಟ್ ಆಗಿದಾರಲ್ರಿ?
ಅಲ್ಲ ಅವತ್ತು ಬಂದಿಲ್ಲ, ಅವ್ರು ಪ್ರೀವಿಯಸ್ ಡೇನೆ ಹೋಗಿದ್ದಾರೆ ಅಂತೆ. ಸೇಮ್ she claims as per that report my lord, she was suffered injury on the previous day itself, not on the date of incident.
Incident ಯಾವತ್ತು?
25/7.
25/7 ಅಲ್ಲ, 25 February.
Sorry. 25/2.
25/2.
25/2.
On that day itself, she went to the hospital.
ಹೌದು, but she says in the hospital, she was suffered injury on the previous day, she visited the hospital ಅಂತ ಹೇಳ್ತಾರೆ on the ಇದ್ರಲ್ಲಿ. So that injury was caused on the previous day, not on the date of incident. So It is a falsehood that as claimed by the accused, it is false case ಅಂತ ಹೇಳಿ. As per that, wound certificate or in certificate exhibit D1, she visited the hospital on the previous day, saying that she suffered some injury. But there was no injury which was or fracture.
Injury ಇದೆ ರೀ ಅಲ್ಲಿ ಇದೆ
ಅಲ್ಲ, fracture
ಬರ್ದಿದ್ದಾರೆ
was not
ಸ್ವೆಲ್ಲಿಂಗ್
found
ಅಂತ
on that.
ಪೇನ್ ಅಂಡ್ ಸ್ವೆಲ್ಲಿಂಗ್.
ಅಲ್ಲ, fracture was not found. Next day ಹೋಗ್ತಾರೆ. Next
ಪುಷ್ಪ
day
ಅಲ್ವಾ?
ಹೌದು.
ಪುಷ್ಪ ಒಂದೇ ಸೆಕೆಂಡ್.
PW4.
25/2/2017 at 12:40 PM she went to hospital 10 AM.
ಹೌದು.
10 AM ಆಗ್ಲೇ ಹೋಗಿದ್ದಾಳಲ್ಲ?
ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದೆ 11 AM. ಇದು ಗಲಾಟೆ ಆಗಿರೋದು 11 AM on 25/7.
9:10 ಅಲ್ಲೇನ್ರಿ?
25 to
ಇಲ್ಲ.
ಎಷ್ಟು ಗಂಟೆಗೆ ಆಗಿರೋದು?
11 AM ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಪ್ರಕಾರ 11 AM.
9:5 PM ಅಂತೇನೋ ಇದೆ ನೋಡ್ರಿ. 25/2/2007 at
ಇಲ್ಲಿ ನಾರಾಯಣಿ PW1 says
ಆಯ್ತು ನಿಮ್ಮ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಪ್ರಕಾರ ಎಷ್ಟು ಗಂಟೆಗೆ
ಅವ್ರ ಪ್ರಕಾರ 11 ಗಂಟೆಗೆ. ಅವ್ರ ಪ್ರಕಾರ 11 ಗಂಟೆ.
alleged assault on 25/2/2007 at 11 AM by Lata so and so. ಎಷ್ಟು ಗಂಟೆಗೆ ರೀ ಇದು?
11 AM ಅಂತ ಇದೆ. ಇಲ್ಲಿ 11 AM ಅಂತ ಇದೆ.
11 AM.
11 AM. ಇವರು ಸಂಧ್ಯಾ ಹೋಗಿರೋದು ರಾತ್ರಿ 9:05 ಇದೆಯಲ್ಲ. Seen on 25/2/2007 at 9:05 PM. Examination started ಅಂತಿದೆ. First one exhibit P12 ಅಲ್ಲಿ. Second one also 9:15 PM. ಸಂಧ್ಯಾ ಅಂತಲೇ ಇದು. Alleged assault by so and so at 11 AM.
But it is a falsehood that claimed by the complainants ಅಂತ ಯಾಕಂದ್ರೆ exhibit D1 ಪ್ರಕಾರ he had visited the hospital on the previous day on the same injury. Before the date of incident itself.
Pushpa, husband of so and so, president of so and so, Mangalore. At 12:40 PM ರೀ ಅದು.
ಅಲ್ಲ ಹೌದು, ಬಟ್ ಡಾಕ್ಟರ್ ಅಲ್ಲಿ ಬರೀತಾರೆ she went to the hospital saying that yesterday I came to the hospital, ಅಲ್ಲಿ ನನಗೆ for the same injury I consulted the doctor, but there was she was all right. On the next day she comes, the next day is on 25th, so that she went to the hospital on the 25th.
ಅದು admitted on 25/2/2007, discharged on 7/3.
But that injury was there on the previous day also.
ಏನ್ರಿ ಕೇಸ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಾಕಿದೆ ಎಕ್ಸಿಬಿಟ್ D1 ಅಲ್ಲಿ. ಇಲ್ಲಿ ಆಲ್ಸೋ wound ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಏನೋ 25/2/2007 10 AM ಅಂತ ಮಾಡ್ತಾರೆ, 10:40 PM ಹೊಡೆದಾಕಿದ್ದಾರೆ. First scene, examination started at 25/2/2007. Injuries, burn poisoning and place, date of time of accident or incident. 25/2/10 ಗಂಟೆಗೆ ಆಗಿದೆಯಲ್ರಿ? wound ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ನೋಡಿ, ಎಕ್ಸಿಬಿಟ್ P14 ಹೋಗಿ ಇನ್ಸಿಡೆಂಟ್ 10 AM ಅಂತ ತೋರಿಸ್ತಾರೆ ಇದ್ರಲ್ಲಿ. ಎಕ್ಸಿಬಿಟ್ P14 ಅಲ್ಲಿ 10 AM ಅಂತಿದೆ. ಹಿಂದಿನ ದಿವಸ 25/2/2007. ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು 11 ಗಂಟೆಗೆ.
25
ಬಟ್ ಫಸ್ಟ್ ಸೀನ್ ವಿಟ್ನೆಸ್ 25/2/7 12:40 PM ಅಂತಿದೆ ರಾತ್ರಿ. ಮತ್ತೆ ಮಿಡ್ಲಲ್ಲಿ ಹೋಗಿರೋದು. 12:40 PM ಹೆಂಗಾಗುತ್ತ್ರಿ? ಅದೇ 12 ಗಂಟೆಲಿ ಹೋಗಿರೋದು ಬೆಳಗ್ಗೆ.
by mistake ಏನು?
ಆಮೇಲೆ ಇವನ್ ಎಕ್ಸಿಬಿಟ್ D1 ಆಲ್ಸೋ ಪುಷ್ಪ ದಾಖಲಾದ ದಿನಾಂಕ ಅಡ್ಮಿಷನ್ at 12:50 PM. ಅವತ್ತೇ ಅದನ್ನ ಇನ್ಸಿಡೆಂಟ್ ಆದ ದಿವಸ. ಬಿಡುಗಡೆ ಆದ ದಿನಾಂಕ 7/3. ಪ್ರಸ್ತುತ ರೋಗದ ಚರಿತ್ರೆ. ದ ಪೇಷಂಟ್ ವಾಸ್ apparent by all right
on the previous day.
One day back when she is said to have been assaulted by her neighbor. ಹಿಸ್ಟ್ರಿ ಬರ್ತಿರೋದು ಅವತ್ತು ಅಡ್ಮಿಷನ್ ಆಗಿರೋದು 12:50. ಅದು ಹಿಂದಿನ ದಿವಸ ಒಂದು ಗಲಾಟೆ ಆಗಿತ್ತಾ?
As for the prosecution on 25 to 2007, 25 to 2007, quarrel has been settled.
Huh?
25 to 2007, quarrel has been settled.
Incident was taken place at 11 AM. 25 to 11.
7.
Other
11 AM.
11 AM.
According to the prosecution.
But our one certificate ಹೋಗಿ ನೋಡಿದ್ರಾ 10 AM ಅಂತಿದೆ ಇನ್ಸಿಡೆಂಟ್ at 10 AM. (25 to 2007) 10 AM ಅಂತಿದೆ. ಅದು ಹೊಡೆದಾಕ್ ಬರ್ತಿದ್ದಾರೆ 12:14 ಅದನ್ನ. ಆಕ್ಚುಲಿ ಹೋಗಿರೋ 12:40 ಅವತ್ತು ಮಧ್ಯಾಹ್ನ. But why history is in terms of exhibit D1? Patient was apparently all right 1 day back when she said to have been assaulted ಅಂತಿದೆ. ಹೋಗಿ ಡಾಕ್ಟರ್ಸ್ ಏನ್ ಹೇಳ್ತಾರೆ DW 1 and 2? ಅವ್ರೇನು
ಅದು ಅಂದ್ರೆ ಇಟ್ ವಾಸ್ ಅನ್ಹೀಲೇಬಲ್ ಫ್ರಾಕ್ಚರ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಂದ್ರೆ ಫ್ರಾಕ್ಚರ್ ವಾಸ್
ಕಾಣುವ ಮೂಳೆ ಮುರಿತ ಹೀಲ್ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ, ಅದು ವಯಸ್ಸು ಹೇಳು ಬರುವುದಿಲ್ಲ. ಇದು ನೋಡುತ್ತಿದ್ದೇನೆ. ಯಾವಾಗ ತೆಗ್ದಿರೋದು ಇದು ಎಕ್ಸ್ರೇ?
ಎಕ್ಸ್ರೇ ವಾಸ್ ಆನ್ 7
ಎಲುಬು ಮುರಿದಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ.
7/3 ಗೆ ತೆಗೆದಿದ್ದು ಎಕ್ಸ್ರೇ.
ಕಾಣುವ ಮೂಳೆ ಮುರಿತ ನಾನ್ ಹೀಲ್ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ, ಅದರ ವಯಸ್ಸು ಹೇಳಲು ಬರುವುದಿಲ್ಲ.
Medical officer ಹೇಳಿದ್ರು 12:45 noon ಅಂತ. 25 to 2007 at about 12:45 noon. Medical officer stated that.
ನೀವೇನು PW4 ಎಕ್ಸಾಮಿನ್ ಮಾಡುವಾಗ ಏನು ಕ್ವಶನ್ ಕೇಳಿಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ. ಎಕ್ಸಿಬಿಟ್ D1 ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟೇ ಮಾಡಿಲ್ಲ ಇಲ್ವೇ? Injured evidence, medical evidence, all are corroborative.
Corroborating, my lord, that injured witnesses, the evidences are contradictory to each other. Right?
Where is the contradiction?
Contradiction says PW one says that accused number 2.
PW one is not an injured ray.
ಹೌದು. But she is the
PW2 ಸ್ವಪ್ನ ನನ್ನ ಚಿಕ್ಕಮ್ಮನ ಮಗಳು ಅಂತ ಹೇಳ್ತಾಳೆ ಅಷ್ಟೇ.
ಹೌದು. PW2 and PW4 are the injured witnesses.
PW1 ಯಾರ್ರಿ? ನಾರಾಯಣ. ನಾರಾಯಣಿ.
ಹೌದು.
He is not an injured witness.
Complainant, she is the complainant. She visited the spot at the time of incident. She claims to be the eyewitness. ಅವಳು ಬರೀ ಒಬ್ಬನೇ ಮೇಲೆ ಮಾತ್ರ ಹೇಳ್ತಾಳೆ. Accused number 2 ಮೇಲೆ ಮಾತ್ರ. And accused number 1 and 2 have assaulted with the hand.
ಮುಂದಿರುವ ಸದರಿ 2 ರೀಪನ್ನು ನೋಡಿದೆ, ಅವುಗಳನ್ನು ಎಮೋ 1ಕ್ಕೆ ಗುರುಸಲಾಯಿತು.
Injury itself has been caused to that is
injured witness ಯಾರು? ಸ್ವಪ್ನ.
ಸ್ವಪ್ನ ಮತ್ತೆ ಸ್ವಪ್ನನಿಗೆ ಏನು
2, 3 and 4. Swapna, Sandhya.
Sandhya and Pushpa are the injured witnesses. Pushpa, the injury is she suffered the fracture, but it is doubtful because of exhibit D1. And she also says that she was suffered a fracture even prior to the.
ಸ್ವಪ್ನಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ wound ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ವಲ್ರಿ? ಬಟ್ ಅಲ್ಲಿ 2 ಹೆಸರು ಎಕ್ಸಿಬಿಟ್ P12 P13
ಅದೇ ಇದೆ. ಏನಿಲ್ಲ ಎಕ್ಸಿಬಿಟ್ ಸಂಧ್ಯಾ ಒಂದು ಎಕ್ಸಿಬಿಟ್ P12.
P13 ಯಾರ್ದು?
P13
ಸಂಧ್ಯಾ.
ಸಂಧ್ಯಾ ಅಂತ ಇದೆ, ಅದಕ್ಕೆ ಕೇಳಿದ್ದು.
wound certificate ಸಂಧ್ಯಾ.
12 ಸಂಧ್ಯಾ, 13 ಸಂಧ್ಯಾ,
14 ಪುಷ್ಪ.
ಸ್ವಪ್ನಂದು
ಸಂಧ್ಯಾ.
ಸ್ವಪ್ನಂದು wound ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲಿದೆ?
ಸ್ವಪ್ನದ
ಎಕ್ಸಿಬಿಟ್ P12 wound certificate of PW1 ಅಂತಿದೆ.
It is she was brought by Sandhya ಅಂತ ಹೇಳ್ತಾರೆ. She herself was injured. ಅವಳೇ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. But that is that exhibit P12.
ನಿಶಾಂತ್ ನನ್ನ ಅಕ್ಕನ ಎಡಗೈ ಉಂಗುರ ವಿರಳನ್ನು ತೀರ್ಚಿದ್ದ, ಉಳಿದವರು ನಮಗೆ ಕೈಯಿಂದ ಹೊಡೆದರು ಮತ್ತು ಕಾಲಿನಿಂದ ತುಳಿದರು. ಈ ಬಗ್ಗೆ ನಾವು ಬೊಬ್ಬೆ ಹಾಕಿದಾಗ ನನಗೆ ಹಾಗೂ ಪ್ರಸ 1 ಅವರಿಗೆ 1 ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ರೀಪೀಸ್ ನಿಂದ ಹೊಡೆದರು. ನನಗೆ ನಿಶಾಂತ್ ಎಷ್ಟನೇ ಅಕ್ಯೂಸ್ಡ್?
Not an accused.
Accused again.
ನಾಟ್ ಅನ್ ಅಕ್ಯೂಸ್ಡ್.
Not an accused.
ಮತ್ತೆ ಇಲ್ಲಿ ನಿಶಾಂತ್ ಎಂಬುವರು ಮರದ ರೀಪಿನಿಂದ ನನಗೆ ಹೊಡೆದಿರುತ್ತಾರೆ ಅಂತ PW3 ಹೇಳ್ತಾಳೆ. ಅವ್ನು ಬಿಟ್ಟಿದ್ಕೆ ಏನು ಇದನ್ ಮಾಡಿಲ್ವಾ?
ಏನು ಮಾಡಿಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಏನು ಹಾಕಿಲ್ಲ. ಅಂಡ್ ಈವನ್ ದೇರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ವೈಲ್ ಫೈಲಿಂಗ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅದರಲ್ಲಿ ಏನಿಲ್ಲ, ಈಗ ಬಂದು ಹೇಳ್ತಾ ಇಲ್ಲ. ಅಂದ್ರೆ ದೇ ವಾಂಟೆಡ್ ಹಿಮ್ ಟು ಬಿ ಇಂಪ್ಲಿಕೇಟ್ ಹಿಮ್ ಆಲ್ಸೋ ಸಿನ್ಸ್ ಹಿ ವಾಸ್ ಎ ಸ್ಟೂಡೆಂಟ್.
ಆಲ್ ವಿಟ್ನೆಸಸ್ ಸೇರ್ಸ್ ನಿಶಾಂತ್ ಮತ್ತು 3ನೇ ಆರೋಪಿ ಹಿಡಿದು ಹೊಡೆದರು ಅಂತ. ವೈ ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ 391 ಟು ಮೇಕ್ ಹಿಮ್ ಆಸ್ ಅಕ್ಯೂಸ್ಡ್ ನಿಶಾಂತ್?
ಬಟ್ PW1 ಹೇಳುದು complainant who is the eyewitness. He doesn't say that. Due to animosity and a civil dispute which was going on for 25 years, all these accused have wanted him to be implicated as one of the accused. And even they had filed one more complaint against him on previous. Admittedly, in the complaint itself, they say that there was a civil dispute. Admittedly, in the complaint itself, and even the witnesses say that there was a civil dispute which was going.
ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದಕ್ಕೆ ಆಗಿರೋದು ಇನ್ಸಿಡೆಂಟ್ ಇಲ್ದವರೆಲ್ಲ ಆಗ್ತಾ ಇತ್ತು.
There was a case and counter case between of which the other case has ended up in acquittal. But, so far as this case is concerned also, they had no motive or intention to cause these injuries or cause this one, because they were doing their work at a place and the complainants themselves have gone to the place. Avrelo, they did not go on their own and they have assaulted them. Even the reasoning assigned by the judge in my lord, the trial court at paragraph number 14, 15 and 16, it is quite my lord, based on the evidence, it is highly doubtful as to the statements of each witnesses. And the exhibit P12 and exhibit D1, if it is read together, my lord, which has to be believed. And even the timing is falsely mentioned or wrongly mentioned. It is rightly mentioned, my lord. But incident had occurred, or she visited the hospital at 10 AM and before the incident itself. And admittedly, that was a government land. It is nobody's land. Government land, and these accused have put up a building there.
That's all.
I maybe kindly see that paragraph number 15 and 16, my lord.
That I have read.
Trial court judgment.
Even I underlined also.
Otherwise, it is on the basis of looks not a reasoning that can be given to the evidences given by the witness. Witness will say something and the reasoning is something. Civil dispute is who is more aggressor. There was quarrel. They did not go because we have been doing the work that itself was the aggression. That is what the trial court's finding. What is not the assault or after the incident, not that is not said by the judge. Judge says that we went to the spot. That is an aggression. What is not the complainant came and questioned and assaulted us is not the aggression.
The PW 2 to 4.
PW 2 to 4 are the injured cases. I told him, madam, heard the petitioner counsel and also the counsel appearing for the respondent state. The factual matrix of case of prosecution is that on 25/2/2007 at about 11 AM, accused number 124 while digging well near their house situated near Meenakalia Panchayat office, Panambur, situated within the jurisdiction of Panambur PS. And when CW 1 and 2 came to the said spot, when they made enquiry, ಏನು ಸರಿಯಾಗ್ಲಿಲ್ಲ ಮೇಡಮ್ ಇದು ಮತ್ತೆ ಸೌಂಡ್ ಬರ್ತಾ ಇದೆ ಆವಾಗಿಂದ came to the said spot. When they made enquiry with regard to the erection of well, accused number 124, in furtherance of common intention to commit an offence, picked up quarrel with them, and in the above said transaction, accused number 1 and 2 assaulted CW 1 and 2 with wooden club. Accused number 3 and 4 assaulted with their hands, thus voluntarily caused hurt by means of dangerous weapon. Further allegation is that by hearing hue and cry, CW 3 and 4 came to the said spot. Accused have also assaulted with hands and with wooden club. And on account of the same, CW 4 had sustained grievous injuries. And also abused in a filthy language. The police, based on the complaint of PW1, registered the case and investigated the matter and filed the charge sheet against accused number 1 to 4. The accused persons were secured and they did not admit the charges leveled against him, and hence prosecution relied upon the evidence of PW 1 to 10 and got marked document exhibit P 1 to 15. On the other hand, defense have examined 2 witnesses as DW 1 and 2, that is doctors, and also marked document exhibit D1 case sheet. The trial court, having considered both oral and documentary evidence, and particularly considering the evidence of PW 2 to 4 who are the injured witnesses, and also major witness PW 5 has supported the case of prosecution, and PW 6 and 7 are the doctors. And their evidence also corroborates with regard to examining of the injured persons when they came to hospital. And convicted the accused for all the offences. Being agreed by the said judgment and judgment of conviction and sentence, an appeal is filed in criminal appeal number 79 of 2015. First appellate court, having perused the exhibit P1 and also the evidence of PW 1 to 4, and also considering the exhibit P1 contents, and also considering the evidence of PW 2, PW 3 and 4, and considering the evidence of PW 6, that is wound certificate of exhibit P12 and exhibit P13 and exhibit P14, and having noticed the nature of injuries, has affirmed the judgment of trial court and dismissed the appeal. Being agreed by the concurrent finding of both the courts, present revision petition is filed. The main contention of the counsel appearing for the revision petitioner is that the very complaint itself discloses that petitioners were not the aggressors and they were digging a well near their house. And at that time, CW 1 and 2 went there and questioned the accused itself. And hence it is clear that they are the aggressors and not the petitioners. It is also contended that no explanation is coming forth by the prosecution side to disbelieve the cross-examination or evidence. And both the courts blindly accepted the prosecution version. The evidence not corroborates each other, and on the other hand, counsel would submit that there are contradictions in the evidence of witnesses. The counsel also would vehemently contend that document exhibit D1, a reference is made that though the PW4 admitted to the hospital and there is a reference of previous day or visit and she was all right. And DW1 and 2 evidence also very clear. With regard to the nature of injuries. First off, the counsel also vehemently contend that in the counter case, the injured witnesses were acquitted. And trial court ought to have taken note of the same and committed an error, and particularly counsel brought to notice of this court paragraph number 15, 16, 17 of the trial court order. And so also the discussion made in paragraph number 18 and contend that trial court committed an error. The counsel also would submit that only in paragraph number 25 and 26, having considered the medical evidence, and in paragraph number 28 also discussed the evidence of PW 6 and 7. And comes to the conclusion that no dispute with regard to the incident is concerned, and taken note of only the evidence given by the prosecution witnesses and fails to take note of cross-examination. And answers elicited from the mouth of prosecution witnesses and committed an error. The counsel also vehemently contend that the first appellate court also blindly accepted the case of prosecution. For contra, the counsel appearing for the state would submit that no dispute with regard to the incident is concerned. The same was taken place on at 11 o'clock, and immediately all the injured, that is PW 2 to 4, were taken to the hospital and they were treated by PW 6 and 7. The evidence of PW 2 to 4 eyewitnesses as well as PW 5, who is the major witness also, visited the incident spot. And he supports the case of the prosecution. And PW 6 and 7 evidence is also very clear, and the same has been discussed by the trial court even as well as first appellate court, having taken note of evidence of PW 6 and 7. Discussed in paragraph number 36, 37, 38 and 39. Nature of the injuries are also extracted. And also taken note of particularly exhibit P 12 to 14. And nature of injuries are also fractures of metacarpal bone of left hand, and rightly confirmed the judgment of the trial court, and it doesn't require any interference. Having heard the petitioner, revision petitioner counsel and also the counsel appearing for the respondent, and also taking into note of the factual aspects of the case. And it is also the case of the prosecution that when CW 1 and 2, having noticed when the accused persons are digging, went and questioned the same at that time. An incident was taken place and PW 2 and 3 were subjected to assault. And having heard the screaming sound, when the PW 4 rushed to the spot and she was assaulted with wooden club. The evidence also clearly discloses that the PW 4 had sustained fractures, that is metacarpal bone fracture of left hand. The evidence of PW 6 and 7 also corroborates that they have examined them And no doubt counsel appearing for the revision petitioner brought to notice of this court a reference made in exhibit D1, wherein a reference is made with regard to the previous date is concerned. And but the incident was taken place on 25/2/2007, and the injured persons immediately were taken to the hospital and they took treatment. And PW 6 and 7, who are the medical officers, are also having deposed before the court that both of them have examined PW 1 and 2 at 9 p.m. and PW 1 who came to hospital with history of assault by the accused persons. And injuries are mentioned in exhibit P12. And so also the injuries in respect of other injured PW3, Swapna. And she also given the history of assault and noticed the injury, which is mentioned in exhibit P13. The other witness is PW4 who also sustained injuries, and she went to hospital at 12:45 noon. And having noticed swelling over 4th and 5th metacarpal bone on left hand. X-ray was taken, and the same also confirms that PW4 had sustained fracture of 4th and 5th metacarpal bones on the left hand. First of all, there is no any delay in lodging the complaint. And also it has to be noted that the injured persons, that is PW 2 to 4, immediately rushed to the hospital and they took the treatment. The medical records of exhibit P 12 to 14 also discloses the nature of injuries. The counsel appearing for the petitioner would submit that only an allegation against the accused number 2 that he assaulted the PW4, and about other accused person is concerned only they assaulted with their hands. But on perusal of the evidence of witnesses, it's clear that earlier they assaulted with reaper putty. And when the PW4 rushed to the spot, having heard the screaming sound, and she was also assaulted. And when all of them were there at the spot, and court cannot take individual inflicting of injuries, and when all of them have shared the common intention. And trial court also invoked section 34 of IPC for the offence punishment on section 323, 324, and also section 326, read with section 34 of IPC. The fact that PW4 had sustained the injuries of fractures of metacarpal bone is not in dispute. It is also important to note that that material discloses that case and counter case also registered in another counter case. The victims have acquitted. Having perused all material available on record, I do not find any error committed by the trial court. And trial court and appellate court also taken note of the nature of injuries, and appellate court also in paragraph number 37 to 36 to 39 taken note of evidence of PW 2 to 4 and also the medical evidence exhibit P 12 to 14 to confirm the judgment. Though counsel contend that these petitioners are not the aggressors, and the fact that these petitioners having noticed that when the accused persons were digging, went and questioned the same at that time, assaulted, and all of them have sustained injuries. And when such being the case, when there is a direct evidence as well as medical evidence supports the case of the prosecution, only on minor discrepancy found in exhibit D1, and the same cannot be a ground to disbelieve the case of the prosecution, and the same will not go to the very root of the case of the prosecution, and hence I do not find any error in convicting the accused persons and second persons. However, having noticed all of them have convicted for the offence punishment 323, 324, 326. 504 read with section 34 of IPC. And in respect of other offences is concerned, only fine is imposed and not imposed any sentence in respect to even section 324 read with section 34 of IPC. The only question remains for consideration of this court is concerned. 1 year punishment is imposed to all of them. The council also would contend that when the other accused persons have not inflicted the injury with wooden club. And both the courts committed an error invoking section 326. I have already pointed out that the said contention also cannot be accepted when all of them are together and share their common intention in inflicting the injuries. However, taking into note of simple imprisonment for 1 year, and also the injured was in hospital for a period of 11 days from 25 to 2007 to 7/3/2007 for a period of 11 days. And also the nature of injuries are also only on the metacarpal bone. And hence the imprisonment for 1 year, it appears to be not commensurate with the charges leveled against them. And hence the same requires to be modified. In view of the discussions made above, I pass the following order. Revision petition is allowed in part. And conviction is also confirmed. However, sentence is reduced to 6 months in respect of offence punishable under section 326, read with section 34 of IPC. The sentence in respect of other offences also confirmed.
Two submission. One, maybe sentence already undergone by ಇದು ಅವರನ್ನ ಸೆಟ್ ಆಫ್ ಮಾಡಿಬಿಟ್ಟು
ಇದರ ಒಳಗಡೆ ಇದ್ರಾ?
ಇಲ್ಲ ಸ್ವಲ್ಪ ಇದ್ರು ಅಂತ ಕೂಡ ಅದ್ರಲ್ಲಿ ಎಲ್ಲಿ ಕಾಣಲಿಲ್ಲ, ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಕಾಣಲಿಲ್ಲ.
ಮತ್ತೆ
PO ಆಕ್ಟ್ ಕೆಳಗಡೆ, ಯಾಕಂತ ಹೇಳಿದ್ರೆ 15 ವರ್ಷದ ಹಿಂದೆ ಆಗಿದೆ.
ಸ್ಟೇಷನ್ ಬೇಲ್.
PO ಆಕ್ಟ್
ಸ್ಟೇಷನ್ ಬೇಲ್ ಆಗಿದೆ.
ಸ್ಟೇಷನ್ ಬೇಲ್ ಆಗಿದೆ.
PO ಆಕ್ಟ್ ಕೆಳಗಡೆ ಅಟ್ಲೀಸ್ಟ್ ಲೇಡೀಸ್ ಈಗ ಒಂದು 15 ವರ್ಷ ಆದ್ಮೇಲೆ ಇಬ್ರು ಲೇಡೀಸ್ ಇದ್ದಾರೆ.
ಏನ್ ಮಾಡ್ಬೋದು?
ಒಬ್ಬರಿಗೆ ಮಾತ್ರ ಏನಾದ್ರು ಒಂದು ಮಾಡಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗೆ ಮಾಡಿಬಿಟ್ಟು
ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗೆ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗ್ತದೆ? ಕಾಮನ್ ಇಂಟೆನ್ಷನ್ ಇದ್ದಾಗ
ಓಪನ್ ಟು ದಿ ಜಜ್ಮೆಂಟ್ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ. ಅಲ್ಲ, ಜಜ್ಮೆಂಟ್ ಗೆ ನಾವು ವಿ ಹ್ಯಾವ್ ಟು ಒಬೇ. ಬಟ್ ಒನ್ ಥಿಂಗ್ ಇಸ್ ದಟ್ ದೇ ಆರ್ ದಿ, ಅಂದ್ರೆ ಒಂದು ಫಾಲ್ಸ್ ಕೇಸ್ 2 ಜನ ಇದ್ದದಕ್ಕಾಗಿ ಮೇ ಬಿ ಈವನ್ ಫಾರ್ ಅಗ್ರೆಷನ್ ಆರ್ ಪ್ರೊವೊಕೇಶನ್ ಏನಾದ್ರು ಆಗಿರ್ಬೋದು. ಬಟ್ ಮೇ ಬಿ ಒಂದು PO ಆಕ್ಟ್ ಅಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ ದಟ್ ಲೇಡೀಸ್
ಆಯ್ತರಿ, ಕೇಳಕ್ ಹೋದವ್ರಿಗೆ ಹೊಡೆದ್ಬಿಟ್ರೆ ಈಗ ಹೆಂಗೆ ಅಗ್ರೆಸರ್ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಬರ್ತದೆ.
ಬಟ್ ಅವರಿಗೂ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡುವ ಅವಕಾಶ ಇತ್ತು ಒಂದು ವೇಳೆ.
Even dispute ಇದಾರೆ ಅಂತ ಗೊತ್ತಿದೆ ತಾನೆ, that is admitted fact also. Why
ಅವರಿಗೂ
digging?
ಅಲ್ಲ, ನಾವು ಹೇಳುದು ಕಂಪ್ಲೇಂಟ್ ಒಂದು ಕಂಪ್ಲೇಂಟ್
1 year ಇಂದ ಕಡಿಮೆ ಮಾಡಿದ್ವಿ, ಒಂದು 6 ತಿಂಗಳು ಅಷ್ಟೇ. 326
ಇಬ್ಬರಿಗೆ
326 ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಮೆಟಾಕಾರ್ಪಲ್ ಬೋನ್, ಆ ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ನೋಡ್ಕೊಂಡು ರೆಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ ಅಷ್ಟೇ.
that may be attributed to accused number 2.
Not only 2.
ಅವರಿಗಿಲ್ಲ ಲೇಡೀಸ್ ಅನ್ನೋ ಒಂದು PO ಆಕ್ಟ್ ಕೆಳಗೆ
ಆಯ್ತು, ಅದೆಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡಾಯ್ತು, ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಕೇಳಾಯ್ತು, ಆರ್ಡರ್ ಬರ್ದಾಯ್ತು. ಏನ್ ಹೇಳಿ, ಬೇರೆ ಏನಾರು ಹೇಳೋದಿದ್ರೆ ಹೇಳ್ಬೋದು.
My lord, I am only requesting for the PO act ಕೆಳಗಡೆ that
PO ಆಕ್ಟ್ ಬರೋದಿಲ್ಲ. PO ಆಕ್ಟ್ ಬರೋದಿಲ್ಲ. The council ತಗೊಳ್ಳಿ, ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ತಗೊಳ್ಳಿ, ಕನ್ಕ್ಲೂಷನ್ ಗಿಂತ ಮುಂಚೆ the council would submit that the accused number, petitioner number ಯಾರು
1 and 3
are the ladies. ಹೌದಾ?
ಹೌದೌದು, ಇಬ್ರು ಲೇಡೀಸ್ ಇದ್ದಾರೆ. And ಅದರಿಂದಾಗಿ ಅವರ ಮೇಲೆ 1 and 3
are ladies and court can invoke PO act.
She was at the time that accused number 3 was 20 years.
The accused number 3 was 20 years at the time of the alleged incident. At the time of the incident, ಈಗ alleged ಬರೋದಿಲ್ಲ, confirm ಆದ್ಮೇಲೆ. Incident.
The time of the
And incident was taken place in 2007. And almost 16 years has been elapsed. And PO act can be invoked. Having considered the factual aspects that accused number 2 inflicted injury with wooden club against PW4 and PW4 had sustained previous injuries of fracture. And also considering the longer period and considering the age of petition number 1 and petition number 3 are the woman folk and aged about 20 years and 35 years at the time of. ಅವಾಗ ಇನ್ನೂ ಕಡಿಮೆ ಇರ್ಬೇಕ್ರಿ ಆಗ್ಲೂ ಅಷ್ಟೇನಾ ಇದೆ ನೀವು ರಿವಿಷನ್ ಅಲ್ಲೂ ಅದೇ ಏಜ್ ತೋರಿಸಿದಿರಾ
ಅವಳಿಗೆ ಇನ್ನೂ ಕಡಿಮೆ
ನೀವು ರಿವಿಷನ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಏಜ್ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗ್ತದಲ್ಲ ಕಡಿಮೆ ಹೆಂಗಾಗ್ತದೆ 20ರಿಂದ ಕಡಿಮೆ ಆಗೋದೇ ಇಲ್ಲ ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ
ಹೌದು 20 ಮಾಡಿ
ನೀವು ಆವಾಗ ಎಷ್ಟಿತ್ತು ಅದನ್ನೇ ಹಾಕಿದಿರಿ ಅನ್ಸುತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು ಅದೇ ಹಾಕಿದಿರಿ ಬಿಡಿ 20 years and 35 years and this court has already come to the conclusion that it is for a sharing of common intention and also considering the incident was taken place 16 years ago and the incident was also taken place with regard to the civil dispute between the parties and particularly the land is also the government land and all of them and they are also the neighbors of the victim and hence it is appropriate to invoke PO Act in respect of petition number 1 and 3 having considered their age at the time of the incident full stop operative portion hakkoli the petition number 1 and 3 are released invoking PO Act and the learned magistrate of the trial court has to get the report with regard to any other prior antecedents. And if any similar offense is committed in future, they are not entitled for any benefit of PO Act and Takfurest.
ನಮ್ದೊಂದು objection. ಒಂದು objection.
ಏನ?
PO Act ಗೆ ನಮ್ದು objection.
ನಿಮ್ದು objection ಹೇಳ್ಬೇಕಾ? ಏನ್ objection ಹೇಳಿ?
326 is the non-compoundable offenses. PO Act is
ಅಲ್ಲ
not.
ಹಾಕೊಳ್ಳಿ. The counsel appearing for the state would contend that
PO Act
the 326
is a non-compoundable offense.
compoundable offense.
Hence PO Act is not.
And hence PO Act cannot be applied. ಅಲ್ಲಿ ಒಂದು ಕೆಳಗಡೆ ಒಂದು ರೀಸನ್ಸ್ ತೋರಿಸು. This court already having noticed that the offense under section 326 is invoked in view of the PW4 had sustained the injuries and injuries are also inflicted by the accused number 2 and only invoke the common intention that is under section 34 while invoking the offense under section 326 against the petition number 1 and 3. And hence the very submission of counsel appearing for the state cannot be accepted and taken note of inflicting of injury and also the overt act of the petitioner number 1 and 3 and their and allegation against them is that they have inflicted the injury to the PW 2 and 3 ಅಂತ ಹಾಕ್ಬಿಡ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಮಧ್ಯದಲ್ಲಿ ಸೇರಿಸಿ.
I'm the amicus curiae. Has died.
41 ಯಾರು ಸತ್ತೋಗಿದ್ದಾರೆ?
138 proceedings ಮಾಡಾರ.
ಪಿಟಿಷನರ್ ತೀರ್ಕೊಂಡಿದ್ದಾರಾ?
ರಿಪೋರ್ಟ್ ಬಂದಿದೆ. I'm the amicus curiae.
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಾದ್ರು ಇದೆಯಾ?
ರಿಪೋರ್ಟ್ ಅಂತ ಇದೆ. Now was appointed Millards sir, verify ಆಗಿದೆ. Last date ಅಲ್ಲಿ ರಿಪೋರ್ಟ್
ಇದೆಯಾ?
That is the case.
Offense in 138.
138.
Other side are B Ravishankar ಇಲ್ವಾ?
The case Millards it may not survive.
ಏನ ಡೆಪಾಸಿಟ್ ಇದೆಯಾ ಅಮೌಂಟ್? ನೀವು ಯಾವಾಗ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಆಗಿದೆ ಏನಾದ್ರು ಕೆಲಸ ಮಾಡಿದ್ದೀರಾ ಅಪಾಯಿಂಟ್ ಆದ್ಮೇಲೆ?
ಅಪಾಯಿಂಟ್ ಆದ್ಮೇಲೆ
ಡಿಬೇಟ್ ಆಗ್ತದೆ ಅದಕ್ಕೋಸ್ಕರ ಹಾ ಅಪಾಯಿಂಟ್ ಆಗಿ ಎಷ್ಟು ಹಿಯರಿಂಗ್ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಿ?
Last date I appeared, the last date, that is on 6th. ಇಲ್ಲಿ on sixth I appear.
ಒಂದೇ ಸರಿ ಬಂದಿದ್ದಾರೆ.
ಒಂದೇ ಸರಿ. ಬಂದಾದ್ಮೇಲೆ ಅದು ಗೊತ್ತಾಗಿದೆ. From infrastructure. Unless and until 390 for application of required.
This proceedings is initiated under section 138 of NI Act. And respondent at the instance of the respondent. And order to pay fine of rupees 2,28,000. And the same is challenged in criminal appeal. And in criminal appeal also, the order of the trial court is confirmed and against that a revision is filed. The revision petitioner not pursued the matter and hence this court has appointed amicus curiae. But order dated 6/2/24. And also court has issued the notice to the petitioner. And now report is received from the police that petitioner is no more. And he died on 5/5/2018 itself. And that certificate is also produced along with the report. The counsel appearing for the respondent is absent. In view of the petitioner is passed away immediately after filing of the revision petition in the year 2018. The revision petition abates. And hence revision petition dismissed as abates. The registry is directed to pay an amount of rupees 2,000 to the amicus curiae. ಅಷ್ಟೇ ಒಂದು ಅಪಿಯರೆನ್ಸ್ ಹಾಕಿದೆ. ಸುಮ್ಮನೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಬೇಡ ಅಂತ 2,000 ಕೊಟ್ಟಿದೆ. ವಿನೋದ್ ಪ್ರಸಾದ್ RB ದೇಶಪಾಂಡೆ. ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
The complaint, my lord.
ಯಾರು RB ದೇಶಪಾಂಡೆ.
Correspondent, my lord.
ನಾ ಬಂದ್ರಲ್ಲ.
For the complaint.
RB ದೇಶಪಾಂಡೆ. ಅವ್ರ ಆಫೀಸಾ ಅಥವಾ ಏನು?
ಇಲ್ಲ senior office.
ಆಯ್ತು. ಹಾ ರೆಡಿ ಇದಾರಂತಲ್ಲ ಹೇಳಿ.
For the complaint under SCST Act. B report was filed on the ground.
B report was filed.
B report was.
The B report was closed.
B report was
Accepted.
filed. That was challenged.
That was accepted.
B report rejected.
Rejected and proceeded to continue.
Without any reasons.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
Order is at
number 12.
at page 16. Para 15, para 4 onwards. Thereafter, inquiry was conducted regarding this objection. The B report. First informant gave their sworn statement. She has examined one more witness, namely the witness, where escorted the first informant to page 15, para 4. These are not eyewitness. What she says is, her principal has insulted on 18th in the chamber. On that day, neither she was there in the college, she had applied leave, nor the principal was in the college. He had gone to the mother function. Police have to be in detail inquiry, held that no such incident has happened on the day because both were not in the same.
Here, madam, nothing is discussed in the evidence.
My lordship, but I have filed my objections to the
Only
B
one
report.
para. Trial court while rejecting the B report has to assign the reason.
Please, my lordship, that also has not.
You see here paragraph number 4. The first informant has produced the complaint which has been marked as exhibit P1 and the objection to the B report is marked as exhibit P2.
Please.
In the sworn statement of the first informant, she has reiterated the contents of the complaint. The other witness has supported the first informant. Considering the evidence produced by the first informant, I am of the opinion that B report filed by the investigation cannot be accepted. These are the reasons.
But my lordship, my contention is that, my lord, the petitioner being the principal of the college, she has harassed the
Whatever it
complainant.
may be,
Please,
madam,
my lordship.
I am going
But-
to set aside this order and remand the matter to the trial court. Consider and pass a reasoned order, that's all. Here is
Finding
where-
by the
huh?
police is,
Huh?
finding by the police is both are not in the case,
Both are,
not in the college. This lady has applied leave on 16th.
let the same may be considered by the trial court as well. While rejecting the B report,
Yes.
assign the reason. Here though, only considering
Maybe
marking.
Prima facie, my lord, they could not have happened because that lady had applied leave on 16, 17, 18.
Yes.
College principal was elsewhere.
ಅದನ್ನ ಇಲ್ಲಿ ನಾನು ಅದನ್ನ ಡಿಸ್ಕಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಇಲ್ಲಿ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿಲ್ದೇ ಇರೋದ್ರಿಂದ ನಾನು ಡಿಸ್ಕಸ್ ಮಾಡಕ್ಕಲ್ಲ. ಐ ಕ್ಯಾನ್ ಸೆಟ್ ಅಸೈಡ್ ಅಂಡ್ ರಿಮ್ಯಾಂಡ್ ದಿ ಮ್ಯಾಟರ್ ಟು ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟು ಕನ್ಸಿಡರ್ ದಿ ಮ್ಯಾಟರ್ ಅಫ್ರೆಶ್.
It should not amount to misuse of this law.
Misuse of law ಅಂತ ಏನ್ ಬರೋದಿಲ್ಲ.
Kindly.
ತೊಡಿ ಆಯ್ತು, that's all.
Kindly incident may kindly for
Counsel is very limited.
Understand.
I am going to set aside only on the ground that no reasons are assigned except relying upon the marked document of complaints as well as B report. Not discussed.
Regarding B report.
The sworn statement.
Not a single word is used for why it is bad. Number one.
Counsel, ನಾನು ಈಗ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ರೀಸನ್ ಇಲ್ಲ.
Understand.
Let the court decide.
If
the same.
complainant herself has not said anything regarding B report, can it be accepted? That's what I'm saying.
Exhibit P1 also, except marking, nothing is produced.
B report itself is very clear. May I read my lord?
Counsel, I cannot accept the B report now unless the same is considered by the trial court. Only course open to the court is remand the same to the.
Possibility is there? Remote possibility.
No, counsel, no reasons order has been passed. That's why I am directing the trial court to pass reasoned order ಅಂತ ಬರಿತೀನಿ ಅಷ್ಟೇನೆ. I am not going to take up any.
ಅಲ್ಲ, ನಾನು ಅದನ್ನು ಹೇಳ್ತಾ ಇಲ್ಲ. ನನಗೆ ಇರೋ ಒಂದೇ ಒಂದು subject whatever court says. When this lady applied on leave and principal is elsewhere.
ಸರಿ ರೀ, ಅದನ್ನ ನಾನು ಈಗ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
It is not disputed by the complainant. What difficulty is this?
B report objection ಏನ್ ಹಾಕಿದಾರೆ ಅದನ್ನೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆರ್ಡರ್ ಬರೀಬೇಕಿತ್ತು, ಏನು ಮಾಡಿಲ್ಲ.
Routine ಆಗಿ ನಾನು ಇದ್ದೀನಿ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ.
ಅದನ್ನೇ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. Heard the petitioner counsel and also the counsel appearing for the respondent. In this revision petition challenged the rejection of B report and taking up cognizance and issuance of process against the petitioner's hearing. The records discloses that the police have filed the B report and thereafter the respondent hearing had filed the objections to the B report in terms of exhibit P2. And thereafter, the respondent complainant was also examined before the trial court on 22/6/2016. And also examined one more witness as PW2 on 30/7/2016. The trial court, after the examination of PW1 and 2, proceeded to pass the order of rejection of B report and also taking up cognizance and issuance of process. Having perused the order of the trial court, as rightly pointed out by the counsel appearing to the petitioner, that in paragraph number 4, the trial court only considered the first informant has produced the complaint which has been marked as exhibit P1 and the objection to the B report as marked as exhibit P2. The trial court only mentioned that sworn statement of the first informant has reiterated the contents of the complaint and other witness has supported the first informant. And considering the evidence produced by the first informant, comes to the conclusion that B report filed by the investigating officer cannot be accepted. It is necessary to take cognizance of the offence alleged and accordingly proceed to pass the following order. Having considered the reasoning, except referring document exhibit P1 and P2 and making an omnibus statement that complainant reiterated the contents of the complaint and witness supported the first informant and not discussed anything about the report filed by the police, that is B report, and also the sworn testimony of PW 1 and 2. And only a reference was made,
My
the
lordship, one
complaint and
submission.
B report, and no discussion
My lordship, one
before
submission.
taking the cognizance and rejecting the B report. And the trial court ought to have considered the report of the B report and formulated the opinion whether B report is acceptable or not, and no such reasons are assigned except reference, and hence it is appropriate to
My lordship,
set
one
aside the
submission.
order with a direction to the trial court to pass the considered order looking into the sworn testimony of complainant and also the sworn testimony of PW 2 and also the material of B report, and no such exercise was made by the trial court, and only in 2 lines an order was passed in paragraph number 4. And hence matter requires to be set aside, and order requires to be set aside, and matter may be remitted back to the trial court to consider the matter afresh in view of the observations made by this court. In view of the discussions made above, I pass the following order. Revision petition is allowed, and the impugned order dated 17/2/2017 is set aside. Matter is remitted back to consider the matter afresh in view of the observations made by this court. Heli madam, ಏನು ಹೇಳ್ಬೇಕು?
My lordship, a state has not been made as a party before this court.
State ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. 3(1) RS of the Atrocities Act ಮಾಡಿಲ್ಲ.
Then complaint and private
ಇಲ್ಲ ಇಲ್ಲ
complaint
ಇಲ್ಲ, FIR registered, my lordship, not private complaint.
FIR ಅಥವಾ private
FIR, my
complaint?
lordship.
Even appeal ಅಲ್ಲೂ ಮಾಡೇ ಇಲ್ವಲ್ರಿ? ನಿಮ್ಮನ್ನೇ ಮಾತ್ರ ಮಾಡಿರೋದು.
Since the private.
Appeal ಅಲ್ಲೂ also you have not raised that objection.
Please, my lordship.
Appeal ಅಲ್ಲಿ
Make.
ಇಲ್ವಾ? Appeal ಇಲ್ಲ.
ಇಲ್ಲ, my lordship. Since it's a travel by sessions court, directly the cognizance has been.
ಪೊಲೀಸ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿರೋದಲ್ವಾ ಇದು?
Police.
FIR ಇಲ್ಲಿ.
ಮತ್ತೆ ನೀವು ಪೊಲೀಸ್ನವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ? Division ಅಲ್ಲಿ.
Since private complaint is rejected.
ಪ್ರೈವೇಟ್
No
ಕಂಪ್ಲೇಂಟ್
private
ಅಲ್ರಿ ಇದು?
complaint, it's a FIR.
ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಪೊಲೀಸೇ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿರೋದು.
Madam,
That is why cognizance is also taken and.
My lord, police have given a clean sheet saying.
ಪೊಲೀಸ್ ಕೊಡ್ಲಿ ರೀ, ಬಟ್ ಪೊಲೀಸ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು?
I thought the private complaint and I not made.
ನಾಟ್ ದಿ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಇದು.
ನಾನು.
ಇಲ್ಲ ಇಲ್ಲ, police complaint ಇಲ್ಲ ಇದೆ FIR.
ಕಂಪ್ಲೇಂಟ್ ಇದೆ, FIR ಇದೆ, ಎಲ್ಲ ಇದೆ.
With the court.
anyhow not the speaking order. ನೆಕ್ಸ್ಟ್ ಬರುವಾಗ ಪೊಲೀಸ್ನ ಮಾಡ್ಬೇಕಾತ್ ಇನ್ನೇನಾದ್ರು ಬರೋ ಅವ್ರೇನ ಮತ್ತೆ ಅಗೇನೆಸ್ಟ್ ಅದು. You have to make the state also party. Case was registered at the instance of the police.
Much obliged.
May make with the court permission you will be or there.
Stage.
ಇಲ್ಲೇ ಕೊಟ್ರು ಇಲ್ಲೇ ಹೇಳ್ತೀನಿ.
ಯಾವ್ದು?
State by.
ಇವಾಗ amend ಮಾಡ್ತೀನಿ.
ಈಗೇನ್ ಬೇಕಾಗಿಲ್ಲ, ಇನ್ಯಾಕ್ ಸುಮ್ನೆ ಆಲ್ರೆಡಿ ಆಯ್ತಲ್ಲ, ಓನ್ಲಿ ರೀಸನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ಮತ್ತೇನಾದ್ರು ನಿಮ್ಗೇನ ಮತ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಂಡ್ರೆ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ. ಅಲ್ಲಿವರೆಗೂ ನಿಮ್ಮನ್ನೇನು ಇಯರ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
Respondent. This is a revision petition filed against the order of allowing the DV petition of the petition.
ನೋಡಿ ಮೇಡಮ್, ಏನ್ ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್?
It is the matter the respondent has instituted a petition under the 12 of the DV Act, which has been dismissed by the trial court, against which the respondent has preferred an appeal.
ಏನ್ ಮಾತಾಡೋದಿಲ್ಲ. ಕೌಟುಂಬಿಕ ದೌರ್ಜನ್ಯದಿಂದ ಮಹಿಳೆಯರ ಸಂರಕ್ಷಣಾ ಕಾಯ್ದೆ ಕಲಂ 12ರಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯನ್ನು ಒಳಗೊಡುವ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಾಯ್ತು?
Appeal ಅಲ್ಲಿ now I have shown to the court that they have not challenged the evidence and shown to the satisfied. So it was set aside and appropriate order has been passed against which the respondent.
ಆಯ್ತು, ಈ ಆರ್ಡರ್ ಏನಾದ್ರು ಸ್ಟೇ ಆಗಿದೆ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಬೇರೆಯವ್ರು ನನ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಆಗಿಲ್ಲ ಅಂತ.
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಯಾರು ಹೇಳ್ಬೇಕು? ನಾವೇ ನೋಡ್ಬೇಕಾ? Directed as respondent notice Directed to take notice for respondent state, 1 week time granted to comply with office. State agreement, domestic violence act. Admit issue notice to the respondent. Directed to deposit 10,000 in the registry towards litigation expenses of the respondent, IA number 1 stand disposed of accordingly. Admit issue notice. Suspended till the next date of hearing antide. None appears for the petitioner. Learned counsel for the petitioner seeks time. Petitioner seeks time. Petitioner absent. ಆಯ್ತು ನಿಮಗೆ ಸಸ್ಪೆಂಡೆಡ್ ಓನ್ಲಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅವರಿಗೆ you can enforce that order ಅಷ್ಟೇ.
Last time a serious order has been passed, both parties were absent as finally for disposal ಅಂತ ಇದೆ.
ಇಬ್ರು absent ಇದ್ರಿ.
ಹೌದೌದು.
However, in the ends of justice, one more opportunity is given.
Is given. I have no objection for granting time also. Just I brought to the notice of the court.
You can proceed.
Yes, ma'am.
Based on the order passed by the appellate court, that's all. Third, petitioner counsel is repeatedly not appearing before the court. And this court having taken note of non-appearance of petitioner on 21/12/23 and also 29/2/24. An opportunity is given, and in spite of the opportunity, and petitioner counsel is not pursuing the matter diligently. Having perused the order sheet also, the order was suspended only till the next date of hearing. Void. Order dated 24/4/2017 and thereafter, the order was not extended, and hence the respondent is given liberty to proceed in accordance with law. This matter in the second week of April last. Second week ಅಂತ ಹಾಕ್ಬಿಡಿ ಸುಮ್ಮನೆ ಅವ್ರಿಗೆ ಎಷ್ಟೆಲ್ಲ ನಾವ್ಯಾಕೆ ಡೇಟ್ ಕೊಡು. ನೆಕ್ಸ್ಟ್
Petition and discuss your motion. Discuss. 138 proceedings. 138 proceedings. Accused is a landlord. And the complainant is a tenant. D2 is the lease deal. Lease was entered on 27/4/2007. Lordship, in this case, in the lease deed, it was that on the vacation, vacating the property in question, he has to remove all the mobiles. So the lease was vacated, the unregistered lease, and the lease was vacated, the lease got terminated. So we have taken the advance was 18,38,100 rupees. Advance was repaid. Then later he told that furnitures, fixtures which he has done, that has to be taken. Then we also purchased that for 7,25,000. That also was paid. Then also he did not vacate the premises. And then he said some chairs are there, like that he said. So finally we issued a check. Only to get him vacated, we issued a check for 70,000. The question of the petition is only for 70,000 euros. 70,000 check was issued, Your Honor. Then that was issued to one Saira, who is the official of the respondent company. And in that later it was found that there was some defects in the check. That UPS. Uninterrupted power supply the machines were installed. That was not in working conditions. So it was decided, and it was decided that 27,000 will be paid. Some repairs were made to the tune of rupees 23,000 and odd. 6 batteries were not in good condition. In that context, 70,000 minus 23,000. So we issued a DD for 27,000. They did not accept it. That is also reflected in the account in exhibit P side.
Is there any consent between the parties for reduction of that amount?
The person who the official of the company who consented was not produced before was not brought as witness. The specific question was asked.
My question is there any document evidencing the fact that both of them?
ಇಲ್ಲ
ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ.
Then I will take the brief facts of the case. Now may I take your answer?
Check ಎಷ್ಟು ಕೊಟ್ರಿ?
70,000. And the issue is that the check was not dishonored. We have issued an instruction for stop payment. On that date of the when the stop
payment also.
No. I admit your. But on the date of issuance of instruction of stop payment, I have sufficient funds in my bank account. There is not, that is all.
Need not necessarily, you are not having any sufficient fund.
You're not.
After the issuance of check,
Yes, sir.
even if you are having the amount in your account, if you give any staff payment, that also attracts.
No, you
Section
are,
38.
if amount is that, that will not, may I take your honor to the, that may.
Is there any correspondence between you and respondent with regard to the UPS are not in?
Yes, your honor. I
Order.
have produced the documents, your. May I request your honor to
Then
leave?
counsel, why you have issued a check for rupees 70,000 without examining the condition of
Because.
UPS and other?
Because I want, but this is, I want my property, your honor. They, after collecting the advance amount, after collecting the furniture amount, 18 lakh, and your lordship kindly appreciate, I have paid a sum of rupees 18 lakh and odd. I have paid a sum of rupees 7 lakhs and odd towards furniture. Totally 26 lakhs I have paid. Then despite of that, he was not vacating the premises. I was in badly in need of premises. And your honor, in the appeal also, they did not appear. Paper publication was issued. Here also, before this honorable court also, they did not appear. Here also, paper publication was issued. Complaint did not appear before this honorable court also, before the trial, first appellate court also, your lordship. Your honor, may I take.
Now, what is your defense counsel in the ground in the revision?
First defense is that your honor, that I was having sufficient, may I take your honor to the.
No consensus with regard to the reducing of the
Yes,
amount from 70,000 to 23,000.
That is, that we are disputing, we are not disputing on that point, your honor.
Even
May I
such
request
being
your
the
honor to
case.
say judgment, okay? In the notice, they say the amount is pertaining to chase. But in the, I have given the reply, but subsequently the complaint, they say it is for pertaining to sofas. They make a lot of very, may I take request your honor to page 19, the reasons given by the trial. From 19 also the reason starts here.
Where is your reply?
Reply notice, sir. Reply notice at D8, your lordship, the exhibit D8. Page number 29, exhibit D8, your lordship.
Only D7 is just.
D7 is the email. D8. You are, before refuting the averments made in your said notice, it is informed that your client has suppressed material facts and has given false and deceptive information to you. It is informed that your client.
That is only your defense that the same is not in order and hence constrained to incur expenditure to the tune of rupees 42,525 to bring the said materials, UPS, furniture and fixtures in working condition.
Yes, your. Only 27,000.
Then why, if the same is not in working condition, you have issued the check for rupees 70,000?
No. First check ಕೊಟ್ಟ ನಂತರ ಇದು ನಾವು
check ಕೊಡ್ಬೇಕಾದ್ರೆ ನೀವು
ಮನೆ ಖಾಲಿ ಮಾಡಿಲ್ಲಲ್ಲ ಅವರು ಮನೆ ನಮಗೆ ಬಿಕಾಸ್ 18 ಲಕ್ಷ 7 ಲಕ್ಷ 25 ಲಕ್ಷ ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅವರು ಅದ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಖಾಲಿ ಮಾಡ್ತಾ ಬೇರೆ ಬಾಡಿಗೆ ಕೊಡ್ಬೇಕು and the rent was 2 lakhs and odd at that point of time, your honor. 1,83,000 was the rent. So there is a big promises.
Only now subject is only to 80,000.
Kindly D9, your lord. D9. D9 is the statement of my bank. But is judge yet confused? This is not on the month of February. May I request that portion of the judgment I will show you. D9 only, kindly see the fourth entry digit 18,38,000 which I have paid. Adnanತರ ಕೆಳಗೆ 27,475 ಅಂತ ಕಾಣಿಸುತ್ತೆ last
27 ಅಲ್ಲ
last entry
27,475.
This is the check DD which I prepared to give him. ಅವ್ರು ತಗೊಂಡಿಲ್ಲ ಮತ್ತೆ that I was retransfer to my account, your honor. This 27,000. First two is my payment, your lordship, 18, and kindly see the balance on that day, your lordship. 24 lakhs is the balance which was on that day.
Cross examination ಏನು ಎಡಿಸಿಟ್ ಮಾಡಿಸಿದ್ರಿ?
Cross ಬಂದು
The same or not in condition ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಮಾಡಿದ್ದೀರಾ?
Yes, you are kindly see your cross-examination dated 5/11/2012. The PA holder of the complaint, Saira Banu, has resigned. I have not produced a resignation letter because I, in the mail I said that Saira Banu was in.
Counsel, with regard to the 70,000 and deduction of the amount is concerned, anything is elicited from the mouth of PW1?
PW1 is a PO holder who was not aware of the transaction. However, I complete this one. I do not have any document to accept salary slip to show that I am working as accountant. The fourth line, we do not have any letter written by the accused showing his intention to buy the goods out of our company. The total value of the goods purchased by the accused was 7 lakh. We do not have the invoice for purchasing a sofa of rupees 70,000. I am not aware of the value of the sofa purchased by the accused. In the complaint, they say that 70,000 was the value of the sofa. For that, this check was issued. So I do not have the invoice. So now I request skip this to the next page, Your Honor. Next page, it is true to suggest that the accused has purchased the goods of rupees 7,25,000, which is relating to different transaction. Now I see a letter dated 2/2/2010, in which Mubarak so and so and admit it relates to another transaction entered into the accused by the same accused, Exhibit D1. According to my knowledge, we have not given original invoice as mentioned in Exhibit D1 to the accused. We had an annual maintenance contract up to February 2000. Annual maintenance contract is pertaining to batteries, Your Honor. I have to check whether the said contract maintained so and so. It is true to suggest that after selling the materials to the accused, we did not provide invoices as promised. We did promise as promised. I am not aware of the amount of set to be asked by the accused. And next, we are not aware that the amount of rupees 45,005 is spent by the accused towards the updating of the material supplied, Your Honor. Now again, second this accused also cross-examination. Accused was that is at page number 22/2012, Your Lordship. The 2012 process. The complaint and the lady were present at that time. May I request? The complaint had orally quoted the value of furniture of rupees 10 lakh. The complainant and the lady were present at that time. The complainant forced me to purchase the above mentioned furnitures. I have not given any complaint to the police stating the complaint forced me to purchase the fixtures and furniture for rupees 7,20,000. I do not remember to say the exact date on which the complaint forced me to pay the additional sum of rupees. It is true that the suggested after discussion, I have issued a check of 70,000. The UPS and the batteries were not in a working condition. At that time, the technician, namely Thomas Money, was present. I have intimated.
Whatever now you are arguing, one sentence of admission given by your client goes against you. It is true to suggest that after discussion, I have issued the check for rupees 70,000. No.
I do not remember.
Then why you have issued the check after the discussions for 70,000?
That time,
Next counsel.
Lots, all their defenses has been considered by the trial court, my lord, which has been given reason at para number 9, my lords. And even, my lord, the contention taken by the defense, my lord, to the extent of this DD amount, my lord, it has been considered, and to that extent cross-examined to the PW1, which is denied, my lord. And there is a concurrent finding, my lords, on the said aspect, my lords. And even in respect of the payment, my lords. Can we page number 7, my lords, of the trial court, my lords, so point number, para number 9, my lords. Which the complainant, can you permit to read, my lords? Para number 9 of the trial court judgment, my lords.
Yes.
The complainant has proved that the present check issued by the accused towards goods purchased for 70,000. However, the said check dishonored for the reasons payment stopped by the drawer. As per the endorsement exhibit P6, the accused has failed to establish he has sufficient fund in his account. Therefore, even if the check dishonored for the reasons payment stopped by the drawer, has no material to show the sufficient of the fund in the account. It attacks the offence under section 138 Negotiable Instrument Act. This is the first defense, my lord. And in respect of the second defense, my lord, where the accused has pleaded that in respect of the facts, my lords, that partially payment, my lords, in the cross-examination, my lords, of the PW1, my lords. When the complainant has cross-examined the accused, my lord, to the extent of whether he has taken any action in respect of the giving the goods in unconditional, my lord, in not working condition, my lord. To that extent, the cross-examination was done to the accused, my lord, where he has denied, my lord. He has not taken any action to that extent, my lords.
May I beg you around the page number 21?
Can we read the cross-examination of the DW1, my lords, dated 2012, my lords. Cross-examination of dated 2012, minutes.
Yes, that's all. May I beg you around? Page number 21. In page number 21. The
Page number?
21.
21
Running
of?
page number 7 of the order of the trial court, your lordship. Running page 21, your lordship. That point number 2.
Yes.
The accused has failed to establish that he had sufficient funds in his account. Now, in this context, I'll request your lordship to pay the exhibit. I'll also read the entire paragraph, your lordship. Therefore, even if the check was reserved for the reason of payment stopped by the order, there is no materials to show that sufficiency of funds in his account. It attracts the offence under 138 of the NI Act. Further, a legal notice dated 1310 issued by the accused through RPID has been served as could be made out from the postal acknowledgements exhibit 6. However, the accused sent a reply note dated 25/3/10 as per exhibit D8 denying this liability to pay the check amount. However, according to him, the final settlement took for rupees out of which 42,000 so and so has been paid and therefore the only liable to pay 27,000. However, said aspect is not admitted by the complaint. Further, the statement exhibit D9 shows for the period of 1/2/10 till 28/2/10 that a sum of 24,69,800 was available in the account. Further, a statement of account for the relevant period as the date of presentation of the check is not produced before the court because the check is dated 6/2/2010. Kindly see, your Lord, this the exhibit D9 is the statement for the February period. Check is dated 6/2/2010. Check is returned on 10/2/2010.
Even counsel erroneous observation made by the trial court is not the question. Question before this court is, you have issued the stop payment. And also you have agreed in the evidence cross-examination after the discussion only 70,000 check was given. But now you contend that the same is not in order. Yourself has deducted 42,000 and payable is only 27,000. That has not been accepted. That is no consensus between you and them for reducing the amount.
But in this case, I have deposited all the money already.
First release ಆಗ್ತದೆ ಬಿಡಿ. ರಿಲೀಸ್ ಆಗ್ತದೆ ಅಷ್ಟೇ ಡೆಪಾಸಿಟ್ ಆಗಿದ್ರೆ.
ಅಲ್ಲ ಅವ್ರು ಎಲ್ಲೂ ಬರ್ತಾ ಇಲ್ಲ ಅವರು.
ಬರ್ಲೇ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್?
ಟ್ರಯಲ್ ಇಲ್ಲೂ ಬರ್ಲೇ ಇಲ್ಲ ಅವರು. ಇವ್ರಿಲ್ಲ ಇವರು
amicus curiae.
Amicus curiae ಇವ್ರಲ್ಲ.
Or the petitioner counsel and also the
even before did not appear here.
Amicus curiae who has been appointed on behalf of the respondent complainant. The factual matters of complaint of the complainant that
may I pass on this
petitioner issued a check for rupees 70,000 towards the purchase of sofa sets.
But submission in this case, when the amount is there in the account, the 138 does not at that submission.
Even amount stop payment ಕೊಟ್ರ ಆಯ್ತು ಮುಗ್ದೋಯ್ತು.
Amount ಇದೆ ನನ್ನ ಹತ್ರ.
Even if it is amount also there, ಏನಾಯ್ತು ಹೇಳಿ? Purchase the sofa sets for rupees 70,000 and taken the custody of goods. And when the check was presented, they received an endorsement stop payment and hence legal notice was given and untenable reply was given and hence complaint is filed and cognizance was taken. The complainant company examined the PW1 and documents are also produced exhibit P1 to 6 and exhibit P2A. And also one of the witness was examined as DW1, that is accused, and 313 statement also recorded. The trial court having considered both oral and documentary evidence comes to the conclusion that when the stop payment was issued and admittedly in the cross-examination stated that the check for rupees 70,000 was given after the discussion. And also taken note of the contention of the accused that the material which was
given were not in order and got it repaired. The same, and documents are also produced. And trial court comes to the conclusion that when the check was issued towards the value of the furnitures, and thereafter staff payment instruction was given and same was given with an intention to award the payment as agreed, and convicted the accused for the offence by section 138 of an act. Being agreed by the said order, an appeal is also filed in criminal appeal number 25022 of 2013. And appellate court also having considered the grounds urged in the appeal, also taken note of the issuance of check after the discussion, and also taken note of in paragraph number 26 when the DW1 was examined. And he categorically admitted that check was given after the discussion, and then the material is not in order, not given any complaint, and also no explanation is offered by the accused for not taking any legal action in respect of alleged damaged furnitures. And comes to the conclusion that accused has not placed any cogent material evidence to show that check was issued under compulsion. And though it is contended that check was issued under compulsion and the same has not been proved, and affirmed the judgment of the trial court. Being agreed by the concurrent finding, the present revision petition is filed before this court. The counsel appearing for the petitioner would vehemently contend that though issued the check for rupees 70,000 and the furnitures which have been purchased were not in order, including the UPS and all, and got it repaired the same. And also after deduction of the amount what the accused has spent, a DD was taken for an amount of rupees
27,000.
475, and the same was not accepted by the respondent. And hence, though check was issued and the petitioner is not liable to pay the amount of rupees 70,000. The counsel also would submit that the respondent is a tenant and also made the payment in lakhs, including the amount of rupees 7,25,000 earlier.
18,38,000.
And in total 18 lakh.
Total 25 lakhs.
And in total 25 lakhs was paid. In spite of the same, the present claim is made. For contra, the amicus curiae would contend that the trial court having taken note of the defense, in particularly in paragraph number 9 of the judgment discussed the same, and also noticed the fact that the DW1 who has been examined before the trial court categorically admitted that the said check was issued after the discussion. And with regard to the furnitures are not in order and got repaired the same, no complaint was given, no action was taken, and the same was taken note of, and also comes to the conclusion that even staff payment also attracts section 138. The first appellate court also given the reasoning while confirming the judgment of the trial court. And both the courts have not committed an error. Having heard the revision petition of counsel and also the counsel appearing to the respondent, and it is not in dispute that both of them are landlord and tenant. It is also not in dispute that the amounts are exchanged between the parties. It is also not in dispute that check was given to the tune of rupees 70,000 towards the furnitures. And the fact that the said check was dishonored with an endorsement staff payment is also not in dispute. The staff payment even including the amount in account also, it attracts 138 of Negotiable Instrument Act. The only defense taken in the trial court that the furnitures which the sale consideration of rupees 70,000 was given were not in order and the same were defective, and they got it repaired the same and spent the money. For spending of the said money also not with the consent of the respondent, and no material before the court for having spent the amount with the consent of the respondent for having repaired the same. And the fact that after deducting this amount, said amount, DD was taken and the same is also not accepted by the respondent is also not in dispute. It is also important to note that RW1 who has been examined before the trial court, he categorically admits that the said check for rupees 70,000 was given after the discussion. And when the check was given after the discussion and thereafter rising of the defenses that the same was not in order, cannot be accepted, and even any amount is spent for repairs also.
That the documents are produced, your lordship.
Cannot be deducted at the expense of the petitioner. And both of them have agreed. And the check was given for rupees 70,000 towards the furniture, and thereafter if any objections are raised. And when the clear admission is given that check was given for rupees 70,000 after the discussion, and thereafter also when the witness categorically admits that when their furnitures are not in order, and categorical admission is given that not taken any legal action in respect of the alleged damages to the furnitures. And the same is also discussed by the appellate court in paragraph number 26. And also the trial court in paragraph number 9 also discussed with regard to the same. And when such being the case, I do not find any error committed by the trial court and also the appellate court in considering the material on record. And the defense which have been taken, only self-defense and no document between the parties with regard to the getting repaired the same with the consent of the respondent. And hence, no grounds are made out to exercise the revisional jurisdiction, and court can exercise the revisional jurisdiction only if order suffers from any legality and its correctness. And hence, I do not find any such legality and suffering order suffers from any legality and correctness, and hence no grounds are made out to allow the revision petition. In view of the discussions made up, I pass the following order. Revision petition is dismissed. Complete. $50 ಬೆಳಗ್ಗೆ ಕೇಳಿದ್ರಲ್ಲ ಯಾರು? ಏನಾಯ್ತದು? ಯಾವ್ದ್ರಲ್ಲಿ ಬಂದಿದೆ? ಇದು ಯಾವಾಗ ಬಂದಿದೆ? ಮೊದಲನೇದು ಮೊದ್ಲೇ ಬಂದಿದೆ. ಇದು ಒಂದ್ರಲ್ಲಿ ಮಾತ್ರ ಅವಾಯ್ಡ್ ಇರುತ್ತಾನೆ 433 ನಲ್ಲಿ. ಈಗ ಏನ್ ಮಾಡಿದ್ರು ಈಗ ಇದ್ ಮಾಡಿದ್ಮೇಲೆ? ಆಯ್ತು, ಇಶ್ಯೂ ರಿಮೈಂಡರ್. ಬೇಲ್ಗೆ ಯಾವ್ದೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ, ಸೇಮ್ ಆರ್ಡರ್. Issue reminder if records are not received before 28/3, the registrar of magistrate court be present before the court. ಅರ್ಚನಾ ಮಿಕಸ್ ಕ್ಯೂರಿ ಅಂತಿದ್ದಿಲ್ಲ, ಅದು ಅರ್ಜನ್ ಆಯ್ತು ಮೇಡಮ್. 51 ಅರ್ಜನ್ ಆಗಿದೆಯಾ? ಈಗ 52 Memo filed by the petitioner counsel for not pressing IA to production of additional documents.
My lords, initially I had filed an IA, my lords, along with the Xerox copy.
Now we are not pressing the application.
That was filed along with the photocopies, my lords. The second time I filed it with the originals. The originals is placed before the court as IA number 1 of 2024.
IA number?
1 of 2024.
Now we have filed 1 of 24.
Yes, sir.
And for that also office objections are there?
Whose objections?
ಇದೆಯಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ಕಾಸ್ಲೇಶ್ ಯಾರು ನೋಡೋದಿಲ್ವಾ ಕೋರ್ಟಿಗೆ ಬರುವಾಗ?
ಚೆಕ್.
ಏನಾಗಿದೆ, ಮೋಸ್ಟ್ಲಿ ಕಾಸ್ಲಿಸ್ಟ್ ಫಿಸಿಕಲಿ ಕೊಡಲ್ವಲ್ಲ. ಕೌನ್ಸಿಲ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಬರೀ ಹೆಸರು ನೋಡ್ಕೊಬಿಡ್ತಾರೆ, ಈ ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೊಡ್ ಬಂದ್ಬಿಡ್ತಾರೆ ಇಲ್ಲಿ.
ಇಲ್ಲ, ನನ್ ತಪ್ಪಿದೆ ಸ್ವಾಮಿ, ನೋಡ್ಬೇಕಾಗಿ.
ದೇ ವೋಂಟ್ ಟೇಕ್ ಔಟ್ ದಿ ಪ್ರಿಂಟ್. ಕಾಸ್ಲಿಸ್ಟ್ ಪ್ರಿಂಟೇ ತೆಗೆದುಕೊಳ್ಳಲ್ಲ ಅನ್ಸುತ್ತೆ. ಈ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ ನೋಡಿ, ಫಸ್ಟ್ ಯು ಕಂಪ್ಲೈ.
I will comply with that.
The petitioner counsel seeks time to comply with office objections on IA 1 of 24. Respondent counsel is present, list this matter on 28/3.
Much of.
My lords, humble submission, my lords, not on 28th, my lords.
Hmm?
I would not be in station on 28th, any other date, my lords.
27th,
27th or 28th ಬಿಟ್ಟು 2 days I'm not there.
27th,
ಇಲ್ಲ 26th.
26th,
ನಾನು 2 ದಿನ ಇಲ್ಲ ಅದಕ್ಕೆ.
27,
holy
28, both the day.
Both days are not there. It's a holy week for us, that's the reason.
Next, first,
ಇಲ್ಲಿ much of
first week, 2-4.
much of
Chetan B, Girish Baladara. Here, what is the matter?
138, my lord, concurrent findings.
ನೋಡ್ರಿ ಏನಾಗಿದೆ ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ಬಂದೇ ಇಲ್ವಾ ಫಸ್ಟ್ ಟೈಮ್ petitioner counsel is absent, respondent counsel is present. List this matter on 28/3. Prasad BS. Yes, Vijay Kumar.
Check amount is 2 lakh blood. Check amount is 2 lakh blood. So loan was given blood. The complaint was given the loan blood. 2,09,000 blood.
What is your defense counsel?
Check was misused blood.
Misused.
Please. Check was misused with the complaint blood. Check was misused by the complainant.
Have you led any evidence before the trial court?
Both the
Regarding
part,
misuse?
Please.
Regarding misuse, have you led any evidence?
Contention ತಗೊಂಡಿದ್ದೀನಿ. ತಗೊಂಡಿದ್ದೀನಿ contention. The misuse.
Intention ತಗೊಂಡಿದ್ದಾರೆ, ನೀವೇನಾರು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಕೇಳಿದೆ.
ಇಲ್ಲ. ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ ನಿಮ್ಮನ್ನ ವಿಚಾರಣೆ ಮಾಡ್ಕೊಂಡ್ರಾ ಹೇಗೆ ಚೆಕ್ ನ ಮಿಸ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡ್ರು ಅಂತ
ಈ ಮಲಾಡ್ ಈ ಕಂಪ್ಲೇಂಟ್ ಮಲಾಡ್
ಹೋಗ್ಲಿ ಕೊಡ್ರಿ ರೆಕಾರ್ಡ್ಸ್ ಏನೋ ವಿಚಾರಣೆ ಮಾಡಿದಾರೇನ್ರಿ?
ಮಾಡಿದ್ದಾರೆ. DW1 and DW2 both the
DW1 and 2.
Please.
ಹಾ ಏನ್ ಆನ್ಸರ್ ಏನಾರು ಇದೆಯಾ?
ಅವ್ರು ಚೆಕ್ ನ ನಾನು ಮಿಸ್ಯೂಸ್ ನನ್ನ
ಅವ್ರು
ಶಾಪ್ ಹತ್ರ ನನ್ನ ಶಾಪ್ ಅಲ್ಲಿ ಬಂದಾಗ ಅವ್ರು ಚೆಕ್ ನ ತಗೊಂಡೋಗಿದಾರಂತ.
ನೀವ್ ಯಾಕೆ ಸೈನ್ ಮಾಡಿ ಇಟ್ಟಿದ್ರ ನಿಮ್ ಶಾಪ್ ಅಲ್ಲಿ ಚೆಕ್?
ಐ ಶಾಪ್
ಅದು ನಿಮ್ ಶಾಪ್
ಟೈಲರಿಂಗ್ ಬ್ಲಡ್
ಚೆಕ್ ನ ಸೈನ್ ಮಾಡಿ ಇಟ್ಟಿದ್ರ ಅಂತ?
ಡೂಯಿಂಗ್ ದ ಟೈಲರಿಂಗ್ ಬ್ಲಡ್ ನಾನು ಚೆಕ್ ನ ಸೈನ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೆ. ಬಟ್ ಬ್ಲಡ್ ದಿ ಫ್ಲೆಕ್ಸ್ ಆಫ್ ಮ್ಯಾಟರ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಬ್ಲಡ್ ಲೋನ್ ಅಮೌಂಟ್ ಇಸ್ 2,09,000 ಬಟ್ ಚೆಕ್ ಅಮೌಂಟ್ ಇಸ್ 2 lakh ಬ್ಲಡ್ ಇಟ್ಸ್ ಕ್ರಿಯೇಟೆಡ್ ಡೌಟ್ ಮೇಲೆ
ದುಡ್ಡು ಕೊಟ್ಟಿದ್ ಕಳೆದು ಕೊಟ್ಟಿರ್ತಾರೆ.
For a moment, blood. The check was given the 4 different date, blood. The fine amount.
He has testified regarding advancement of rupees 2,09,000 to enable the accused to have lorry and its maintenance advance the said amount and towards repayment of said amount, the accused issued check for rupees 2,09,000. Its dishonor check demand and also paid to the accused also. The complainant has produced check bearing number so and 30 alleged to be issued by the accused exhibit P1 and check stands in the name of complainant for rupees 2 lakh. Exhibit P2 is the endorsement for dishonor of check so and so so and so.
There are 4 times given the loan, blood. For a moment, kindly see the evidence, blood.
ಏನ್ರಿ 2,09,000 ಕೊಟ್ರೆ ಚೆಕ್ ಯಾಕೆ 2 ಲಕ್ಷ ರೂಪಾಯಿ ತಗೊಂಡ್ರಿ?
2,09,000 ಸುಮ್ಮನೆ.
ಹೌದು ಚೆಕ್ ಅಮೌಂಟ್ 2 lakh.
ಚೆಕ್ ಯಾಕೆ 2 ಲಕ್ಷ?
ಚೆಕ್ ವಾಸ್ ಗಿವನ್ ಫಾರ್ 2 lakhs. ಅನದರ್ 9,000 ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು 2 lakhs ಅನ್ನ ಅವ್ರ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ವಿ ಚೆಕ್ ಅನ್ನ.
ಆ ರೀತಿ ಬ್ಯಾಲೆನ್ಸ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು
ಅವ್ರು ಹೇಳಿದ್ರು. ಅದಕ್ಕೆ ಮತ್ತೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಒಡೆದು ನಮಗೆ ಗಲಾಟೆ ಮಾಡಿ ದೇರ್ ವಾಸ್ ಎ ಕಂಪ್ಲೇಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಜಿಸ್ಟರ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್.
ಕ್ರಿಮಿನಲ್ ಕೇಸು ಆಯ್ತಾ?
ಆಯ್ತು. ಬೋತ್ ಅಗೇನ್ಸ್ಟ್ DW1 DW2 ಇಬ್ಬರ ಮೇಲೂ.
ಓ DW2 and DW.
ಹೌದು.
ಬೋತ್ ಏನಾಯ್ತಾ ಕೇಸು? ವಾಟ್ ಹ್ಯಾಪನ್ ದಟ್ ಕೇಸ್?
ಆ ಕೇಸು
ಕಂಪ್ಲೇಂಟ್ ಆದ ಕೇಸ್ ಏನಾಯ್ತ್ರಿ?
ಕಂಪ್ಲೇಂಟ್ ಇಟ್ ಈಸ್ ಗೋಯಿಂಗ್ ಆನ್.
ಇನ್ನು ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್.
ಹೌದು.
ಸ್ಟೇಟಸ್ ಗೊತ್ತಿಲ್ಲ. ಬಟ್ ಫಾರ್ ಅ ಮೂಮೆಂಟ್ ಬ್ಲಡ್
in respect of exhibit P1.
Loan was given the 4 times, blood. Kindly see, blood. Different date, blood. 15,011 to 2012. 55,003 13 to 2012. 45,014 to 2012.
ಏನದು?
ಅಲ್ಲ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದು ಕ್ಯಾಶ್ ನನಗೆ ಕೊಟ್ರಿ ಅಂತ ಹೇಳಿ.
ಯಾರು ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ?
ಅಲ್ಲ ಅವ್ರು ನನಗೆ ಕಂಪ್ಲೇಂಟ್ ನನಗೆ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿ. ಕಂಪ್ಲೇಂಟ್ ನನಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದು.
ಕಂಪ್ಲೇಂಟ್
ಲೋನ್ ನನಗೆ ಕೊಟ್ಟಿದ್ದು.
ಲೋನ್ ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ಡಿಫರೆಂಟ್ ಡೇಟ್ಸ್ ಅಲ್ಲಿ ಅಂತನಾ?
ಡಿಫರೆಂಟ್ ಡೇಟ್ಸ್ ಅಲ್ಲಿ.
ಹೌದು.
ಅಲ್ಲ ಡೇಟ್ ನೋಡಿ ಸ್ವಾಮಿ ಯಾವ
ಇದೆಯಲ್ಲ 11 to 2013.
ಸೊ ಲಾಂಗ್ ಡೇಟ್ ಇಸ್ ದೇರ್ ಮಿಲಾಡ್. ಇಸ್ ನಾ ಅವ್ನು ಮೊದಲು 55,000 ಕೊಟ್ಟಿಲ್ಲ ವಾಪಸ್ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಹೌ ಕ್ಯಾನ್ ಈ ಬಿಲ್ ಇನ್ ದಟ್ ಮಿಲಾಡ್ ಅಗೇನ್ ಇದೆ ಗಿವ್ ಮನಿ.
ಡಿಫರೆಂಟ್ ಡೇಟ್ಸ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಿ.
ಒಂದು ಮಿಲಾಡ್ ಅಲ್ಲ ಜಸ್ಟ್ he is pledged the she is pledged the gold and given the loan amount. It's not a believable words ಮಿಲಾಡ್. ಅಲ್ಲ ಅವ್ರು ಗೋಲ್ಡ್ ನ ಪ್ಲಡ್ಜ್ ಮಾಡಿ ನನಗೆ ಸಾಲ ಕೊಟ್ರು.
The husband also no more. Complaint husband also no more. My lord. She was residing the parents' house.
I have produced the documents to show that I have withdrawn the amount, the same amount has been withdrawn from my bank and I have paid the amount to the accused.
ಈ ಅಮೌಂಟ್ ನೆಲ್ಲ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ನೀವು ಡ್ರಾ ಮಾಡಿಕೊಟ್ಟಿದ್ದೀರಾ?
ಡ್ರಾ ಮಾಡಿ ಬಂದು ಕೊಟ್ಟಿದ್ದ ಅವ್ರಿಗೆ ಲಾರಿ ಮೇಂಟೆನೆನ್ಸ್ ಇದಕ್ಕೆ ಕೊಟ್ಟಿರೋವಂಥದ್ದು.
ಅದಕ್ಕೆ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ. ಎಕ್ಸಿಬಿಟ್ P7, P8 ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಮತ್ತೆ
ತೊಂದರೆಗಳೆಲ್ಲ ಆರೋಪಿತನಿಂದ ಸಾಕಷ್ಟು ಸಲ ಹಣ ಪಡೆದಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು.
ಅವ್ರು ನನಗ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ
ಯಾವುದೇ ಮೂಲ ಆದಾಯ ಇಲ್ಲ ಎಂದರೆ ಸರಿ.
ಅಲ್ಲ ಅವರೇ ಒಪ್ಕೊಂತಾರೆ ನನಗೇನು ಇನ್ಕಮ್ ಇಲ್ಲ, ಸೋರ್ಸ್ ಇಲ್ಲ ಅಂತ. ಶಿ ಇಸ್ ರಿಸೈಡಿಂಗ್ ದಿ ಪೇರೆಂಟ್ಸ್ ಹೌಸ್.
ನನಗೆ ನನ್ನ ಸ್ವಂತ ಮನೆಯನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಮನೆ ಅಥವಾ ಜಮೀನು ಮತ್ತು ಯಾವುದೇ ಮೂಲ ಆದಾಯ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ಯಾವುದೇ ಕೆಲಸ ಮಾಡುವುದಿಲ್ಲ. ಆರೋಪಿತನಿಗೆ ಸಂಬಂಧಿಕ ಆಗುವುದಿಲ್ಲ. ಆರೋಪಿತನಿಗೆ ಮದುವೆಯಾಗಿದ್ದು ಅವನ ಊರಿನಲ್ಲಿ ವಧುಪೂರವಾಗಿದ್ದಾನೆ ಎಂದರೆ ಸರಿ. ನನಗೆ ಕಳೆದ 7 ವರ್ಷಗಳಿಂದ ಯಾವುದೇ ಆದಾಯ ಇರುವುದಿಲ್ಲ ಮತ್ತು ನನ್ನ ಮಗಳೊಟ್ಟಿಗೆ ಜೀವನ ಸಾಕಷ್ಟು ಕಷ್ಟವಾಗಿದೆ ಎಂದರೆ ಸರಿ. ನನಗೆ ತೊಂದರೆ ಆದಾಗಲೆಲ್ಲ ಆರೋಪಿತನಿಂದ ಸಾಕಷ್ಟು ಆರೋಪಣೆ ಸುಳ್ಳು. ನನಗೆ ತೊಂದರೆ ಆಗಲೆಲ್ಲ ನನ್ನ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಬ್ಯಾಂಕಿನಲ್ಲಿ ಅಡವಿಟ್ಟು ಸಾಲ ಪಡೆಯುತ್ತಿದ್ದೇನೆಂದರೆ ಸುಳ್ಳು. ಆರೋಪಿತನು ನನಗೆ ಹಣದ ಸಹಾಯ ಕೇಳಿದ್ದರಿಂದ ನಾನು ನನ್ನ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಅಡವಿಟ್ಟು ಸಾಲ ಪಡೆದಿದ್ದೆ. ದಿನಾಂಕ 11/2/2001 ಆರೋಪಿತನಿಗೆ 50,000 ಹಣ ನೀಡಿರುತ್ತೇನೆ. 13/2 ಕೊಟ್ಟಿರುತ್ತೇನೆ, ನೀಡುತ್ತೇನೆ. ನಾನು ಈಗ ಹೇಳಿದ ಎಲ್ಲ ಮೊತ್ತವನ್ನು ಬ್ಯಾಂಕಿನಿಂದ ಅದೇ ದಿನಗಳನ್ನು ಹಣವನ್ನು ಪಡೆದಿರುವ ಕಾರಣ ಆರೋಪಿತನಿಗೆ ಅದೇ ದಿನಕ್ಕೆ ಹಣ ತಡೆಯುತ್ತೇನೆ, ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದೇನೆ, ಸರಿಯಲ್ಲ. ನಾನು ಈ ಮೇಲೆ ಹೇಳಿದ 3 ದಿನದ ಅಂತರದಲ್ಲಿ ಆರೋಪಿತನಿಗೆ 1,50,000 ರೂಗಳನ್ನು ಕೊಟ್ಟಿದ್ದೆ ಅಂತ ಹಣವನ್ನು ಒಂದೇ ದಿವಸ ಏಕೆ ಕೊಡಲಿಲ್ಲ ಎಂದರೆ ನನಗೆ ಬ್ಯಾಂಕಿನ ವ್ಯವಹಾರ ಮಾಹಿತಿ ಇರದೇ ಇದ್ದ ಕಾರಣ ನೀಡಿರುವುದಿಲ್ಲ. ನಾನು ಶಿವರಾಮ್ ಚಿಟ್ಸ್ ಫೈನಾನ್ಸ್ ನಲ್ಲಿ ನನಗೆ ಚೀಟಿ ಹಾಕಿದ ಕಾರಣ ಹಣ ಬಂದಿದ್ದು, ಆ ಹಣವನ್ನು ಆರೋಪಿತನಿಗೆ ನೀಡಿರುತ್ತೇನೆ. ಸದರಿ ಹಣವನ್ನು ನನಗೆ ಆರೋಪಿತನಿಗೆ ನೀಡುವುದಕ್ಕೂ 1 ವಾರದ ಅವಧಿಯಲ್ಲಿ ಶ್ರೀರಾಮ್ ಚಿಟ್ ನಿಂದ ಬಂದಿರುತ್ತದೆ. ನನಗೆ ಶ್ರೀರಾಮ್ ಚಿಟ್ಸ್ ಫೈನಾನ್ಸ್ ನಿಂದ ಒಟ್ಟು ರು 1,66,000 ಬಂದಿರುತ್ತದೆ. ಶ್ರೀರಾಮ್ ಚಿಟ್ ಫೈನಾನ್ಸ್ ಸದರಿ ಹಣ ನನಗೆ ಚೆಕ್ ಮೂಲಕ ನೀಡಿದರು ಅಥವಾ ಹಣ ನೀಡಿದರು ಅಂದರೆ ಸಾಕ್ಷಿ ಶ್ರೀರಾಮ್ ಚಿಟ್ ಫೈನಾನ್ಸ್ ನಾನು ಸಿಂಡಿಕೇಟ್ ಬ್ಯಾಂಕ್ ನಿಂದ ಹೊಂದಿದ್ದ ಖಾತೆಗೆ ಜಮಾ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನನಗೆ ಆರೋಪಿತರು 22 ಜನವರಿ ತಿಂಗಳಲ್ಲಿ 1,50,000 ಹಣ ನೀಡಲು ಕೇಳಿಕೊಂಡಿದ್ದರು. ನನಗೆ ಶ್ರೀರಾಮ್ ಚಿಟ್ಸ್ ಫೈನಾನ್ಸ್ ನಲ್ಲಿ ಹಣ ಬಂದ ವಿಷಯ ಆರೋಪಿತನಿಗೆ ಹೇಗೆ ಗೊತ್ತಾಯ್ತು ಅಂದರೆ ಸಾಕ್ಷಿ ಶ್ರೀರಾಮ್ ಚಿಟ್ ಫೈನಾನ್ಸ್ ನಲ್ಲಿ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಆರೋಪಿತನೇ ಚೀಟಿ ಹಾಕಿಸಿದನು, ಕಾರಣ ಅವನಿಗೆ ಗೊತ್ತಿರುತ್ತದೆ. ನನಗೆ ಹಣ ಸಂದಾಯದ ಬಗ್ಗೆ ಶ್ರೀರಾಮ್ ಚಿಟ್ಸ್ನವರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಚೆಕ್ಕಿಗೆ ನಾನು ಸಹಿ ಮಾಡಿದ್ದೇನೆ ಇಲ್ಲೋ ಎಂದರೆ ಸಾಕ್ಷಿ ಸಹಿ ಮಾಡಿರುವ ಕುರಿತು ನೆನಪಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ದಿನಾಂಕ 11/2/2001 ನಾನೇ ಬ್ಯಾಂಕಿಗೆ ತೆರಳಿ ಚೆಕ್ ಮೂಲಕ ಹಣ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಸದರಿ 3 ದಿನಗಳಲ್ಲಿ ನಾನು ಬ್ಯಾಂಕಿನಿಂದ ಹಣವನ್ನು ಆರೋಪಿತನಿಗೆ ನೀಡುತ್ತೇನೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಆರೋಪಿತನ ಹೊಲಿಗೆ ಅಂಗಡಿಯಲ್ಲಿ ಆರೋಪಿತನು ಅಂಗಡಿಯಲ್ಲಿ ಡ್ರಾದಲ್ಲಿ ಇಟ್ಟಂತ ಸಹಿ ಮಾತ್ರ ಮಾಡಿದ ಖಾಲಿ ಚೆಕ್ ಅನ್ನು ಪಡೆದುಕೊಂಡು ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡಿದ್ದು ವಿಷಯ ಈಗ ಗೊತ್ತಾಗಿದ್ದು ಅದನ್ನು ಆರೋಪಿತನಿಗೆ ಮರಳಿ ನೀಡಬೇಕೆಂದು ಆರೋಪಿತ ಪ್ರತ್ಯುತ್ತರ ತಿಳಿಸುತ್ತಾನೆ ಎಂದರೆ ಸರಿ. ಚೆಕ್ ಕಳವಾಯ್ತು ಅಂದಾಗ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರಿ?
ಹೌದು ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ ಕೊಟ್ರಿ?
ಬ್ಯಾಂಕಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೀನಿ ಬಿಫೋರ್ 1 day.
ಬಿಫೋರ್ 1 day ಅಂದ್ರೆ
ಇದು ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿಂತ 1 ದಿವಸ
ಪ್ರೆಸೆಂಟ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ.
ಪ್ಲೀಸ್
ಎಂಡರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು ಏನು?
ಎಂಡರ್ಸ್ಮೆಂಟ್ ಮಾರ್ಕ್
ಏನೋ ಕಂಪ್ಲೇಂಟ್ ಆದಾಗ ನೀವು ಹೋಗಿ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಮುಚ್ಚಳಿಕೆಲ್ಲ ಬರ್ಕೊಟ್ ಬಂದಿದ್ದೀರಲ್ರಿ?
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಂತ ಇದೆ.
DW2 is the wife of DW1.
ಹೌದು ಪ್ಲೀಸ್ DW1 ವೈ.
When I demanded for the refund of money,
ನನ್ನ ಟೈಲರ್ ಅಂಗಡಿ ಕಾರ್ತಿಕ್ ಮೆನ್ಸ್ವೇರ್ ಅಂತ ಹೆಸರು ಇದೆ ಸರಿ. ನಾನು ಅಲ್ಲಿ ಇತರ ಬಟ್ಟೆ ಹೊಲಿಗೆ ಮಾಡುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. ನನ್ನ ಚೆಕ್ಗಳು ಕಳವಾದ ಬಗ್ಗೆ ನಾನು ಪೊಲೀಸರಿಗೆ ದೂರು ಕೊಟ್ಟಿಲ್ಲ. ನಾನು ಯಾವಾಗ ಚೆಕ್ನ ಮೊತ್ತದ ಪಾವತಿ ಬಗ್ಗೆ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದೆ ನನಗೆ ದಿನಾಂಕ ನೆನಪು ಇಲ್ಲ. ಹಾ,
2024 ಪ್ರಕರಣದಲ್ಲಿ ವಾಪಸ್ ಪಡೆದುಕೊಳ್ಳಬೇಕು.
ಫಿರ್ಯಾದಿದಾರರಾದ ಸೌಮ್ಯ ಅವರ ತಂದೆ ತಾಯಿಗೆ ಒಬ್ಬಳೇ ಮಗಳು ಎಂದರೆ ಸರಿ. ಅವರಿಗೆ ನೀರಾವರಿ ಜಮೀನು ಇದೆ ಎಂದರೆ ಸರಿ. ಮನೆಯಲ್ಲಿ ವಾಸ ಇದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ನಾನು ಫಿರ್ಯಾದರಿಗೆ ಹಣ ಕೊಟ್ಟ ಬಗ್ಗೆ ದಾಖಲೆ ಇಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿದಾರ ವಿರುದ್ಧ ದೂರು ಕೊಟ್ಟ ಬಗ್ಗೆ ದಾಖಲೆ ಇದೆ. ಈ ಪ್ರಕರಣವನ್ನು ವಾಪಸ್ ಪಡೆದುಕೊಳ್ಳಬೇಕು. ನಾನು ಫಿರ್ಯಾದಿದಾರ ಬಳಿ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡಿದ್ದಕ್ಕೆ ಕೋಟೆ ಪ್ರಕರಣದಲ್ಲಿ ಸಾಕ್ಷ್ಯ ಕೇಸನ್ನು ವಾಪಸ್ಸುಗೊಳಿಸಲು ಫಿರ್ಯಾದಿದಾರರು ಹೇಳಿದ್ದು ನಾನು ಹೇಳಿದಾಗ ನನಗೆ ಹೊಡೆದರು. ಆಗ ನನ್ನ ಪತ್ನಿ ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಹೊಡೆದ ಕಾರಣ ಪ್ರಕರಣ ದಾಖಲಾಗಿದೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಹಾ, ಈ ಬಗ್ಗೆ ದಾಖಲಾದ ಪ್ರಕರಣ ಸಾಕ್ಷಿಯನ್ನು ತೋರಿಸಿದಾಗ ಅವರು ಒಪ್ಪಿದ್ದು ಅದು ನಿಶಾನತೆಯನ್ನು ನಡೆಸಲಾಯಿತು. ನಥಿಂಗ್
ವೆರಿ ಕಂಟೆನ್ಷನ್ ಬ್ಲಡ್ ಬಟ್
ಚೆಕ್ ಕಳುವಾಯ್ದಕ್ಕೂ ಇಲ್ಲ, ಗಲಾಟೆ ಮಾಡಿದ್ಕು ಕೇಸ್ ಆಗಿದೆ ಅನ್ನೋದಕ್ಕೂ ಒಪ್ಕೊಳ್ತೀರಿ. ಆಮೇಲೆ ಹೋಗಿ ಮುಚ್ಚಳಿಗೆ ಬರ್ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಲೇ ಹೇಳ್ತೀರಿ.
ಹೌದು.
ನಿಮ್ ವೈಫ್ ಬಿಡ್ಕೊ ಹೊಡೆದ್ಲು ಅಂತ ಅದನ್ನು ಒಪ್ಕೋತೀರಿ. ಆಗ ನನ್ನ ಪತ್ನಿ ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಹೊಡೆದ ಕಾರಣ ಪ್ರಕರಣ ದಾಖಲಾಗಿದೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಮತ್ತೆ
is admitted malad.
ಹಾ,
Even though malad is the check amount is concerned malad it is 2 lakh but different date malad.
ನೀವೇನ್ ಹಾಕಿದಿರಿ? ನೀವು ಅಮೌಂಟ್ ಡ್ರಾ ಮಾಡಿದ್ಕೆಲ್ಲ
bank account extract
ಹಾಕಿದಿರ?
ಹಾಕಿದ್ವಿ.
P6 and P7.
P6
P7 malad.
Corresponding dates ಅಲ್ಲೇ
ಆ ಟೈಮಲ್ಲೇನಾ?
ಹೌದು, ಆ ಡೇಟ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಬೇಕು ಅಂದಾಗ ನಾನು ಚಿಟ್ಟು ಅಲ್ಲಿ ಅಮೌಂಟ್ ನಾನು ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಆ ಅಮೌಂಟ್ ಬಂದಿತ್ತು, ಅದನ್ನ ನನ್ನ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಇತ್ತು, ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತಿತ್ತು.
ನೋಡಿ,
ಚಿಟ್ ಅಮೌಂಟ್ ಸಹಿತ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಒಂದೇ ಸರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಡಿಫ್ರೆಂಟ್ ಡೇಟ್ malad. The date also malad.
ದುಡ್ಡು ಕೊಟ್ಟಾರ ಅವತ್ತಿಂದ ಡೇಟ್ ಹಾಕೋರು.
ಆ ಡೇಟ್ ನೋಡಿ ಡೇಟ್ ನ ಒಂದೊಂದು 6 ತಿಂಗಳ ಗ್ಯಾಪ್ ಕೇಳಿ. ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದು 5-11
counsel and also the counsel appearing for the respondent. This revision petition is filed against the concurrent finding of the trial court in respect of the offence punishment on section 138 of Negligent Punishment Act. It is the case of the petition complainant, public respondent before the trial court that the complainant and accused are known to each other since several years, and accused is neighbor of parental house. Out of the said acquaintance, in the month of January 2012, the accused requested the complainant to give loan and also availed the loan amount on different dates, in total 5 times. And accused failed to repay the said amount and ultimately given the check for rupees 2 lakh when the complainant insisted to repay the amount, and when the same was presented dishonored with endorsement funds insufficient and payment stopped by trial. Legal notice was issued and reply kotra and untenable reply was given. Not and the accused not repaid the money and hence cognizance was taken based on the complaint. The accused oblique petitioner appeared before the trial court and denied the charges. And hence the complainant has been examined as PW1 and also got marked document exhibit P1 to 9. On the other hand, both husband and wife have been examined as DW1 and 2 and got marked document exhibit D1 to 4. The trial court having considered the both oral and documentary evidence, and when the check was admitted and defense was taken that the complainant has visited the shop of the accused, and by that time the same was stolen and no financial transaction was taken place between them.
in spite of both DOW 1 and 2 are examined before the trial court. The trial court comes to the conclusion that when the check was stolen, no complaint was given and also not taken any steps. And apart from that, the complainant has produced the bank statement for having withdrawn the amount and so particular dates as contained in the legal notice, and hence convicted the petitioner. Being agreed by the said judgment and judgment of conviction and sentence, criminal appeal 122 of 2015 was also filed. And first appellate court also having considered the document, particularly exhibit P7 and the account extract of a syndicate bank as per exhibit P8. And it is also the contention of the complainant that he had received the amount from the chit and the amount was in the account and the same was drawn and paid to the petitioner. And appellate court also having considered material material evidence, that is both oral and documentary evidence, discussed the same and also relied upon the document exhibit D2, an intimation given by the accused to the manager, Canara Bank on 2/8/2013, wherein it has been mentioned that as the checkbook containing check leaves 625351 to 635353, it indicates that check number 625351 to 625360 has been noted down and scored off and contended that checkbook has been missing and requested to lock the check book and mentioned the account number. In order to support his case, the accused has examined his wife DW2. And DW2 is working as a teacher at Anganwadi and she is claiming that she is also doing tailoring work in the accused shop. And she heard the close relationship, having a close relationship of accused. And they heard the close relationship of accused and the complainant by third parties. And the same also discussed in paragraph number 16 and also paragraph number 17. And in paragraph number 16 held that therefore trial court has rightly comes to the conclusion that theory set up by the accused is an afterthought just to escape from the legal liability in which accused has not succeeded. And confirmed the judgment of the trial court. Being agreed by the said order of conviction and confirmation, the present revision petition is filed. And counsel appearing for the petitioner would contend that the complainant paid money to the petitioner by pledging gold in Manapuram gold. But during the course of cross-examination, she has deposed that she had money since she had taken chit amount from Sriram Chits. And the same is inconsistent. And also the contention that money was drawn on different dates and taking off the advantage of drawing off the said money on different dates. The complainant has set up the said ground. And both the courts committed an error. Per contra, the counsel appearing for the respondent would contend that issuance of check is not in dispute. And only contention that the check was stolen. And in order to substantiate the same, categorically admitted in the cross-examination that when the check was stolen, not given any complaint. And all this aspect has been considered by the trial court and also the appellate court. And not committed any error, and question of entertaining the revision petition doesn't arise. Material available on record, it is very clear that that there was a transaction and check was issued on insistence of demand to repay the amount. And though a different story is set up in the evidence and nothing is elicited during the course of cross-examination, and the same has been considered by both the courts and all, and hence there are no grounds. Having heard the petition of counsel and also the counsel appearing for the respondent, and also having considered the contents of the complaint and also the evidence of PW1, he contends that both of them are neighbors and having acquaintance with each other. And during the month of January 2012, requested to lend the money. And step by step loan amount was given. And though amount was given 2,09,000 on insistence, check was issued for rupees 2 lakh. The same was dishonored. No doubt in the cross-examination of PW1, an answer is elicited that complainant is not having any work and also not having any other source. But in the cross-examination admits that when the accused demanded money, she has pledged the money with the bank and obtained the same. And on 11/2/2002, gave the money of rupees 50,000 and different dates, the amounts are given. And in further continuation of cross-examination, complainant says that he has received the amount from Sriram Chips. And the amounts are drawn on different dates and the same was given. And the accused was having the knowledge about the amount in his account. When the suggestion was made that he had obtained, and when the suggestion was made that when the blank check, when the empty check which was signed was kept in the shop, and the same was stolen and misused, and the said suggestion was denied, but admits that in the reply, the same defense was set up. The PW1 also admits that the accused has given instructions to the bank. On the other hand, both accused and his wife were examined as DW1. And DW1, who is the wife, speaks about the complainant was coming to the shop of her husband and having intimacy with each other, and people were talking about the same. In the cross-examination, DW2 admits that her husband tailoring shop is only a menswear, that is Karthik menswear. And she cannot tell the amount given to her husband, amount given by her husband to the complainant. On the other hand, it is admitted that when the complaint was given by complainant with regard to insisting of withdraw the complaint.
Withdraw the complaint.
And the threat was made that going to kidnap the daughter. And in that connection, complaint was given, and in that complaint, they went to police station and they have given the undertaking. On the other hand, the accused also examined as DW1. And in his evidence, he says that he gave the money to the tune of 20 to 30,000 to the complainant, and he used to give money often and often. And the said fact came to the knowledge of his wife, and wife made the galata. And his wife also assaulted the complainant, and case was also registered. In the cross-examination, he categorically admits that he is running the Karthik menswear tailoring shop. And also he categorically admits that he only stitches the men's cloth. And he has not given any complaint when the checks were lost. And also cannot tell on what date he gave the intimation to the bank. He also admits with regard to the financial condition of the complainant, stating that she is the only daughter and having irrigated land, and they are staying in their own residential house. And also he has given the complaint against the complainant. And he also admits with regard to the insisting of the complainant to withdraw the case. And galata was taken. And also assaulting the complainant by his wife. And document is also confronted and marked as Exhibit P9. Having taken note of both oral and documentary evidence, I have already pointed out that no dispute with regard to the issuance of check Exhibit P1 for an amount of rupees 2 lakh. And also not in dispute that the check was returned and notice was also given in terms of Exhibit P3. And the same was also served and reply was given. And in order to substantiate his contention, that the Exhibit P6 pertaining to Manappuram Finance Limited. ಇದೇನು ಲೋನ್ ತಗೊಂಡಿದ್ಕಾ ಇದೇನು ಎಕ್ಸಿಬಿಟ್ P6
ಪ್ಲಚ್ ಮಾಡಿದ್ರು ಗೋಲ್ಡ್ ಪ್ಲಚ್ ಮಾಡಿ ನಂಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಂತ ಗೋಲ್ಡ್ ಅನ್ನು ಪ್ಲಚ್ ಮಾಡಿ ನಂಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿದಾರಂತ
for having pledged the gold. And Exhibit P7 is also another document. And so also the bank statement of Syndicate Bank, which is marked as Exhibit P8, which discloses on different dates withdrawing the amount of rupees 50,000, 55,000, 45,000. These documents discloses for having pledged the gold as well as drawn the money from the Syndicate Bank. It is also the specific case of PW1 in the cross examination that he had received the amount from Sriram Chits, and the said amount was in the account, and the same was drawn and given to the accused. It is also not in dispute that complainant and accused are known to each other. And no doubt the document is also produced before the court with regard to both of them. A galata was taken place and undertaking was also given as admitted. And also though content that checks were stolen, and DW1 categorically admits that he has not given any complaint. And when the checks are stolen, which is a normal conduct of the person who lost the check, will give the complaint. And no doubt an answer is elicited with regard to the giving of intimation to the bank. And though content that the accused himself used to advance the amount in favor of the complainant and nothing is placed on record before the court. The trial court as well as the first appellate court considered both oral and documentary evidence available on record. And when both of them are having acquaintance with each other, and when the accused not dispute the issuance of check in terms of exhibit P1. And case of the complainant is probable since the complainant says that avoid the loan from the Manappuram Finance and also they drawn the money from syndicate bank. And the same is supported by documentary evidence. And hence I do not find any error committed by the trial court by appreciating the same in their judgment and in the judgment. And first appellate court also reassess the material available on record. Though counsel contend in this argument that both the courts have committed an error in not appreciating the material available on record. And the said defense which has been set up has not been substantiated by giving any evidence. The contention that two contra evidence was given for pledging the gold in Manappuram gold and also drawing the bank from syndicate bank and the same is contrary cannot be accepted and the same is supported by the documentary evidence of exhibit P6, 7 and also exhibit P8. And also drawing of money on different dates and also the transaction also on different dates has been narrated in the notice itself. And when such being the case, and trial court and the first appellate court also rightly drawn the presumption under section 139 of NI Act, and the same has not been rebutted by producing any cogent evidence. And when the evidence of PW1 has not been rebutted by leading any cogent evidence, this court cannot find any error and also any miscarriage of justice, and hence no grounds are made out to reverse the finding of the trial court and also the appellate court. In view of the discussions made up, I pass the following order. Revision petition is dismissed.
Amount in deposit maybe.
Amount in deposit ಎಲ್ಲಿದೆ? ಇಲ್ಲಿದೆಯಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
60,000 ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರು ವೆದರ್ ದೇ ಹ್ಯಾವ್ ಡೆಪಾಸಿಟೆಡ್ ಹಿಯರ್ ಆರ್
ಡೆಪಾಸಿಟ್ ಮಾಡ್ರೆ ನೀವು ಅಲ್ಲಿ ವೆರಿಫೈ ಮಾಡಿ ತಗೊಳ್ಳಿ
ಪ್ಲೀಸ್. ಐ ಲೀವ್
ರಿವಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದ್ರಿಂದ. ನಾಲ್ಕು 50 ಯಾವಾಗ್ರಿ ಯಾವಾಗ
ಸೆಟ್ಲ್ ಮಾಡಕ್ ರೆಡಿ ಇದಾರೆ ಪಾರ್ಟಿ ಚೆಕ್ ಅಮೌಂಟ್ ಕೊಡ್ತಾರೆ ಸರ್. ಚೆಕ್ ಅಮೌಂಟ್ ಇಸ್ 2,08,000, ಫೈನ್ ಅಮೌಂಟ್ ಇಸ್ 3,80,000.
ಏನೋ ಚೆಕ್ ಅಮೌಂಟ್ ಕೊಡ್ತಾರಂತಲ್ಲ ಮಾತನಾಡಿ.
Last time 3,10,000 ಏನೋ ಆಫರ್ ಮಾಡಿದ್ರು.
ಅವ್ರು ಆಫರ್ ಮಾಡಿದ್ರೆ ಚೆಕ್ ಅಮೌಂಟ್ ನಮ್ಮ ಪಾರ್ಟಿ ಚೆಕ್ ಅಮೌಂಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
ಚೆಕ್ ಅಮೌಂಟ್ ಎಷ್ಟ್ರಿ?
2,80,000.
2,80,000. 280. ಫೈನ್ ಹಾಕಿರೋದು ಎಷ್ಟು?
380 ಮೇಲೆ.
380. 1 ಲಕ್ಷ ಜಾಸ್ತಿನಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ 310 ಕೊಡ್ತೀವಿ ಅಂದಿರ. 310 ಕೊಡ್ತೀವಿ ಅಂದಿರ ಅಂತ.
ಇಲ್ಲ 310 ಹೇಳಿ 280 ಹೇಳಿದ್ರು ಸ್ವಾಮಿ, ಅವ್ರು ಜಾಸ್ತಿ ಹೇಳಿದ್ರು.
ಸ್ವಲ್ಪ
280 ನಾನು 50 days
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಿದ್ರೆ
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕಾ? ಮಾತನಾಡಿ ನೋಡಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ತಗೊಳ್ಳಿ. Petitioner counsel submits that the petitioner is ready to pay the check amount and hence the respondent also seeks time to put the same on the respondent and list this matter to report the settlement, and if settlement is not arrived, argue the matter positively on 28/3.
1,90,000 ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಿ.
ಬ್ಯಾಲೆನ್ಸ್ ಎಷ್ಟಿದೆ ನೋಡಿ ಮಾತನಾಡಿ ಇಬ್ಬರುವೆ ನೋಡಿ. ನೆಕ್ಸ್ಟ್ 58 RS ಏನಕ್ಕಿದೆ ಇದು?
ಫೈನಲ್ ಇಯರಿಂಗ್. ಫೈನಲ್ ಇಯರಿಂಗ್.
ಫೈನಲ್ ಇಯರಿಂಗ್ ಇವತ್ತು ಹಾಕೊಂಡ್ವಿ ನಾವು.
In the last week, the matter has been listed on last occasion and date was given, please, madam. So,
for want of time, list this RSA this laki, madam. 2nd of April. 2/4. Idu ashtena? For want of time, list this matter on 2/4, please. Ashtena?